Good morning.
Good morning.
Okay, good morning, everyone.
Morning.
How's everyone this morning? Okay, well, it's good to see you all. Glad everyone made it. All right, are there any preliminary matters before we get started? Morning, Mr. Peterson.
Morning, Judge Corbin Johnson. How are you?
Wonderful.
Plaintiff has two brief matters before we call our next witness. First, we move to admit into evidence. I believe the next document is Exhibit 33.
33,
Is,
okay.
is that right?
Correct.
And that's the 1929 statute, which was discussed during Dr. Holloway's testimony yesterday.
Okay.
We shared this with defense counsel, and they have no objection.
All right, we'll mark that 33 then.
Sorry, 1829 statute.
Thank you. Okay, counsel, what else?
Second, we wanted to respond to Judge Cook's question about the interplay between Section 69 and 71 of the 1829 statute. As your honors will recall, this came up because defense counsel tried to show that the Tennessee General Assembly first adopted criminal disenfranchisement in 1829. Dr. Holloway had testified that this first happened in 1858. The actual 1829 statute shows they were incorrect. Section 71 just says that people convicted of infamous crimes can't testify in court. It doesn't say anything about losing voting rights or voting at all. Section 69 just says that this entire 1829 Act, all of the sections of it, don't apply to slaves, and that slaves remain subject to prior criminal laws. That's consistent with Section 71, and our main point remains: the 1829 statute did not adopt criminal disenfranchisement, as the other side had argued yesterday. That didn't happen until 1858, which, as Dr. Holloway testified.
Okay.
Any questions, Your Honor?
No questions. Thank you. Judge, any questions?
No.
No? Okay. All right. Good morning.
Good
Ms.
morning.
Theodore, how are you?
I'm doing good.
Wonderful.
Julie Ratcher for the plaintiff.
I'm sorry, Rashida, I'm sorry. I thought you kind of looked a little bit like, okay, you guys changed chairs, so, okay. All right, I see her back there. All right, yes, Miss Rashida.
We're ready to call our next witness, Dr. Frank Baumgartner.
I'm sorry, Dr.
Frank Baumgartner.
Okay, Dr. Frank Baumgartner, please come forward. Okay. Good morning, sir.
Good morning.
Please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? All right, thank you. Please come have a seat. Excuse me 1 second. Alrighty. How are you this morning, sir?
I'm doing well, thank you.
Okay. All right. Well, we're going to go ahead and get started. Counsel, whenever you're ready.
Your honors, we have a witness finder for Dr. Baumgartner, since the screen is a little bit farther away so he can see if that's all right.
Okay. Any objection?
What's in the witness finder?
It's just his presentation and then the exhibit he's on to admit, just copies of his tables and charts.
So the actual PowerPoint's not in here?
We have a copy of the PowerPoint as well, but we would plan to give him.
With the stipulation that these aren't admitted, they're just for his reference, that's fine.
Yep.
All right. Thank you, counsel.
And then we also have copies of the PowerPoint itself for your honors and for Dr. Baumgartner, just for reference and for
Okay.
opposing counsel.
So,
Just because there's a lot of charts and tables that have small numbers, that might be difficult.
so as background, we had agreed that it would be fine to use PowerPoints during presentation. I want to start with that. The question we had after yesterday was, who actually wrote the PowerPoints? Who created them?
It was a combined effort between.
Is that relevant?
It is,
Okay,
because
why
if
is
the
that?
attorneys created the PowerPoint and they're putting it on the screen, that would be the definition of leading. If the witness created the PowerPoint and is using it to make a presentation, then that's his demonstrative. So that's why it matters to us.
Well, that's the first time I've ever heard that argument,
Yeah.
but what do you say, counsel?
I'd say that they're Dr. Baumgartner's words and his calculations, so the tables and charts that are in the PowerPoint were created by Dr. Baumgartner. And this is just for a visual aid for,
We can handle each slide as they
Your
come.
honors.
I mean, that's fine, as far as, as long as they're not admitted as far as handing them out at this point.
Okay. All right, very good. Well, let's proceed then.
Actually, if you have one. Oh, thank you. So,
Yes, counsel?
yeah, I keep getting stuck on this.
That's okay.
He's handing him a roadmap for all the questions he's about to be asked, along with the answers.
A
That's
roadmap
leading.
for his questions. What was handed to Dr. Baumgartner?
What
The
appears to be an
PowerPoints?
outline of his direct examination.
An outline? I don't see any questions on here, counsel. I see a typical PowerPoint that's used in many trials. So if you don't want Dr. Baumgartner to have it, that's fine, but there are no questions on here. So this is not a direct examination.
I guess the reason I say it that way is the first
Yes.
slide is his qualifications. We all know now that the first question is gonna be about his
Well, we don't know
qualifications.
what the questions are gonna
Okay.
be. We have no way of predicting that. So, just to make this simple, let's just use the PowerPoint for Dr. Baumgartner. Officer, if you could hand that back to
and Dr. Baumgartner.
counsel, yes. All right, thank you. You may
Okay.
proceed.
Thank you, Your Honor.
Okay.
Dr. Baumgartner, good morning.
Good morning.
Will you please state your name for the record?
Yes, my name is Frank Baumgartner, Baumgartner.
Thank you. And can you please speak up a little bit just so everyone can hear you?
Yes, is that better?
Yes, I believe so.
Thank you.
And Dr. Baumgartner, what is your educational background?
My educational
Objection, Your
background is,
Leading, I'm trying to do this on questions that aren't substantive to begin. She just put the answer on the board before he answered the question. She's providing the answer before he gives it.
Okay.
Your
let's-
Honor.
Yes, I'm sorry, go ahead.
We did this yesterday with Dr. Holloway, and there were no objections from defense counsel. She had her qualifications on the PowerPoint. And Dr. Baumgartner knows his qualifications. I don't believe that's a leading question.
It was a different attorney, different counsel, so, but there is an objection on the floor, and I do think that the doctor should answer questions without the assistance of the PowerPoint. But again, he is an expert witness, and PowerPoints are very often used, so I'm sure the doctor knows his qualifications, and I'm sure that the PowerPoint is not gonna assist him in answering that. But since there has been an objection, let's just take the safe route and have the expert answer to the extent that the PowerPoint is gonna assist the judges in understanding the evidence or with the flow of the examination, we will use that. But again, this is a bench trial, this is not a jury trial, so please have confidence in us that we can distill and assess the credibility of the witness, the veracity of the witness, and this is just used as a visual aid. It's not in evidence, so with that, let's go ahead and proceed.
Thank you, Your Honor.
All right, thank you.
So, Dr. Baumgartner, what is your educational background?
as far as I can recall, I have a bachelor's degree in French and political science from the University of Michigan. I received those degrees in 1980. I received a master's degree from the University of Michigan in political science in 1983, and my PhD in political science also from the University of Michigan in 1986.
And where are you currently employed?
At the University of North Carolina at Chapel Hill.
And what titles do you hold at UNC?
I hold the Richard J. Richardson Distinguished Professorship in Political Science
And how long have you taught at UNC?
since 2009.
And before that, how long have you been in
Sorry,
academia?
we have that on the, who's working the projector? All right, counsel, okay, thank you, I'm sorry.
Sorry about that. And before that, Dr. Baumgartner, how long have you been in academia?
I received my PhD in 1986, and I've been a full-time faculty member ever since then.
And were all of these positions in the field of political science and statistics?
Yes, I've been a professor of political science since I received my PhD.
And can you briefly describe your current areas of academic focus for us?
Well, throughout my career, I've studied public policy, government actions. I've used statistical methods to analyze various aspects of government policymaking processes. Since approximately 2000, so halfway into my career, I became interested in criminal legal matters because I wrote a book about the death penalty that was published in 2008, but which the research began in around 2000. Since then, I became interested in racial disparities, poverty, gender disparities, geographic disparities, various types of statistical analyses of criminal justice matters. But I've maintained my activity also in other areas of public policy analysis, always with a statistical focus.
And you teach statistical methods in the classes you teach at UNC, is that correct?
Yes, I teach research design. I've taught over my career many times, and the courses that I teach include the use of statistical methods, and the articles and books that I've published virtually always, not every single one, but every single book that I've published has used those methods, and the vast majority of the articles that I've published have as well.
And you just noted that you published in the field of political science, correct?
I have.
And what have you published in the fields? How many books?
Well, I've written, co-authored, or co-edited 17 books and over 100 peer-reviewed journal articles or book chapters or law review contributions, as well as other smaller items.
And have you won any awards for your published works?
I have. I've won a number of book awards for several different books from different political science associations, International Public Policy Association, the American Political Science Association, and some of its divisions. I was awarded a Guggenheim Fellowship, and I'm an elected member of the American Academy of Arts and Science.
And I believe you already said this, but you employ statistical analysis in your published works, correct?
Yes, I do, consistently.
And you've performed statistical analysis of racial disparities in the criminal justice system.
Yes, I have. For example, I published a book in 2018 about racial disparities in the outcomes of traffic stops. That was based on a database of over 20 million traffic stops in North Carolina. And we looked at the differences in the rates at which black and white drivers might see that traffic stop end up in a search or an arrest or a different outcome. So I do have a lot of experience in using government databases to analyze racial differences in outcomes.
And have you ever testified as an expert witness before, Dr. Baumgartner?
Yes, I have.
And have you testified as an expert witness in any similar trials related to racial disparities and felon disenfranchisement?
Yes, I have.
And the courts where you testified accept you as a qualified expert to provide expert testimony?
Objection, Your Honor, leading.
Could you repeat that question, counsel?
Did these courts accept you as qualified to provide expert opinion?
Overruled. May answer the question.
Yes, I've been accepted as an expert each time that I've been offered as an expert.
And have you submitted an affidavit or expert opinion in other cases, even if you did not testify as an expert?
Yes, on numerous occasions I've written reports or affidavits that did not involve testimony in other legal cases.
And have courts or judges cited your research in any other cases?
Yes, some of my published research has been cited by the Supreme Court of the United States, by the Supreme Court of the State of Oregon, State of Iowa, and an appellate court in the State of Arizona on different matters, some relating to patterns of use of the death penalty, and some related to the book I mentioned about traffic stops.
Your Honors, at this time, we would tender Dr. Baumgartner as an expert in political science, statistics, and intersection of race and criminal justice.
Your Honor, we have no problem with the first two. The third seems to be a little broad.
What was the third one?
The intersection of race and the criminal justice system.
All right, so it's political science, statistics is the second,
Correct.
and then the
Intersection
intersection of racial and
of race and the criminal justice system.
race and the criminal justice system. All right, specifically when you say the intersection, could you be more specific, please? In terms of the expertise?
As Dr. Baumgartner noted, he's written numerous books and articles on his statistical analysis of racial disparities in the criminal justice system as related to death penalty, as related to traffic stops, and has previously testified in a matter where he was accepted as an expert related to race disparities in felon disenfranchisement.
All right, well, I agree the tender is a little broad in terms of the intersection of race and criminal justice. That's a little broad, so are you able to narrow that tender or that request?
We would narrow that to racial disparities in the criminal justice system.
I'm sorry, repeat it again.
Racial disparities in the criminal justice system, if that's
All right,
acceptable.
any objection, counsel, to that? Racial disparities in the criminal justice system.
I'm only trying to be careful. We have no objection to the idea that he is a statistics expert and that he has done a statistical analysis that relates to felon disenfranchisement in Tennessee. My problem is the criminal justice system is a huge thing, and lots of it has nothing to do with felon disenfranchisement, and lots of those things aren't relevant to this case. And I am worried that by tendering such a broad expertise that opens up all kinds of questions that he would then be able to speak to that we haven't cross-examined him on as to his actual expertise. So if we can narrow it to the numbers associated with felon disenfranchisement in Tennessee, sure, we'll agree that he is likely an expert on that. But racial disparities in the criminal justice system as a whole just still seems to open it up way too broad.
We believe that Dr. Baumgartner has provided plenty of publications and has plenty of relevant experience in racial disparities in the criminal justice system and different facets of the criminal justice system. And also, statistics and political science are also broad fields that involve many different facets.
And how would those racial disparities be relevant in this particular case in terms of his testimony and expertise?
Dr. Baumgartner conducted an analysis of the racial disparities in felon disenfranchisement and the way that different race groups in Tennessee are affected and impacted by the disenfranchisement laws that are in effect.
Well, that's I mean, that's specific, I think answers the question. I think the objection was to the criminal justice system as a whole, I guess in the entire world, I think is the objection. Your answer narrowed it down. I mean, that answer seems to be responsive to your objection.
And it mirrors exactly what we're okay tendering him for.
Okay.
Well, I'm a little, well, I just have a question about when we say in Tennessee, because Dr. Holloway had pretty broad experience, and she testified about discrimination in the southern states. So I want to be careful not to limit Dr. Baumgartner's testimony only to Tennessee to the extent that it would be relevant. So is there somewhere in the middle that both counsel can agree on in terms of what the scope of his opinions or expertise would be?
Sorry, go ahead.
We would narrow to racial disparities in felon disenfranchisement in the United States, if that is acceptable to your honors. In opposing counsel.
Counsel? Racial disparities in felony disenfranchisement.
We're okay with that. We may have some objections if the testimony goes outside what's actually in this report that we've been able to cross-examine him on, but that's fine for now.
Okay, all right, very good. All right, then the court will tender Dr. Baumgartner as an expert in political science, statistics, and racial disparities in felony disenfranchisement. You may proceed.
Thank you, Your Honors. Dr. Baumgartner, you submitted a report in this matter, is that correct?
Yes, I did.
No.
Your Honors, we would like to offer Dr. Baumgartner's report in this matter into evidence as Exhibit 34, I believe.
Okay. Any objection to the report, counsel?
We won't seek to exclude the report as a whole. We may have some objections to specific parts as to relevance, if that's fine.
Okay, all right, we'll mark that the next exhibit, then that will be, is that 33?
34, I believe.
34, okay, thank you.
And for our record, it's stamped as Plaintiff's Exhibit 31. It'll be 34 for trial exhibits.
All right.
Now, Dr. Baumgartner, is this a copy of your report that you have in front of you?
Yes, it is.
And did you work with anyone else in preparing this report?
Yes, I did. I worked with my colleague, Dr. Kanisha Johnson.
And what are Dr. Johnson's qualifications?
She's also a professor of political science at UNC Chapel Hill. She holds her bachelor's degree from UNC Chapel Hill, her master's in law from the University of Chicago, and her PhD in political science from Harvard University.
Thank you. And what issues did plaintiff ask you to evaluate in this matter?
There were exactly 3 issues that I was asked to evaluate. The first had to do with the share of felony convictions that derive from a jury trial versus other mechanisms such as a plea agreement, but anything other than a jury trial.
I'm sorry, could you repeat that?
The first had to do with the share of felony convictions in Tennessee that relate to a jury trial.
Okay.
And also in Tennessee, but I had evidence about other states as well. The second had to do with racial disparities and felon disenfranchisement in the state of Tennessee. And the third had to do with the possible impact of those disenfranchisement patterns on elections.
Thank you, Dr. Baumgartner. And if we could click to slide 5, if that would be acceptable.
Why don't we do this? Why don't you ask him his conclusions from the report and then throw that up there? Your Honors, to explain the whispering, what I've just told opposing counsel is to the extent that there are slides that are blow-ups of what's in the report that's now in, we don't have any objection to putting those up on a screen or handing him those.
Okay.
It's to the extent that there's either summaries that he hasn't testified to or new figures and charts that he hasn't. Those will be the genesis of our objection.
Okay, well, if you see something go up, then you
Yeah.
just make an objection.
I just
Okay.
wanted Your Honors to be aware of the
Okay.
whispering that was going on.
All right, thank you.
All right, apologies, Dr. Baumgartner. Can you let us know what are the main conclusions you drew from your analysis?
I'm sorry, Counselor, if you could speak up, it's kind of hard to hear up here. Do we need to adjust that mic for you? Oh, you're working on it? Okay.
I'll
All right,
speak
'cause we
closer
have-
to this one.
We could probably raise it up a little bit if necessary, because it's been adjusted, yeah. I know first we have 1 book, now we have 3.
Nope.
Maybe we can put some additional books under, there are books in our. Do you want me to step off and get more books? I can step off and get them. Oh, would you go? I'll step off, okay, okay. Just be easier.
the ones that might be temporary, it's also very disparate by race with the ratio of approximately 2.6. So black Tennesseans are 2.6 times as likely as white Tennesseans to be disenfranchised. I found that that number was approximately 10% of all black Tennesseans compared to approximately 4% of white Tennesseans. So that's how we get the ratio of 2.6. In the more limited group of people permanently disenfranchised, the numbers are significantly lower, but the racial difference is even higher.
I'm sorry, could you repeat that last, I don't know if I quite understood that last statement.
There are 300,000 people disenfranchised, and 13,000 of them are permanently disenfranchised because of the offenses that they were convicted of. We call that, in my report, Category 2. Category 1 is all people disenfranchised. There's 300,000 and over 300,000 such people. The racial difference among that large group is 2.6. That is the ratio of white to black, 2.6. I should say the ratio of black to white, 2.6.
Is that in the category 1?
Category 1, the broadest category. 10% of black Tennesseans, 4% of white Tennesseans with some decimal places. So 2.6 is the ratio. There's a smaller group, 13,000 and some people who are permanently disenfranchised. So because that's such a smaller group, all of the rates are significantly lower. 13,000 people out of 6.5 million people in the state of Tennessee. So the rates are lower. But the difference in the black rate compared to the white rate is even greater. It's 3.2. So there is a very significant racial disparity in permanent disenfranchisement for white and black Tennesseans. It's greater among the group that are permanently disenfranchised than it is for the larger group that includes the temporary disenfranchised. But in both cases, the patterns are highly similar, and you can judge for yourselves whether 2.6 and 3.2 are very different numbers. They're quite substantial numbers. In other areas of analysis of these types of disparities greater than 1.2 are considered to be substantively important. 20% difference would be considered to be a substantively important difference. So anything less than 0.8 or greater than 1.2 might be considered to be a substantial difference in the odds of a certain outcome happening based on the category to which you belong. So double the rate, obviously you can judge for yourselves, is that an important substantive difference? And the finding is here that it's 3.2 times the rate for blacks compared to whites in the narrow group. So that's my third conclusion. The fourth conclusion is that this is highly consistent across the entire geography of the state of Tennessee. We looked county by county across the 95 counties, and we found that there are, of course, counties in Tennessee that have very low populations, and they have sometimes very few African Americans living in certain counties. Populations of some counties are so small, and you'll recall that the permanent disenfranchised group is 13,000 across the entire state. So when you break it down county by county, there are a few counties where in fact no black person is disenfranchised permanently in that county. But those tend to be the counties that have quite small black populations. I identified, I think, 6 or 8 such counties where there were no blacks disenfranchised at all. However, when we look at the broad patterns, it's consistent almost everywhere, and certainly everywhere where there's a large number of black people in the population, a higher share of the black population is disenfranchised either temporarily or permanently than the share of the white population. So this is consistent in the small counties and the large counties, and in fact, the largest counties of the state, including Shelby County, have higher than the state average. They have rates of the ratio of disenfranchisement is even greater than 3.2. The statewide average is 3.2. The statewide rate is 3.2, the ratio from black to white. In Shelby County, it's even higher than that. In Hamilton County, Davidson County, it's also Knox County. The largest counties have even higher rates of ratios of disenfranchisement of blacks to whites. So the geographical analysis suggests that the large statistically apparent disparities that obtain across the entire state do not derive from a few outlier counties. They're consistent across the entire map of Tennessee. So that, I think, is my fourth conclusion. And that conclusion holds whether we look at the broad group of the 300,000 people disenfranchised even temporarily, or we look at the smaller group of 13,000 in category 2. Then I had a conclusion about the possible impact on elections. If there are 300,000 people disenfranchised, and there's an election where the margin of victory is less than 300,000, and the margin between the first place winner and the second place runner-up, or then mathematically it's possible that these policies of disenfranchisement would affect the outcome of that election. That's a simple, and that's the analysis that I've done. I don't make any assumptions about whether people would vote, how they might split their votes as a group. I just count and note that we have over 300,000 people at least temporarily disenfranchised. We have 13,000 people permanently disenfranchised. And in those cases, such as some local elections, elections for judge, elections for city council, elections for county commissioner, elections for state legislative races, sometimes those election results come down to the wire. Sometimes there are very, very close elections. So without giving specific examples, but that might come up later, my conclusion is that sometimes these policies could affect the outcome of elections. Again, I don't try to predict how any particular individual would vote, but that is my conclusion. So overall, in answer to the 3 questions, it's not by jury trial on average. It's very disparate by race. It affects the entire geography of the state, and the numbers are great enough that they could affect the outcome of some elections.
Thank you, Dr. Baumgartner. And just real quick, you submitted a corrected report in this matter, is that correct, prior to your deposition?
Yes, I did.
And did your conclusions change when you submitted a corrected report?
No, there were no changes to the substantive conclusions at all.
Thank you very much. Are there any objections to slide 6?
Straight out of his report, right?
Yep. Yep. All right, if we could go to slide 6, please. Thank you. All right, Dr. Baumgartner, is this table 1 from your report?
Yes, it is.
Plaintiff would like to introduce a larger version of table 1 into evidence.
Okay, all righty.
And this says yellow stamp plaintiff's exhibit 43, but will be admitted as exhibit 35, I believe. Is that correct?
Okay, no objection, counsel?
No, Your Honor.
Thank you.
Dr. Baumgartner, can you explain at a high level what we're looking at, what this table includes?
Yes, on the screen is a version or presentation of the finding in Table 1 of my report, which comes from the National Center for State Courts, that provides information about felony jury trials as a percentage of all judicial outcomes across selected states. You should note that not all states are listed there. They weren't available in the data source that we found, which is the National Center for State Courts.
Is that the most comprehensive source you were able to find?
It's the most comprehensive source, and it's consistent with other sources that we found that had to do with individual states or the federal system, or also my own experience in analyzing court outcomes in North Carolina. So these are the felony jury trial rates. You can see above 6% in Arkansas, but on average, very low rates.
And the numbers on the screen and in your table include both state and federal jury trial rates?
Yes, they're reported by state, but they incorporate both federal trials as well as, or federal cases as well as state cases.
And why are some states listed twice?
Some states are listed twice in this report because they differentiate in a few states between specialized courts and general courts. But the rates are still per 100 judicial outcomes. So we wouldn't add those rates together. We would combine them by averaging, weighted by the number of observations. So we don't add one to the other. The rates are all extremely low as a share of all judicial outcomes.
And as you mentioned before, we can see Tennessee on the screen. And what is the rate for Tennessee?
The rate for Tennessee listed in the table is 1.01%.
And real quick, can you explain what you mean by felony jury trial rates?
My understanding of it is that for every felony conviction, it shows the rate per 100 such convictions, persons convicted, that derived from a jury trial as opposed to some other judicial mechanism.
So in plain terms, about 1% of felony convictions come from a jury trial as opposed to alternate mechanisms, is that correct?
In Tennessee.
I'm sorry, as opposed to what?
An alternative mechanism.
Alternative mechanism, okay.
That's correct.
Thank you. And what is the importance of this information in plain terms?
Well, my understanding is that from the testimony yesterday, I was in court listening, but it's not my expertise, but my understanding of the question
Yes,
is,
Your Honor, he prefaced the answer with, it's not his expertise, he's here as an expert witness. Whatever he says next is inappropriate testimony.
Withdrawn, Your Honor. In your expertise, what is your understanding of what is important about this information?
that the Tennessee Constitution
Objection, Your Honor, this is legal
Withdrawn,
expertise.
withdrawn, Your Honor.
Okay.
You are so soft-spoken.
Oh,
I need you to
so
speak
sorry.
up.
I'll speak up.
I'm
I'll
really
speak up.
having a hard time hearing the questions.
So this just tells us that on average, few convictions, felony convictions, are derived from jury trials. Is that correct?
1%, I would say that's very few.
Thank you, Dr. Baumgartner. We moved on to the second issue analyzed. And once again, remind us, what was the second issue analyzed for plaintiff?
The second issue is whether there are racial disparities in the rates of disenfranchisement.
And what data did you use to do that analysis?
Well, I received a large database from the Tennessee Department of Corrections that incorporated over 500,000 records of individuals who have been convicted of a felony in the state of Tennessee. Some of those convictions went back in time, several decades, but anyway, it was a database provided by the state that included information about the offense, the primary offense, to which the person had been convicted, and the county of the conviction, and the race of the individual, as well as some other information that we did not need to analyze in order to calculate the rates by race.
And did you also use information from the U.S. Census Bureau?
Yes, then, and
Leading.
Sustained.
Did you use any other information, Dr. Baumgartner?
the first bit of information was the people convicted of felonies, and the second was the residential population of the state of Tennessee, and we took that from the census by county, by race, as well as the state totals.
And did you?
I'm sorry, did you say residential population or residential demographics? Did you say, I'm sorry, what was your answer?
I used the word population, I believe.
Population, okay.
And did you have to perform any sort of data cleaning on the database you received from the Tennessee Department of Correction?
Yes, we did.
Can you explain that process for us?
Yes, if you don't mind, I would like to find the page. Yeah, I found the page of my report that lays it out so I can be clear and accurate.
And what page is
Doctor?
that?
It's page 3 of my report. There are some bullet points towards the top of page 3. We moved from 544,000 records, plus or minus, which to 323,000 records by eliminating duplicates, cases before 1973, of which there were very few, cases with erroneous dates in the future. So those were obvious data errors, of which there were only 2 such exclusions. And people with felony convictions that derive from Tennessee courts rather than out-of-state courts.
So to clarify, you only included individuals with felony convictions in Tennessee state courts?
That's correct.
Were there death dates available in the TDOC database?
Yes, thank you for asking that question. We also eliminated a few people who had passed away, according to the DOC, Tennessee Department of Corrections. So we eliminated people who were no longer alive.
And is this a standard methodology for cleaning data sets in your field?
Well, whenever one receives a very large database from a government agency, it's important to evaluate its accuracy. This one was highly accurate, but we found 2 cases where there was an apparent error in the date, since the date of conviction was in the future, and obviously that couldn't be true, and it's important to recognize occasionally there can be data entry or typographical errors in a large administrative database. But in general, this database was quite clean. The biggest work that we had to do was to find people with multiple felony convictions. So the same person, of course, might have more than 1 felony conviction, but we were trying to count by person, not by conviction, so we needed to identify anybody who might have a duplicate record. That was the largest issue. And we did that by using their name, their demographics, and we were able to identify a large number of duplicates.
Thank you, Dr. Baumgartner. And you're aware that defendants also submitted an expert report related to statistics in this matter?
Yes, I am aware of that.
And do you know if defendant's statistical expert also performed data cleaning on the set?
Yes, I paid careful attention to the data cleaning that the state's expert used, and they provided a good explanation of the data cleaning that they used, and they used slightly different dates of exclusion, but there are very few observations from the early years in the database. So I think the state's expert excluded cases before the 1980s, and I went back to 1973, but it made very little difference. Anyway, the state's expert came up with a final number of, I think, 322,000 and some observations, and my report is based on 323,000 and some observations. So the numbers were very, very similar.
And Dr. Baumgartner, you were asked to analyze racial disparities for different categories of convicted individuals. Is that correct?
Yes, I was.
And what were those categories?
The first category was all people in the database, all those with a felony conviction. The second category, and we refer to that as category 1. The second category,
I'll pause you for a second, Dr. Baumgartner. If we could put slide number 9. I believe opposing counsel has no objection to this. All right. You may continue, Dr. Baumgartner.
the second category is the subset of the first category, which is the people who are convicted of certain felonies that are permanently disenfranchising.
Thank you. And did you also analyze a third category in this matter?
I did. There was a third category initially presented to me, which I could explain if that's of interest, but
Your understanding is that's no longer relevant to the matter.
I understand that it's no longer relevant to the legal question, so it is in my report, but I won't be testifying about it.
Can I clarify that? So in looking at page 7 to the chart in the, I think the supplemental report, would that be category 3 that you're referring to?
Yes, it would.
Okay.
And throughout the rest of your testimony, when you are referring to category 1 or category 2, those are the categories that you just explained for us, is that correct?
Yes. Category 1 is all felonies. Category 2 is the permanently disenfranchising felonies.
And how did you identify the individuals that fell into category 2 for permanent disenfranchisement?
We had a list of the offense codes and the dates during which those offense codes were permanently disenfranchising based on the legislation that mandated permanent disenfranchisement for different offenses. Those offenses changed, I think, in 1986, changed again in 2006. We were provided the dates and then the qualifying or disqualifying, I should say, offenses. And we assigned a value of 1 for any person who had a qualifying or disqualifying offense during the relevant time period, and aggregated that up appropriately using the time periods with the offense codes, and that generated the list of 13,000 and some people who had been convicted of those permanently disenfranchising felonies. So it was a little bit tedious, but straightforward statistically and database management, just to identify the people that had the disqualifying offense in the appropriate time period.
And the offense codes were in the Tennessee database. You didn't have to do any guesswork on that.
No, there was no guesswork involved. We just, did you commit one of the disqualifying offenses? The offense is listed in the database, and then what was the date of conviction, and did those correspond?
Thank you, Dr. Baumgartner. And so you analyzed felon disenfranchisement at a statewide level, is that correct?
I did.
Sustained as to leading.
Did you do a statewide analysis, Dr. Baumgartner?
I did a statewide analysis. Yes.
And if we could flip to slide 10, please. Any objection? Correct.
Okay, thank you.
This table contains information taken from table 2 in your report.
Yes, it does.
And we would like to admit a larger version of that table into evidence.
Okay.
It's 40.
Table 2 of the report actually includes more information than this. This isn't table 2 of the report, so we do have an objection.
Okay. Counsel, response?
Sure. So we just omitted the last 2 categories in the table, Hispanic and other, as Dr. Baumgartner's analysis focuses on the white and black disenfranchisement rates and ratios.
All right, Mr. Hilo? Oh, hey, hello?
I mean, the numbers are accurate as to the total, the white and the black. We have no issue with that.
Okay.
To the extent the court may find it informative that there were other races included, if we're gonna have an accurate depiction of table 2, the other races are there. But that's, I mean, it's in the report, so it's up to the court.
And we are admitting the full table into evidence for your reference.
All right, let's see the table you're gonna mark into evidence. So it's not the one on the slide, it's the one in the,
The one in the evidence, yeah, the one in the
Okay.
Isn't it
report.
already in evidence with the report? I mean, it's page 7.
We're admitting larger versions for your reference because they can be a little small in the actual report.
okay, the court will mark this, the next exhibit, is it 36?
Yes.
37, okay. Sir?
36.
Okay. Yes.
And now, Dr. Baumgartner, can you explain column by column what we're looking at here?
Yes, the first column lays out the categories, and as you recall, the third category is irrelevant, so we won't be talking about that today, but the first category is all those disenfranchised. Second category is the permanent disenfranchisement. The second column lays out the total across the state of Tennessee. I should have said that in the first column, we also have at the bottom the census population numbers for Tennessee. So when we look at the second column, the total, we see there are 322,984 individuals disenfranchised. In category 2, 13,000 and some. And then the census population for Tennessee at the time when I gathered it was 6.9 million and some change. Among white individuals, in the next column, 195,000 and some are disenfranchised in category 1. That represents 60% of those disenfranchised. In category 2, there are 7,500 and some whites disenfranchised, which represents 55% of those disenfranchised in that group. And at the bottom, we see that there are 5 million and some whites in the state, and they represent 72% of the state population. The last column shows the black numbers, the numbers disenfranchised who are black, 117,000. That means that they represent 36% of those disenfranchised in category 1. In category 2, 5,500, they represent 40% of those disenfranchised in category 2. And at the bottom, we see the total population of black African Americans in Tennessee, 1.1 million, 16%. So we can see the differences in the shares that black and white individuals represent in the disenfranchised groups compared to their share of the population at the bottom.
And so as we're looking at the table, black Tennesseans are only 16% of the state's total population. 16.5% of the state's total population.
That's correct.
But they make up 36%, but black Tennesseans make up 36% of those who are disenfranchised.
That's correct. And then they make up 40% of those who are permanently disenfranchised. I would say that in my report, this table provides the base numbers, and then we look at different ways, or I wrote in the report, describe different ways that we can compare these numbers. But the raw numbers are available for for the court in table 2.
Thank you, Dr. Baumgartner.
So I do have a question. So if African Americans or black individuals represent 16.5% of the total population of Tennessee, but yet the category 1 is 36.3, category 2, 40.2, how do we consider that in light of the fact that African Americans are only 16.5% compared to white Americans who are 72.5? I understand those raw numbers, but what does that mean?
Well, very simply, it means that African Americans are vastly overrepresented among those disenfranchised by a factor of approximately double, or even more than double their share of the population. Double 16.5 would be 33%. These are even higher than double their share of the population. On the other hand, white Americans are underrepresented. They're 72% of the population, but 60 or 55% of those who are disenfranchised. So one group is underrepresented among the disenfranchised, and the other group is very greatly overrepresented as a share. Now, of course, you should understand that the percentages are what we call row percentages. They sum to 100% across the rows. And there are, in my table 2 in the report, also Hispanic individuals and people of other race listed. And so if we combine all of those, they do sum to 100%. Obviously, 60.6 plus 36.3 in category 1 for white and black does not sum to 100%. The reason is that there are Hispanics and people of other races also included in table 2 that aren't on the screen. But anyway, this table, I think, is important for the court to understand. It's fundamental. Black people are more than double the share. Their rate of presence among the disenfranchised is greater than double their rate of presence in the general population. White individuals are substantially underrepresented among the disenfranchised. So when we compare those two, one being underrepresented, one being dramatically overrepresented, we get to the ratios of, I think there are 2.8 for category 1 and 3.2 for category 2. But all of those calculations derive from this table, table 2, which gives the raw numbers.
All right, thank you. And I think it was 2.6. You just said 2.8. Was it 2.6 or 2.8? Category 1.
I think we'll get to that, but it's 2.6. I'm sorry. I'm looking at table 3 in my report now in front of me. It's 2.6 and 3.2.
All right.
You're right.
And on this exhibit, category 3, we should just strike through that. That's no longer an issue, right?
Correct.
Okay.
And Dr. Baumgartner, your data set of 322,000 felony records only includes individuals with state convictions from the state of Tennessee?
I'm sorry, repeat the question, counsel.
For your data set of 323 total felony records, does it include state convictions from the state of Tennessee?
Yes, it's limited to people with, as I described earlier in the data cleaning, we excluded people who had convictions from out of state. So these are Tennessee convictions.
Does it include out-of-state convictions?
Does not.
Does it include individuals with felony or federal level felony convictions?
Does not.
Why does it not include those individuals?
The data on federal convictions was not made available to us because it was not in the Tennessee Department of Corrections database. The data on interstate or cross-state, out-of-state convictions, we didn't analyze because we didn't know they didn't have the offense codes. We couldn't assign those convictions to, for example, whether it was a felony or not, and what type of felony crime it may have been. So we couldn't assign the people to category 1 or category 2 because the offense codes were not there. So the result of this is that these numbers are conservative estimates. They underestimate the number of people disenfranchised. And I thought that was the best way for me to analyze the data.
For the census numbers, did you use voting age population?
The census numbers relate to the total population.
And what impact would that have on your analysis?
it would have a very minor impact, could change the ratios ever so slightly. There are certainly no juveniles listed in the felony conviction data from the state of Tennessee. Those are adults. And the census data corresponds to all age groups, including children. I don't see any reason to believe that white and black would have vastly different shares of persons under age 18. The census data that we received had age groups that didn't correspond. I think the age groups went to under 16 and then 16 to 21. It didn't have a cutoff at age 18, as I would have preferred. So rather than use a subset of the census data, we use the entire census data. I think it would have a very small, substantively unimportant impact on any conclusions.
And let's pull up slide 11, which is table 3 from Dr. Baumgartner's report. And again, we would like to enter a larger version of the table into evidence.
Okay.
And
Exhibit 37.
Thank you, Your Honor.
Welcome.
Dr. Baumgartner, what does table 3 show, broadly speaking?
Well, table 3, I have in front of me both table 2 and table 3, and I think it might be very helpful for the justices to look at both of them combined. The numbers in table 3 correspond to the numbers in table 2. So, for example, in category 1 in table 3, I represent that 4.7% of the Tennessee population is disenfranchised. That number is calculated from the corresponding cells in table 2. In table 2, we see 322,000 people disenfranchised in category 1 and a population of 6.9 million. Divide one by the other, multiply by 100, you get 4.7% of the population is disenfranchised. So table 3 shows the percent of people disenfranchised. In the second column labeled total, we see the total number. And then by race, for category 1, we can see that 3.9% of white Tennesseans are disenfranchised and 10.3% of black Tennesseans. Again, these numbers derive from a calculation based on table 2. It's simply the percent of the total population who are disenfranchised separately by race. So 3.9% of whites, 10.3% of blacks temporarily disenfranchised. Divide the black rate by the white rate, you get the ratio, which is 2.6. What that means is that black Tennesseans are 2.6 times as likely as white Tennesseans to have a disenfranchisement. In category 2,
Temporary, right? Line 1 is temporary.
line 1 is all, includes temporary as well as permanent.
Okay, thank you.
Line 2 is temporary, and you can see that, line 2, category 2 is the permanent disenfranchisement category, and you can recall from table 2 that those numbers are much smaller, 13,000, 7,577 whites divided by 5.007 million white people living in Tennessee, you get a rate of 0.2%, which is indicated on table 3. So 0.2% of white people are permanently disenfranchised. For black people, it's 0.5%. And the ratio is 3.2. So the numbers are lower. The percentages are lower because obviously 13,000 is a smaller share of the population than 322,000. So the numbers are all reduced. but the differences in the rates are quite substantial. So table 2 leads to table 3. Table 3 is calculated simply by generating the percent of the population who are disenfranchised in the different groups. And then the last column of table 3 simply shows the ratio, which is 1 divided by the other. It's very simple. And that ratio is understood in statistics as a very important indicator. It's sometimes called an odds ratio, a prevalence ratio, but it's an important indicator of equality. If the ratio were 1.0, it would mean that both white and black groups had the identical rate of disenfranchisement. If the rate were 0.5, it would mean that black individuals had half the rate of white individuals. If the rate were 1.5, it would mean that blacks were 50% more likely to be disenfranchised. So the rate of 2.6 or 3.2 means that black individuals are 220% more likely than whites to be disenfranchised permanently, or 3.2 times as likely.
If we can turn to the next slide. Dr. Baumgartner, is this figure 1 from your report, part of figure 1 from your report?
Yes, it is.
And we would like to enter the entirety of figure 1 into evidence. And it'll be trial exhibit 38.
I'm sorry, could you repeat that, counsel?
It'll be trial exhibit 38, I believe.
38, okay, thank you.
And looking at figure 1, Dr. Baumgartner, what does this show?
Well, again, I would urge the court to have in front of them table 2 as well as this figure. The figure derives from the numbers that are laid out in table 2. So in table 2, we saw that white individuals are 72% of the Tennessee population. So the first pie chart lays that out in graphical form as a simple pie chart. The white group listed in blue with the initial W for white is 72.5% of the area of that pie chart. Blacks are 16.5%. So it's simply laying out the numbers in table 2 as a pie chart. So you can see that when we move from the population to category 1, the red slice of the pie grows. The population number is 16.5% black. That's the red slice of the pie in the first pie chart. When we move to the category 1, those who are disenfranchised, that slice of the pie grows dramatically, and you know from table 2 that slice of the pie is 36%. It's a simple graphical illustration of the change when we move from the population to category 1. And when we move to category 2, the black slice of the pie grows to 40.2% as is laid out in table 2. So figure 1 is a simple graphical illustration of the numbers that are laid out in table 2. If there were no racial difference in the rate of disenfranchisement, we would have 3 pie charts that look the same. And in particular, the black slice of the pie, the red slice of the pie corresponding to the African Americans would have the same share. And you can see by simply glancing at figure 1 that it more than doubles in size. So this is a simple way of presenting the data that I thought would be helpful to the court.
We'll look at slide 13, which is figure 2, part of figure 2 from Dr. Baumgartner's report. And we will admit we'll admit this into evidence. And that'll be exhibit 39.
All right, thank you, counsel.
Thank you.
And Dr. Baumgartner, can you please explain what we're looking at here?
Yes, here I would urge the court to have in front of them Table 3, as well as Figure 2. You recall that Table 3 is a simple calculation of the percentages of the, is the rates of disenfranchisement by race. And so we saw in Table 2 that 3.9% of whites are disenfranchised and 10.3% of blacks are disenfranchised. So Figure 3 is a graphical illustration, and it goes to one additional decimal place. That's the only difference between the numbers that are listed in Figure 2 are the same as the numbers in Table 3, although I added one extra decimal place. I can't tell you why I did that. It makes no difference. It's a graphical illustration of the numbers that derive from Table 3. Of course, those derive from Table 2. So all of this is a simple way to illustrate that the differences that are laid out in the statewide analysis by race are not marginal, small little differences at the edges. You can see by looking at Figure 2 that it's a big difference. It's not just a 15% difference. It's 2.6. And you can see that by looking at the size of those two bars. So these are just illustrations. As a statistician attempting to explain numbers to a court of law, I want to make sure that I present it in a way that perhaps can seem redundant, because I am presenting the same data from Table 2 in several different ways, but I hope that it will have an intuitive understanding for the court that these aren't small differences. These are big differences, very large disparities by race.
And just to clarify, this is for Category 1. Oh, sorry. Is this for category? What category is this for, Dr. Baumgartner?
Figure 2 on the screen right here is for Category 1. It says so. It says as it says in the text right on the screen.
And Dr. Baumgartner, in preparation for your testimony today, did you prepare a similar figure for Category 2 on permanent disenfranchisement?
Overruled.
Yes, I prepared the identical figure based on the numbers in Table 3 in my report to illustrate for the court the exact same demonstration based on Category 2. So I do have that available.
We would like to present that to the court in the next slide.
Yes, sir.
This gets to our objection that I mentioned was going to be coming.
Okay.
Expert disclosures were months ago. Expert depositions have already happened. The table they'd like to put up was not included in the expert report. We didn't have a chance to have our rebuttal expert examine it to make sure it accurately reflects what it should, and we were never able to cross-examine Dr. Baumgartner about that table.
Okay.
And so we just think it's unfair surprise and outside scope issue.
Okay.
Your Honors, all of the information is in Dr. Baumgartner's report. It was in the appendices. As Dr. Baumgartner said, all of these charts are just visual representations and demonstratives of the data that was already there, that defense counsel had access to, and in the appendices before deposition. And Mr. Haley took Dr. Baumgartner's deposition and asked him about information in those appendices, so he had full access to it the entire time. And they have full opportunity to cross-examine Dr. Baumgartner here today on that information as well.
I'm sorry, repeat that last part.
And defense counsel has full opportunity to cross-examine Dr. Baumgartner on that information as well. And again, this is all already in his report in the appendices.
Okay, could you repeat your objection again?
Yes.
Please,
so,
okay.
Everything, with the Supreme Court argument last night, because of the difference, everything counsel just said is absolutely true. We had the numbers for category 2, we've cross-examined them on the numbers for category 2, none of that is untrue. What they'd like to put up is a visual representation. Now, I think what they're trying to show is one black bar is much taller than the other black bar. What we haven't been able to do is have our guy run the same table to see if the scale looks the same. Fundamentally, we trust Dr. Baumgartner, but at the same time, we're introducing new visual representations of trial that had not been introduced in this report, a report that, mind you, contains about 15 visual representations. We thought we had them surrounded. We had our expert look at them. We didn't have an issue with them. We didn't have access to this one in that same.
Your Honors, the state of law in Tennessee is clear that charts and summaries are allowed for expert opinions, especially when they are based on voluminous information, such as Dr. Baumgartner's report. If Dr. or Mr. Hill would like, we can have Dr. Baumgartner draw the information today in court, but I do believe that State v. Wiseman makes it clear that summary charts and demonstratives of expert information are admissible in court.
All right, so let me make sure we understand, Mr. Halo. So you received the report, which is dated May 26, 2025. And the information and the data that the chart contains was in the report. So this is not new data or new opinions. Your argument or your position is that the chart itself, the visual, was not produced in discovery.
Yes, and Your Honor,
Okay.
let me put a finer point.
Yes,
This table appears on page 10.
in the report, correct?
Right?
Yes.
We were able to hand this table to our expert, our rebuttal expert, and say, hey, here's the chart. Do one on your end to make sure it looks the same. Make sure the space between 10 and 8 is the same, and 6 and 8 is the same as 10 and 8. And we were able to confirm the visual accuracy of these charts. We agree that the Tennessee rules allow experts to summarize with charts. That's not what the issue is. The issue is when we should receive those charts. Our problem today is we should receive those charts as a part of the expert disclosure. They should not be popped on us the day of trial.
They were not popped on defense counsel on the day of trial. We provided these charts in advance of trial to counsel to make sure they had
When did
opportunity
you provide them?
last week when we exchanged exhibits.
In other words, post-disclosure, post our expert being able to engage with them.
But again, these charts are based on information that was already available to their expert, and he could have created charts of his own to compare.
How many other charts are there like this? In other words, the charts we've seen are in the report, but how many others are coming up that were last week given to them?
There's this one, and then there's 2 other graphic scatter plot representations.
All right.
Apologies, 1 more bar graph. Total 4.
And we will have the same objection to all 4. I mean, this is just, again, a report that contains this many. There's no reason why, if they thought these visual representations were important, that they wouldn't have included them in the report.
And when is your expert going to testify?
When?
Is your expert, the person who reviewed the chart, the report, going to testify?
We assume so, yes, Your Honor.
All right, and when do you anticipate that will occur? Today, tomorrow, or?
Our case probably won't open until Thursday, if I'm understanding their timetable.
Okay. All right, well, the court, when we consider these types of issues, we certainly look at the prejudice and the timeliness that the documents have been provided, but more importantly, the prejudice that it would result to your client. What the court is inclined to do is to take this under advisement. Now, Dr. Baumgartner's not going to be available, but if we took it under advisement, we could let your expert look at it. We certainly don't want to prejudice the state, but if this is just a simple diagram of numbers that have already been provided, an expert could look at this chart in 15 seconds and tell that it's accurate based on what's in the report. So again, we haven't seen the visual, but assuming that the numbers represent what's already been provided and it's a simple visual, that would not be very difficult for your expert to review and say, yes, it's accurate or it's not accurate. So we can afford your expert that opportunity. The question would then be, if Dr. Baumgartner is not here, how would we get it in? So what I'm inclined to do is to mark it for ID. We won't look at it. Let your expert review it. And then if you believe that it's either prejudicial or that it's not an accurate depiction of what has already been provided, then the court can make a ruling at that point. So I think that's what we should do, mark it for ID, and then we'll let you make an offer of proof through Dr. Baumgartner before he leaves. Does that make sense? So let me just repeat that, because that was, okay. So, mark it for ID only. When we complete Dr. Baumgartner's testimony, let him make an offer of proof. Let your expert review it, and if you have an objection at that time, then the panel, the judges can take it up. And if it's not an accurate depiction, we will probably sustain the objection. However, if it is an accurate depiction, then we will probably overrule the objection. But we want to make sure that it's not prejudicial to you.
And Your Honor, I do want to be clear. We think the numbers underlying the chart, we're not saying we have an issue with those.
Okay.
It's just the visual representation. And much like my objection to leading on his qualifications wasn't substantively the most important thing for this case, this is coming 4 more times, and we may care more about the next set of charts than this one. And so I don't want to make a big deal out of it.
Well, now I'm a little bit confused, because if it's an accurate depiction of what's already been presented in terms of the number, what is it about the chart itself that is objectionable? I mean, I know that it wasn't presented, so that's a reasonable objection. I'm not saying that that's not, but in terms of the substance of the document, why should the judges not see it?
I hope this makes you smile and not hit me, but I'm one of those belt and suspenders lawyers.
Okay.
And I am literally the person that sends this to the expert and says, make sure nothing's exaggerated here and the spacing's right, produce the same chart. Let's make sure they didn't make one black bar artificially look a little bit bigger.
Okay. Well, then let's follow the procedure that yes, and I really appreciate that. Let's follow the procedure that the court has outlined so that you can have your expert look at it, and then if it's a problem, then we'll go from there, okay?
Thank you.
All right, very good. So let's go ahead and mark it for ID only, and then we'll pass it back. Officer, if you'll pass it back to counsel. It'll be 39 for ID. And if it's for ID, you don't pass it to us or Mr. Emily, just mark it 39 for ID.
I believe it's 40, Your Honor.
40? 40, okay, 40 for ID. Did I
No,
miss
I think it was 39.
Okay, I have 39.
I show it should be 39.
Oh, okay.
Yep, 39.
Okay.
Okay, all right, so 40.
Thank you.
And I learned from our honorable former Judge Jerry Stokes, when we mark documents for ID, I tend to give them back to the attorneys, because I had one case, it was a wrongful death, jury trial, we concluded it, and there were 3 exhibits that were marked for ID. And when we sent them back to the jury, the ID documents, exhibits got mixed in with the admitted exhibits. It was a defense verdict, and of course, we had a motion for mistrial, polled the jury, the documents were in there, and they were very prejudicial documents. This was a wrongful death, and there were a lot of photos and things that, so, you know, I was a new judge at that point, and Judge Stokes was my mentor, and he said, you know, in the future, he says, what I do is just, you know, I mark them, and I give it back to the attorneys. That way I don't have to worry about them getting mixed in. So that's been my practice ever since. So we'll let you hold on to that, and then if it, you know, if and when we admit it, you just tender it back to the court at
Thank
that
you.
time. Okay, very good. All right, let's move on.
It's been about an hour and a half. Do you mind if we take a brief recess, Your Honors?
That's fine, yes ma'am. Why don't we take a 10-minute recess?
All rise. Court will be at recess. Legacy.
All right, we'll see you back in 10 minutes.
back in session. You may be seated.
All right, thank you. All right, we hope everyone had a good break. We're going to go ahead and resume. Mr. Baumgartner, please come forward. You may proceed, Ms. Rashiba. Yes.
Which is figure 3 from Dr. Baumgartner's report. Back one more second, sorry. Go back. There we go. And we would like to move this into evidence, a larger version of this graphic.
All right, any objection? Okay, thank you. Is it 40 or 41?
40.
All right, thank you. Okay, 40 was marked for ID only, Judge.
So it's ID only?
No, 40 was marked for
Oh.
ID. This is 41.
41.
Yes,
Thank
so we're missing 40.
Okay.
Dr. Baumgartner, what does this figure show?
Figure 3 that's displayed on the screen shows the degree to which white and black people are over or underrepresented as a share of those who are disenfranchised. Again, it derives from the numbers that are in Table 2. And so I could walk through how we calculate those numbers. But if you recall, in Table 2, white individuals in Category 1, they're 72% of the population, but they're 60.6% of the disenfranchised in Category 1. Those numbers are in Table 2. So if the justices look simultaneously at Table 2 and this figure, you'll see that if you divide 60 into 72.5, you see that that is 84% of the population share. So the disenfranchisement rate for whites is 0.84 times their population share. For blacks, it's 36% compared to 16.5%. So they are overrepresented by a factor of 2.2. And that's what's displayed here in this figure. It's another way of graphically presenting to the court.
Could you adjust your mic for us, please? Thank you.
It's another way of graphically presenting to the court the numbers that are presented in Table 2. And it includes Category 1, Category 2, and Category 3. But I understand now that Category 3 is no longer relevant.
And what does the dotted line represent, Dr. Baumgartner?
The dotted line is at 1.0, which would be racial equity. If there were the same share of whites and blacks who were disenfranchised as they represent in the population, then when we divide the share of whites who are disenfranchised by the share of whites who are in the population, we would get a number of 1.0. And when we divide the share of blacks who are disenfranchised by their share of the population, we will get a number of 1.0. So 1.0 would be the shares are equal to the population share. So a number higher than 1 is that that group is overrepresented, and a number below 1 is that that group is underrepresented. So it's a very simple presentation. You can see that consistently, no matter which category we look at, we find similar results. A dramatic overrepresentation of blacks and a substantial underrepresentation of whites.
And before we move on to the next slide, I would like to address Judge Tidwell's question from earlier about jury trial rates. If we could turn back to Table 1 in Dr. Baumgartner's report.
Is that figure 1, the pie chart?
Table 1, the jury trial rates. And earlier, Judge Tidwell, you had asked a question about the time frame that was being analyzed here. Dr. Baumgartner, can you tell us what time frame or year this table is from?
I'm reading from my report on page 5 of my report. It lays out that the National Center for State Courts provides caseload statistics and so on. It's available for, this is data from 2023. In the paragraph preceding that, the paragraph before, I also indicated a few sources in the literature that I found that present similar information for individual states at different times. So this is a cross-section of 2023.
Thank you, Dr. Baumgartner. Does that answer your question, Judge Tidwell?
Yes.
All right, now about Dr. Baumgartner, did you perform a county level analysis of disenfranchisement rates?
Yes, I did.
And what was the purpose of doing a county level analysis?
Well, as I mentioned earlier, I wanted to see whether the disparities that are so apparent in the statewide analysis could potentially have been explained by a particular pocket or geographical area of the state that had a high disparity, whereas other areas might not. So I looked county by county. The data that I received from the State Department of Corrections indicated the county of conviction. And of course, the census data by county are available. So it was a simple matter to look at the 95 counties and see whether the patterns were consistent across the different counties.
And now if we look at figure 4 from Dr. Baumgartner's report, we'll enter this into evidence. It should be exhibit 42.
Exhibit 42. Any objection?
Sorry, Your Honor.
Okay, thank you.
Now, Dr. Baumgartner, to confirm, all of the data represented in this graphic is available in the appendices to your report?
Yes, it is.
And if somebody wanted to look up Shelby County to see what the exact disenfranchisement rates were, where could they look?
Well, I would point the justices to Appendix B, and the first table, Appendix B1, which starts on page 31 of my report, lays out the actual numbers, the population size, the black and white population, as well as Hispanic and other, and then the number of individuals who are disenfranchised. That's laid out in Table B1. It's a very wide table. It has a lot of columns. So in the next table, Table B2, I derived the rates. And the rates are what are shown in the figure in front of us on the screen. And the rates themselves are laid out in Table B2, which is on page 35 of my report. But just to clarify for the court, the numbers on which the rates are based are all available in the previous table, Table B1. So the raw numbers are in Table B1, and then the rates, simple percentages, are presented in Table B1. B2 is the rates. B1 is the numbers. So if we wanted to look at Shelby County, we could go to page 36, and we would see that the total rate is 5.69. The white rate is 2.47. The black rate is 8.87. And the ratio of those two rates, the black rate divided by the white rate, is 3.59.
I'm sorry, what page are you on?
I'm on page 36 of my report.
Okay, 36. Okay. Starts on 35?
Yes, Table B2, and when we get down to Shelby County, the counties are listed alphabetically. So when we get to Shelby, we can see the rates, total, white, black, Hispanic, other, and then the black-white ratio is the last column. and that number for Shelby is 3.59.
Thank you, Dr. Baumgartner. So Dr. Baumgartner, turning back to figure 4, what does this figure show?
Figure 4, again, derives from the numbers that are presented in Table B2. Every county is represented in the figure as a dot. On the x-axis, the horizontal axis at the bottom of the figure, is the rate at which white people are disenfranchised as a share of their population. So you can see at the bottom, I believe that's Wayne County, has a white rate. Wayne County is labeled in the figure. The rate of disenfranchising whites is roughly 7%. And if we look in the table, we'll see that number. And then Wayne County disenfranchises blacks at a rate, just eyeballing from the figure, you can see that the rate of disenfranchising blacks is approximately 4%, roughly. And that exact number is in the table. So the black line, so the white rate is displayed on the horizontal axis, and on the vertical axis, or the y-axis, is the rate of disenfranchising black Tennesseans. That rate extends in some counties to over 20% of the black population being disenfranchised, with a maximum value of just over 30%. Those numbers are all laid out in Table B2. The black line in the figure on the screen represents equality. The black line is the 45-degree line that represents the 1-to-1 ratio. The red line represents what we call the best fit, the regression line. That's the line that travels through the center of all the dots with an equal number of dots on the left and an equal number on the right. So it's the regression line, and the equation for that line is 2.88. It's laid out in the figure. The black rate equals 2.88 times the white rate when we look at the numbers county by county. So you can see, the justices can see, and you can verify in Table B2 that there are 4 counties out of the 95 counties below the black line. That means that there are 4 counties that disenfranchise whites at a higher rate than they disenfranchise blacks, including Wayne County, the one that I started with the illustration. On the other hand, there are 91 counties out of 95 that appear above the black line. And when we look at the general pattern of how high is the black rate on average compared to the white rate, that follows the red line that's laid out in the graph. And the 2.88 calculation is quite similar to the 2.6 ratio that we observe when we look at the entire state population. So when we break it down county by county, we observe that the pattern that was present in the statewide numbers is generally replicated county by county. 91 of the 95 counties have a rate that's higher for blacks than for whites. And you can see just by glancing at the county, at the figure, that there's quite a number of counties that disenfranchise more than 15 or 20% of the black population, even though the average, you remember from Table 1 or 2 or 3, is 10% of the black population is disenfranchised statewide. But there are not an insignificant number of counties, quite a substantial number, where that rate is 15 or 20% or more. There is no county in the state that disenfranchises more than 10% of the white population. But the majority of counties disenfranchise more than that rate for blacks. So there's no rate. The majority of counties in the state disenfranchise more blacks than any county disenfranchises whites.
I'm sorry, repeat that again?
the majority of counties in the state of Tennessee disenfranchise more black people as a share of the population than any county in the state disenfranchises white people. And you can see that yourselves from looking at the graph, and you can verify it in the table, table B2. There is no dot on the white rate further than 10%, indicating that the maximum rate of disenfranchising whites is less than 10%. But if you look at the vertical axis, there are many dots appearing representing most of the counties in the state that disenfranchise more than 10% of the black population.
And Dr. Baumgartner, as a clarification, the TDOC data that you received, did it contain county of residence for the felony records?
The TDOC data that I had is county of conviction. So it is important to recognize there could be some slight movement in some of these counties. Somebody might live in one county and have a conviction in a neighboring county or in a different county entirely, and vice versa. Some might have the county have been convicted elsewhere. Some may have traveled into the county and been convicted. So if we had the residence rather than the county of conviction, some of the dots might move slightly.
Based on your experience in the field, would that difference have an impact on your opinions?
Based on my experience, it would likely have a very marginal, substantively insignificant effect, but it would move the numbers. It would move the dots slightly to the left or right, up or down, ever so slightly. But in my experience, it would be a minor adjustment.
Would the patterns remain consistent?
The patterns are likely, very, very highly likely to remain consistent, although some of the dots might move in one direction or another. But I would add that if one dot moved to the left, another dot would move to the right. If one moved down, another would move up. They would be, there's no reason to even think that they would all move in the same direction. Some would move in one direction, some would move in another direction. So the precise placement of the points, the precise rates that we might calculate for each county, yes, they might differ a little bit, but the pattern is very likely to remain the same.
Thank you, Dr. Baumgartner. So to confirm, is this for state or for total disenfranchisement rates, this graphic that we're looking at?
This graph is for category 1, and that's the one that's reported that's included in my report.
If you were to draw a similar graph for category 2 for permanent disenfranchisement, what would that look like?
Well, I could tell you exactly what it would look like because I have calculated that exact same presentation.
Your Honors,
Yep.
this is going to be that same objection, and in fact, this one's different, and this is why it was different than just the black bars. This is no longer a representation of numbers in the report. This is now him doing a separate regression analysis and a separate calculation, and then putting that into a chart for category 2. So this isn't as simple as plugging in numbers. Actual analysis was done to create the next chart he's talking about.
Your Honors, Dr. Baumgartner has already done that regression analysis, but I'll withdraw the question and ask a different one. Dr. Baumgartner, if you were to plot the dots for category 2, where would you expect the dots to go?
Well,
Same objection. We have no idea where he would put them because they're not in a report, and we haven't been able to cross-examine him about this, and that's why.
I'll withdraw the question and re-ask.
Okay.
Based on the numbers in your appendices, Dr. Baumgartner, where would the dots go?
well,
All right, so if we could drill down based on the numbers of the appendices and what dots she's referring to, I may be able to formulate what the objection
Okay.
is.
Counsel, what appendices are you referring to?
Appendix C1, Your Honor.
C1 is on page 38. And can you tell us what C1 is, Dr. Baumgartner, please? What C1 is?
Yes, absolutely. C1 is the identical table as table B2, except that table C1 displays the rates of disenfranchisement by race for those who are permanently disenfranchised. That is referred to as category 2 in my report. So it's the same data as is presented on the screen for category 1 and is presented in appendix table B2 that you were just referring to, I think. And so table C2 presents the same presentation for that limited category, in category 2, the permanent disenfranchised.
Okay, Mr. Halo, any objection to the
So
question now?
Yeah, I guess
Okay.
I'm wondering what the question is. So we obviously have rates by counties in this chart. Is council just asking where these rates would show up on an axis, an X and a Y axis?
Yes.
So, Your Honor, that's what's he going to say, 1/2 inch to the left and 1 inch up? I don't understand how it's an unanswerable question without the visual.
Well, I think it's answerable, so I'm going to overrule
Okay.
the objection. Okay.
You can answer, Dr. Baumgartner.
Could you restate the question?
Sure. Based on the numbers in the appendix, what would the dots look like on the chart, on a similar graph?
Well, if you look at appendix table C2, you will see, and recall that in
C1, I believe.
C1, I'm sorry, and if you look also at table B1, the population sizes and the number of white and black people who are residents of the different counties are laid out in appendix table B1. And then we get to those 13,000 people who are disenfranchised in category 2. These numbers, you recall, I mean, you can see from table C2, they tend to be quite low numbers.
C1.
They're table C1, I apologize. They tend to be relatively low numbers, 1/10 of 1%, 1/2 of 1%, goes up to a maximum just over 2% of the population, the black population is disenfranchised in, I think, one county. When we present it in a graphical form similar to the form that's on the screen, the scales differ because it doesn't go all the way to 30%. It only goes up to 2.5%. The figure looks identical, almost. There are a number of counties, I think 5 or 6 counties, that have 0% of blacks permanently disenfranchised. So there's a cluster of points right along the bottom x-axis with 0. So there are a few more counties that show that are below the black line. But the general pattern looks very similar to what we see here, and the correlation or the steepness of the share of blacks who are disenfranchised compared to the share of whites is even more stark than what's laid out in the figure in front of you. So it looks very similar. All the numbers are dramatically lower, and all those numbers are laid out in appendix table C1.
Thank you, Dr. Baumgartner. Your Honors, we would like to mark for ID it's labeled as Plaintiff's Exhibit 249, but we'll be marking it as Exhibit 44 for ID, 43 for ID.
Okay.
Actually, we would like to move it into evidence, Your Honor.
So you want to mark it at 43?
So this is
Okay.
same objection, not
Same
provided.
objection?
Yeah.
Okay.
Actually, let me add to this objection, because again,
Okay.
this one includes actual analysis. This is not as simple as black bars that are easy to scale. This includes a regression analysis, which, for the love of God,
So
I've
it
tried
was
to
not
figure out.
provided to you or your expert? Is that, could you restate the whole objection, so?
Yeah,
Okay, yes,
so
sir.
this includes actual analysis and opinion that was never provided to us. It's not just a graphical representation of things that were. Second, it wasn't provided to us, even if it weren't all of those other things.
It was not,
Yeah, it was not.
okay.
It was a week ago, sorry. It was
A
not
week
prior to
ago.
the disclosure.
Okay.
And it was provided, and we would add that it's based off of the numbers that are all contained in C1 in the appendix to Dr. Baumgartner's report, which defense counsel has had.
Okay, so when you say it's an analysis, a new analysis, is it taking the data and the numbers out of the report and putting them on a chart, or is it a whole new set of numbers and an analysis?
Putting
So-
them on a graph.
No, we disagree fundamentally. On the black bars that we had earlier, it was a matter of you took one number, you put it at the bottom of one bar, you took another number, you put it on the bottom of one bar, you had an X and Y axis, and they went up so high. That's easy. I can do that. What I can't do by hand is a regression analysis. That red line, to do by hand, when I was in college, would have taken me 3 hours of math. Now I have calculators that can do it, sure. But that's what makes him a statistics expert. It's things that you and I can't do. And that wasn't provided to us. And she can say it was derived from the information. Every expert report is derived from some information, but it's applying his expertise to that information. That's the thing that we couldn't do without. And that's what that red line represents.
And
Okay.
we would say that every single dot that's on the graph, all that information is provided within the appendix.
Which
And
appendix is that?
C1, Your Honor.
Okay, C1. All right, well, let's mark it for ID. And this graph, if it looks like exhibit number 42, is a little bit more complex than I think it was the exhibit, was it 30 not? No, it was 40 for ID. So we'll apply the same rule. We'll mark it for ID, and then we'll let your expert look at it. And then we'll come back and revisit that objection. Okay? Okay, thank you. All right, so let's mark it for ID and give it back to counsel.
And we have one more, Your Honor, to mark
Okay,
for
have you received it back?
ID.
Okay, all right. And that was gonna be 43 for ID. Let me just write that down. Okay. All right.
We have one more that we would like to enter into evidence, Your Honor.
All right, has counsel seen it?
I'm looking at it right now.
Okay.
Which does this coincide with in the report?
It's also from C1.
It's one of the ones we sent you last week.
Yeah, so, Your Honor, this fits, and I'll show it generally. See that red line? You've now got dots with sizes to them. They are correct in that any statistics expert with the subset of information that was in this report could have come up with this. I will tell you, as someone who took several statistics classes, I couldn't. And I think a layperson couldn't, and that's his expertise. This is another analysis that just wasn't done by the disclosure deadline. We got this for the first time a week ago. And so this is different, again, than those two black bars. This is new analysis. This is a new opinion of an expert, just like the last one was. And I'm not even sure marking for identification is the appropriate thing here, because this isn't about our guy checking to see if it's right. This is about whether their guy gets to have new opinions at trial. Both these last two things are new analysis, new opinions.
Well, I guess you could analyze raw data and statistics in many different ways. So now we're talking about a regression analysis, and I do understand a little bit about regression analysis. But is this, without the diagram, would there be an objection to Dr. Baumgartner testifying about his opinion in terms of what these numbers represent? Because unless there's an objection to that opinion being a new opinion, then I'm having difficulty understanding how the chart would be a new opinion. I certainly agree that your expert should have a chance to look at the chart, but in terms of you suggesting that it's a new opinion, what do you say to that, counsel? Is it a new opinion if the data is analyzed in terms of the regression analysis?
We do not believe it's a new opinion, Your Honor.
In terms of which counties are gonna be, if this solid line is the line of equality?
Yep, the black line is the line of
Okay.
equality.
And the majority of counties, assuming that the opinion is gonna be that the majority of counties are gonna fall on the red line above that line of equality.
Correct.
There's gonna be some counties that are gonna fall below the line. Is that a new opinion in terms of category 2, which is the 13,000 individuals in Tennessee who have been permanently disenfranchised? Is that a new opinion?
No, Your Honor, it is
Is
not.
that a new analysis?
We believe it's not a new analysis.
Okay. Mr. Hilo, what do you say? Is it a new opinion? Is it a new analysis?
I will tell you that I have read his report numerous times. Here's what his report says.
I'm sorry, if you could just answer
Yeah,
that question
it's
first.
It's new opinion, new analysis.
Okay.
It just fundamentally, if I can get into the weeds, a regression analysis requires an assumed error rate. It requires setting a dependent variable and an independent variable. These are all assumptions that go into doing it. The assumptions aren't even listed here. I don't see an error rate here.
Well, isn't that a basis for cross-examination?
And it would have been in a deposition if he had disclosed it prior to the disclosure deadline. There's a reason we have these deadlines. And to pop it on us a week before trial and then show up to trial and pretend it's authoritative, when I haven't had the chance to, it's new.
Authoritative? What do you?
It's coming from a guy with a PhD. That makes us all think it's correct.
It's not authoritative, it's an opinion. So the judges will assess the witnesses, in terms of the guidelines that we have. The opinion, his qualifications, his experience, the facts upon which he relied upon to formulate that opinion, and whether the methods and sources are tested. I mean, those are the things that we look at. So, no, nothing that we hear in a trial is authoritative.
Understood.
So I do take a little bit of issue with that.
Understood. Use the wrong word. I'm
Okay.
sorry about that.
Right.
But there's got to be a reason we set disclosure deadlines for opinions. It's so we can have them.
Right.
We can depose him about them. I could have asked about error rate. I could have asked dependent versus independent variables. I could have asked about all the underlying assumptions. As it stands here today, I'm going to be sitting at trial for the first time wondering, do I ask him? Does it make me look worse? Does it make me look better? Is there a hole? Is there not a hole? Our case should have been prepared prior to today. And I'm being asked to do it on the fly.
Well, I mean, this is just how trials go. Sometimes trials just don't go perfectly, and that's why we have a procedure to follow, and we have rules of evidence. So the court is trying to assess whether or not this evidence should come in as an exhibit.
And Your
So
Honor,
I understand that we have deadlines and disclosures and things of that nature, but very seldom do we have a perfect trial where, all of these things are resolved on the front end. So again, explain, counsel, I think the burden is on you if you want to get this document in, why you contend that it is not a new analysis or a new opinion.
Yes, Your Honor. So all of the data is already in Dr. Baumgartner's report in Table C1. We provided these 4 new charts to opposing counsel a week ago, and it would have taken their expert 30 minutes to validate
But in
them.
terms of extrapolating the opinion from that data, has Dr. Baumgartner already done that in terms of a regression analysis?
In
We
ter-
understand that there's data,
Mhm.
and you can look at data many, many, many different ways, but in terms of the opinion that he's going to give, in terms of what that data represents and putting it on this chart, has he given that opinion?
Only the red line would be entirely new. The rest of the data and analytics are already in the report. And it's just a visual representation with the dots. What if we delete the red line, would that be acceptable to opposing counsel?
So by deleting the red line, does that eliminate the regression analysis and it just plots the numbers?
Correct.
All right, would there be any objection to that, counsel?
I guess not. I mean,
Okay.
it would go under the same objection as before for the proffer without the new opinion overlay.
I'm sorry, repeat that again?
It would go to the same objection as the 2 black bars without the new opinion overlay. In other words, we would just need to confirm this was an accurate representation of the numbers.
Okay. All right, so if what I'm hearing is that There was no opinion ever offered by Dr. Baumgartner regarding regression analysis, either in his report, his disclosures, his deposition. Even though the data was provided, then I will sustain the objection with regard to giving an opinion regarding the regression. And then we'll apply the same rule for exhibit number 43. We'll remove the regression line and we'll just allow your expert to review that document. And if they agree that the numbers are plotted correctly, then we'll come back and revisit it.
Thank you, Your Honor.
All right, very good. So let's go ahead and mark it as 44. It's gonna be 44? Yes, 44 for ID. And that's gonna be a revised, it's gonna be a revised, counsel? It's gonna be a revised document. Okay.
To the next slide, please. And this is going to be figure 6, I believe, from Dr. Baumgartner's report.
Okay. 6. What page would that be?
And we'll, I'm so sorry. Page 17 of Dr. Baumgartner's report. And we will introduce this figure into evidence as a standalone document. Exhibit 45.
All right,
And-
any objection? All right, thank you.
All right, Dr. Baumgartner, can you talk us through what this figure represents?
Yes, this figure is another way of presenting the information that was in the scatter plot that we were just discussing. The numbers in this figure are all presented in table B2 in the appendix, and it's simply a presentation of the ratio, which is the last column in table B2, the degree to which the black rate is greater than the white rate presented as a ratio. You'll recall that on the scatter plot, there were 4 counties where the ratio was below 1. Those are the 4 counties that disenfranchise more whites as a percent than they do blacks. Those are the 4 counties that were listed below the black line of equality in the previous scatter plot. Those counties are listed at the top. They appear at the top of this in this presentation, because this presentation presents the ratio of the black rate compared to the white rate. The black line, the vertical line in this plot, represents the ratio of 1.0, or racial equality, and you can see the 4 counties at the top are below that. They have a value below 1.0. 91 counties have a value greater than 1.0. And you can see that the vast majority of the counties have values 2, 3, 4, or greater. One county has quite a substantial number, approximately 9. I would urge the court not to pay too much attention to the outlier counties, because many of the outlier counties, the ones with very low rates or very high ratios, are the smaller counties. You should look at the bulk of the counties. And in the table, you can look at Shelby County, Rutherford, Knox, Davidson counties. We can look at those numbers in the table, in appendix table B2. And then for the permanently disenfranchised, which would be next, you can look at the table C1. So this represents the ratio, the degree to which the rate is higher for blacks than whites across the counties. And you can see that it, except for 4 examples, 91 of them are above 1, and it tends to be pretty high numbers.
So, Dr. Baumgartner, in layman's terms, when you say 91 counties are above the 1.0 line, what does that mean?
It means that 91 of the 95 counties in the state disenfranchise the higher share of their black population than they do whites.
And Dr. Baumgartner, do you know the 4 most populous counties in Tennessee?
Yes, they are listed in table B1. The population size of all the counties is listed in table B1. And so if we look at table B1, I think we'll see that Shelby County is the largest county by population in Tennessee. And if we look at table B2, we could see the rates for Shelby County. And similarly, we can look at any of the counties that we prefer.
And Troy, likely. Dr. Baumgartner, are these the 4 most populous counties based on the information that is contained in your appendix?
Yes, we can look right now in appendix table B1. Shelby County in table B1 on page 33 is listed with a population of 930,000 and some residents. If we continue to table B2, we can see what is the ratio of disenfranchisement for Shelby County. It is 3.59. Shelby County disenfranchises 2.47% of whites. I'm reading from table B2, and 8.87% of blacks.
I'm sorry, let me take a look at that. What page is that?
It's table B2, page 36. Shelby County. The overall rate is 5.69, which is made up of 2.47 for whites, 8.87 for blacks, and if you go to the last column, the ratio, the black rate divided by the white rate, is 3.59.
Dr. Baumgartner, in layman's terms, what does that mean?
Black people have almost 4 times the rate of disenfranchisement in Shelby County compared to white people.
And what is the pattern across the 4 most populous counties with regard to disenfranchisement of race?
The statewide rate is 2.6, but the largest counties all have even higher rates than the statewide average. Davidson County has a rate of 3, Knox County has a rate of 4.6, Hamilton County has a rate of 3.4. So the disparities that we're observing are not due to a few outlier small counties with small populations and potentially erratic statistics based on small numbers. The largest counties in the state have even higher than average ratios of disparity by race.
And these are 2023 numbers.
These numbers relate to what was provided by the Department of Corrections.
I mean,
These are the 2023 numbers that you might be asking about. That was the rate of jury trials.
I'm asking total population. My
Oh,
understanding is Rutherford County is now the 4th most populous. And so I'm just wondering, what is the population when you say the fourth most populous, what year would that be?
I'm just trying to see in my report
Sure.
the right page, so excuse me for a second.
Take your time.
If I might offer some guidance to the court. Dr. Baumgartner, is this based on the 2020 census? What is this based on?
Sustain.
We'll let him find it. Go ahead.
On page 6 of my report, where it says statewide results, it indicates according to the 2020 census.
2020. Okay, thank you.
Did you say 2020 census?
Yeah. So you can look, Rutherford County is also included in the table, of course, and so the numbers are presented there.
Does that answer your question, Your Honor?
It does. I wanted Rutherford County to get credit for over here.
And Dr. Baumgartner, let's look at Rutherford County, and we can look at the ratio.
I've looked at it.
Congratulations, Your Honor. It's only 2.17.
Thank you, Dr. Baumgartner.
Huh? Oh, yeah. That's good.
And Dr. Baumgartner, again, this was the ratios for, was this the ratios for total disenfranchisement across the state?
The ratios that are on the screen right now relate to category 1, all people disenfranchised, the 323,000.
Dr. Baumgartner, what would those ratios be for category 2 for permanent disenfranchisement based on the numbers in your appendices?
In table C1, it lays out those ratios county by county. So we can look at Davidson County, the ratio is 3.95. I'm just going alphabetically. In Knox County, it's 6.28. In Rutherford County, it's 2.13. In Shelby County, it's 5.9. I think I skipped Hamilton, so let me find that. .29 as a ratio in Hamilton County.
And Dr.
So the ratios in these, and for category 2, the permanent disenfranchisement in the largest counties of the state are even higher on average than the ones presented on the screen.
I'm sorry, can you remind us what is the statewide permanent disenfranchisement ratio?
The ratio for category 2 is 3.2. So these numbers are higher than the state average.
And again, what does that mean in layman's terms?
Statewide, as I said before, black Tennesseans are 3 times as likely, more than 3 times as likely as whites to be disenfranchised permanently. And in the largest counties of the state, those ratios are 5 and 6. So 5 and 6 times as likely for a black person in the largest counties to be disenfranchised on a permanent basis.
Thank you, Dr. Baumgartner. Are there objections to the next slides? And Your Honors, we're going to move another exhibit into evidence, which is going to be the same depiction, but for category 2, and we anticipate it will fall into the same category as needing to be marked for ID.
Sorry, what was the last part?
We anticipate it will have an objection and need to be moved into the same category as marked for ID.
Okay, same type of chart? Same type of chart?
Same type of chart as the one on the
Any objections?
screen, yes.
So it is the first objection. In other words, we're not saying new analysis, new opinion. We're saying we just never got this and
Okay,
we just need a
let's
chance
go
to.
and mark it for ID only. That will be exhibit number 46, ID
Mhm.
All right, so we have 4 for ID at this point,
That'd be,
40,
5
43.
are including yesterday, 32 Friday.
We had 32 yesterday?
Yes, yes, Your Honor.
Okay, 32, 40, 43, 44, 45. All right, thank you.
And 46, I believe. Oh, sorry, apologies, not 45, 46.
Oh, okay, thank you for correcting that, 46, you're right, 46.
Are there objections in the next one? The summary slide.
Oh, yeah, that's fine.
Right. All right, and we can move to the next slide, please. Now, Dr. Baumgartner, for total disenfranchisement across the state of Tennessee, what were your findings based on your analysis?
Well, in, I think it was table 3, I presented 2.6 is the ratio of the black disenfranchisement rate compared to the white rate. So black Tennesseans are disenfranchised at more than 2.5 times the rate of whites.
What were the patterns across the counties that you found?
Virtually ubiquitous. 91 of the 95 counties disenfranchise blacks more than whites at a higher rate, I should say. And a large share of those counties disenfranchise blacks at a rate higher than any county disenfranchises whites. In fact, that number is 79 of the 95 counties disenfranchise more than 10% of the black population, and no county disenfranchises that percent of whites. There are 17 counties where 20% or more of the black population is disenfranchised.
And what does that mean in plain terms?
A lot of black people are disenfranchised.
I'm sorry, so.
And how many?
I just want to make sure I understand. So bullet point number 4, when you say 17 counties, that 1 in 5 represents 20%?
Yes, 1 in 5 is 20%. You'll recall from the scatter plot that we presented that there were a number of counties at the high left end of that scatter plot. Those would be the 17 counties where more than 20% are disenfranchised. More than 20% of the black population is disenfranchised. And of course, no county disenfranchises even as much as 10% of the white population. So that's quite a substantial disparity.
And how did the patterns compare to permanent disenfranchisement and the analysis you did for permanent disenfranchisement?
When you compare the numbers that are in Table B2 with the numbers that are in Table C1, that is the permanent disenfranchisement, of course, as I said, all the numbers are much lower for the permanent disenfranchised group because it's only 13,000 people compared to 323,000 people. So it's still 13,000 people is a lot of people, but it's not as many as the 300,000 in the first category. The patterns are largely identical, even a little bit more extreme in category 2, 3.2 rather than 2.6 overall, and similar patterns geographically. So many counties have more than double the rate, triple the rate of disenfranchising blacks compared to whites on a permanent basis.
Thank you, Dr. Baumgartner. And quickly going over the third issue that plaintiffs asked you to analyze, what was that?
The third issue was whether these numbers are large enough to affect elections.
All right. And we would like to flip to the next slide, which will be what was pre-marked as Plaintiff's Exhibit 65. And this is an affidavit from Coordinator Goins that was submitted in a different case.
So, Your Honor, we object on hearsay grounds on this one. It's a declaration from another proceeding.
It's a party opponent statement. It was offered as an affidavit submitted by Coordinator Goins, the defendant in this matter, in a different proceeding.
And I thought that might be her response, and she's right.
All right, thank you.
Sorry.
It's okay.
And I would like to move this into evidence, Your Honors.
Okay, exhibit number 47.
Yes, Your Honor.
Thank you.
And what we have on the screen is a quote from page 4 of this document. Dr. Baumgartner, what are the vote margins listed in this quote?
Well, the first election that is mentioned in this quote is a tie, so the margin is 0.
I'm sorry, I'm confused. What are we referring to?
So page 4 of Coordinator Goins' affidavit in a different matter discusses.
Okay. All right.
And so, Dr. Baumgartner, in the elections discussed in this affidavit, what are the vote margins that you see named by Coordinator Goins?
I see first a tie, so a margin of 0. Next, in District 71, a margin of 4 votes.
And Dr. Baumgartner, apologies, can you say what election you're speaking about when you also discuss the margin?
I'll just read from the copy that was provided to me. In 2010, an election for judge.
Your Honors, I actually will object. The statement itself is probably admissible in this trial as evidence. As far as his expert opinion, this was not a cited source in his report. This was not something I would have had notice about cross-examining on in his report. And so, Your Honors, while his report does speak to some elections being close, it did not get the specific, it did not list the source. Couldn't have asked him questions about it. He shouldn't be able to testify about it today.
Your Honors, Dr. Baumgartner, we're simply providing an example for small margins, and that is relevant to his expertise and the analysis he did on margins of potential impact on elections based on felony disenfranchisement.
I'm sorry, could you repeat that again?
Apologies, yes.
Okay.
This is relevant just in that Dr. Baumgartner did an analysis on potential impact on elections of disenfranchised and permanently disenfranchised populations, and we are offering this as examples to compare to what the disenfranchisement numbers are in his analysis and whether the numbers that he analyzed could have an impact on elections in Tennessee, such as the ones emphasized here by Coordinator Goins.
And the objection is that Dr. Baumgartner's opinion was not based on this affidavit or these statements. Is that correct, counsel?
Yes, Your Honor, and in fact, as Dr. Baumgartner will remember, we had a back and forth about this exact issue for about an hour in his deposition. This source was not one of the sources I was prepared to question him about during that hour. We'll stipulate.
When you say not prepared to question him on, I'm a little bit, I don't understand that. Was it part of his disclosures or his opinion, or?
There you go.
Okay. He says no.
This document was not, but impact on elections was, and he has analyzed potential impact on elections in Tennessee, and elections in Tennessee.
It's a data set problem. This would be like if he analyzed felon disenfranchisement, but if he came with a new data set today, that wouldn't be allowable. This data is a new data set as it goes to the closeness of elections. That's why experts have to cite their sources so we can check them and depose them about them. And here we were not afforded that opportunity.
Your Honor, this is a statement by Coordinator Goins, and it's in evidence, the party opponent statement. It's not new data.
Okay, well, let's see.
Could she get this in through Commissioner Goins.
I will happily admit that halfway through my objection, I realized it was a bad one. This is admissible evidence, and Commissioner Goings would absolutely, it could come in through him.
So it's already in. The question I was more thinking about was whether or not the witness could give an opinion about it. So I was not inclined to unmark it, but I'm taking up the new objection, which is whether or not he can testify. So what do you think, Judge? It's already in evidence. He didn't object to it coming into evidence. Okay, so if Dr. Baumgartner did not use this in his analysis to give an opinion on the impact that his statistical analysis has on elections in Tennessee, if this was not a basis for that opinion, then the court is going to sustain the objection. But in terms of it being admitted, it was already admitted. So we could unadmit it and then have it coming through Mr. Goins, but it's already been admitted, so.
We don't need to admit it, the formality of having something allowed, something.
Okay, all right, but we will sustain the objection in terms of being able to answer questions about this document.
Baumgartner, based on the data you were provided, are there counties in Tennessee with more than 4 permanently disenfranchised individuals?
Objection, Your Honor, leading. They just put the answer on the screen for him.
I asked if there were counties with more than 4 permanently
I'm sorry,
disenfranchised individuals.
I'm having a hard time understanding you, counsel. Just, could you repeat that again?
Yes, Your Honor.
No, not you.
No,
When you
no.
turn away from the mic.
Apologies, Your
Yeah, okay.
My question was whether there were, based on the TDOC data that Dr. Baumgartner was provided and his analysis, are there counties where more than 4 individuals were permanently disenfranchised?
With all due respect, I want y'all to put your proof on both sides, but at this point, we've heard these same points over and over. If it's cumulative, I mean, I'm not ruling on it, she's ruling on it, but I would like to hear things we haven't heard thus far. And I get it by the 3rd time y'all say it.
Yes, Your Honor.
Okay, so, I'm sorry. Could you repeat the question again one more time?
I'll withdraw the question, Your Honor.
Okay, all right, thank you.
Dr. Baumgartner, just in general, what did you find in your analysis of election impact?
To the extent that elections are close, it's a mathematical fact that excluding thousands of people statewide and smaller numbers county by county or who are eligible in a particular jurisdiction could mathematically affect the outcome. And to the extent that the election is closer, that increases the likelihood that the exclusion of certain people could affect the outcome. To the extent that the election outcomes are landslides, then it would not affect the outcome, but to the extent that there are close elections, it increases the likelihood that these disenfranchisements could affect the outcome.
And Dr. Baumgartner, did you identify elections where the number of disenfranchised people is larger than the vote margin?
I did, in my report, identify a number of cases where the number of people disenfranchised was larger than the vote margin between the winner and the second place finisher.
Thank you, Dr. Baumgartner. No more questions, Your Honor.
Okay, all right, it's 12:10. Why don't we take a lunch break and then we'll come back for the cross-examination? All right, so we'll take, yeah, let's take an hour, okay? And we'll see you back at about 10 minutes after 1. Okay.
All rise.
you, officer. All right, welcome back, everyone. I believe Dr. Baumgartner was on the stand. Okay, and yes.
Just real quick before we moved on to cross-exam, Your Honor, we would like to admit a few more exhibits into evidence.
Okay,
There will be 5 that are straight from Dr. Baumgartner's report that have no objection.
5, okay. Are they gonna be individual exhibits?
Yes.
Okay, well, let's go ahead and pass those up. Is it gonna be 46?
I believe we're at 48, Your Honor.
48, okay.
So it'll be 48, which will be figure 5 from Dr. Baumgartner's report. And then there'll be plaintiff exhibits pre-marked 40, which will be 49 for trial exhibits, which is table 5 from Dr. Baumgartner's report. Pre-marked plaintiffs 42, which will be, I'm sorry, pre-marked plaintiffs 41, which will be exhibit 50 on the record, which is table 6 from Dr. Baumgartner's report. Pre-marked 42, which will be 51, trial exhibit, table 7 from Dr. Baumgartner's report. And then pre-marked 251, which will be exhibit 52, which is Dr. Baumgartner's CV. It's pre-marked 251.
Do you need stickers?
And then we have, and then we have one that will be admitted for ID, because we anticipate there will be objection. Sorry, I would move to admit it, but we anticipate it'll be marked for ID.
And what number is that? Will that be?
And that will be number 53.
Okay.
And this is the very basic visual objection, not new analysis objection.
I'm sorry, repeat that again, counsel.
It's the objection to being provided a chart right before trial and not prior to disclosure. We're not alleging there's any new analysis.
Okay, all right, let's mark that for ID.
Yep. And it, yeah,
53.
it'll be 53. It's pre-marked with the sticker 250, Plaintiff's Exhibit 250.
Okay. All right, we'll give that one back to you.
This one coming in? Gotcha.
All right, anything else, counsel? No? All right, you ready for cross-examination?
As ready as I will be, Your Honor.
Okay, all right, you go right ahead whenever you're ready.
Good afternoon, Dr. Baumgartner.
Good afternoon.
My name is Will Halou. We met during your deposition. I don't know if you remember.
Yes, I remember. Thank you.
I want to start with some fairly basic methodology questions. And the first is, you kept using the words temporary disenfranchisement and permanent disenfranchisement. Explain to me what you meant by those words.
Well, category 1 is all the people who have been disenfranchised. Category 2 is the people whose disenfranchisement shall be permanent. Some of the people in category 1 may have their franchise reinstated. That's what I mean by temporary.
Okay, and let me ask you if I could pass a copy of 40-20-112 to the witness. I'm not bringing it as an exhibit, just for the witness's sake. What I've handed you, Dr. Baumgartner, is a copy of Tennessee Code 40-20-112. Do you recognize that statute?
I recognize that it appears to be 40, 20, 112.
Have you ever read it before?
No.
Okay, well, now that I've put it in front of you, do you mind reading the first sentence aloud?
Objection, Your Honor. Will this call for a legal conclusion?
I think reading a statute requires no analysis or conclusion.
Okay, overruled.
Upon conviction for any felony, it shall be the judgment of the court that the defendant be infamous and be immediately disqualified from exercising the right of suffrage.
Do you see any temporal limitation to that?
Objection, Your Honor. The call is for a legal conclusion.
Your Honor, this witness has been qualified as a political science expert. As part of political science expertise, I'm sure he's reviewed statutes, I'm sure he can read them, and I'm sure he's got an opinion about what he thinks they say.
Well, he hasn't been qualified as a legal expert. Political science is different from legal, so does it not call for a conclusion in terms of what it means? Isn't that for us to determine what it means?
It is absolutely for you to determine what it means. I think
Okay.
asking him if he sees a time limitation in a sentence is not a legal conclusion. It's a simple identification of words.
Your
Counsel?
Honor, Mr. Haley was asking Dr. Baumgartner to interpret a statute, which does call for a legal conclusion.
So let me answer more clearly just so you can see where I'm going.
Okay,
Mr. Baumgartner has been asked to determine a population affected relevant to this lawsuit. I think we can all agree to that, whether it's felons or whether it's Tennesseans at large. And he's made judgment calls about what the denominator should be, what that population is. Now, Your Honors, what you heard us say in opening, and what I'm going to get to with Mr. Baumgartner, is we think for his analysis, he chose the wrong population. In fact, there is no such thing as permanent or temporary disenfranchisement. There are things
Well,
related
counsel,
to re-enfranchisement.
Counsel, sounds like you're testifying now,
Well-
so, okay. We'll take the testimony from the witnesses and the experts, but in terms of the objection, the question is, does it call for a legal conclusion? And if you could please restate your question, then maybe we'll better understand it.
Understood.
All right, thank you.
Do you see any temporal limitation to that disenfranchisement in the first sentence?
Objection, Your Honor. Calls for a legal conclusion.
I'm going to overrule the objection. I think he can answer that question.
In the sentence that I read, I don't see a issue of time.
Okay. Now, what I'd like to pass up that will be an exhibit is a collection of public acts. Each one will be a separate exhibit. I'm going to pass them all at the same time because I think that makes more sense.
Okay?
Here's your copy. So I think this one goes to him first, and these are for the judges. Oh, one's mine. And can we hand the marked copy to the exhibit, or to the witness?
All right, so let me just make sure we get these into, okay, so you're marking these as exhibits?
Each separately, yes, Your Honor.
Okay, would this be 54, 55, 56?
54, I believe.
Yeah, 54, 55, and 56, yes, Your
All
Honor.
right, thank you. Any objection?
Yes, Your Honor.
Okay.
Apologies. No objection to the exhibit.
Okay,
And can we pass the witness the numbered copy? Now, before we get to the actual exhibits, Dr. Baumgartner, let me ask you this. A re-enfranchisement scheme, a re-enfranchisement statute, would that apply to the public at large or only to disenfranchised people?
Objection, Your Honor. Calls for a legal conclusion.
repeat the question, please.
Would a re-enfranchisement statute apply to the public at large or only disenfranchised people? In other words, does the public at large have a need for re-enfranchisement, or is it only disenfranchised people that need to be re-enfranchised?
Counsel says it calls for a legal conclusion. Is it asking him to evaluate the legal effect or the intent of that statute?
I've not asked him about a
Okay.
single statute or
Okay.
statute
Help
number
us
or
understand.
interpretation of a statute.
Yes, sir. Help us understand what you're asking him, because it sounds like a question for a legal expert, but perhaps I'm not
Not at all.
Correct. Okay.
Honestly, it's a common sense question. If you haven't been disenfranchised, you can't possibly be subject to a reenfranchisement statute.
But in terms of the question, he's been designated as a political scientist, a statistician, and an expert to look at racial disparities and felony disenfranchisement. So he's not a lawyer, he's not a legal scholar.
No, ma'am.
So even though it may be a simple question for the proper witness, is he the proper witness to answer this question?
If he is an expert in felon disenfranchisement, I assume he should have an opinion on who reenfranchisement statutes apply to.
All right,
They
Counsel,
are
what do you say
part and
about that?
parcel.
Your Honor, we say that this calls for a legal conclusion, and it's a hypothetical about a statute that Dr. Baumgartner has not read, has not said he is an expert on, or has not been qualified as an expert on. He's not a lawyer, he's not a political analyst, and this is political.
Which
Political
statute are we,
analyst.
which
He is a-
statute are we dealing with? Which statute, Counsel?
We haven't even touched him yet.
It's a-
Okay, you have, so you're not asking him about a specific statute. What are you asking him about?
Generally speaking, is a reenfranchisement scheme applicable only to disenfranchised felons?
Okay, so is this a hypothetical?
No, it goes to the denominator used underlying his entire expert report.
I'm going to sustain the objection. If you want to ask a different question, but I'm going to sustain the objection because it sounds like it's calling for a legal conclusion.
I'm trying to understand what the legal conclusion is, because I'd like to not run afoul of that again.
I don't have to explain it.
Okay, understood. Let me ask this more basically. You've testified that black Tennesseans, by virtue of committing felonies, have been disenfranchised at a higher rate than white Tennesseans. Is that right?
With respect, it's been convicted of a felony, not committing a felony. In that sense, for the rest of it, it's correct.
Okay, so black Tennesseans are disenfranchised at a higher rate than white Tennesseans by virtue of being convicted of a felony. Is that right?
Because they've been convicted.
Okay. And so wouldn't any scheme that sought to reenfranchise that population have a more positive effect at a higher rate for black people than for white people?
I guess it depends on the scheme,
Tell me what it would depend upon.
the design of the scheme, and whether, for example, it applies to all felonies or only certain felonies. If it applied to all felonies that disenfranchised, then eliminating that would have the exact opposite effect of establishing it in the first place. So in that sense, it would be true, but I wasn't sure what scheme you're referring to.
Perfect. Let's be more specific. Tennessee scheme.
Objection, Your Honor. No foundation.
Your Honor, this witness just testified for 4 hours about Category 2 felons. He couldn't have possibly done that unless he had an opinion, and he called them permanently disenfranchised. Unless he had an opinion about what that was, he couldn't have had that testimony. And so it can't be okay when they need it and not okay when we need it.
Well, I'm trying to follow counsel, and let's just stick to one-word objections because the commentary is a little bit confusing at this point. So let's stick to the rules with regard to objections. One word, and then we'll give you a chance to reply. If we need an explanation, then okay. But all the commentary about what was allowed before or on direct examination, I think that that's inappropriate because it implies that we're applying different rules, and we're not applying different rules.
Oh, no, Your
So
Honor.
let's just focus on the question at hand, and that's the question before the court at this point, not what happened for 4 hours before.
And let me be clear, we didn't make this objection. I don't think the panel is applying different rules.
Well, I understand exactly what you said, and I just have a concern about the inference
I
that it may.
apologize then.
Okay, so, let's state the objection again.
The objection is that Mr. Haley had not established a foundation to ask Dr. Baumgartner about a specific scheme And he is welcome to ask Dr. Baumgartner about his methodology or the way he created category 2 in his report. But we don't believe that it's proper for him to ask about hypothetical statutory scheme or
Okay,
legal
can
issues.
you give me a one-word objection? What would be the?
Foundation.
Foundation, okay, thank you. Foundation, counsel.
And Your Honor, this is what I meant by the 4 hours. For 4 hours, they laid the foundation of this witness's knowledge of category 2 and permanently disenfranchising in Tennessee's scheme. If you'd like me to spend time relaying it, I can do that. I thought I could rely on the foundation that was laid this morning.
Well, I'm a little bit concerned, I'm a little bit in the dark about what scheme you're referring to too. So perhaps you should lay a foundation.
Okay.
Okay, thank you.
Dr. Baumgartner, you singled out category 2 crimes, is that right?
In my report, I analyzed category 1, all felons, category 2, which I referred to as those permanently disenfranchised, and then category 3, which, remember, we are not talking about.
And what informed your understanding of what category 2 was?
When I was first retained and learned about the case, I was asked to establish the 3 categories, and I was given the crime codes that corresponded to the 3 categories.
And what's your understanding of why you think category 2 is akin to permanent disenfranchisement?
My understanding is that the attorneys that brought me into the case explained that I should please analyze category 1, all people disenfranchised, a separate subset of those people who were referred to as those with permanent disenfranchisement, and a third category that we're not going to analyze today.
So you adopted their language without ever fully understanding what permanently disenfranchised meant?
I read and I laid out in the appendix to my report the crime codes and the time periods that caused a person to be in that category. So I did read through what those codes are, and I understand what the codes are. But I was told, and I believed the legal team, that this could be referred to as those with permanent disenfranchisement.
And you just took that at face value? You have no idea independently why those category of crime codes would be permanently disenfranchising?
I believed what was represented to me by the legal team, yes.
Okay. So with that, Your Honor, it sounds like he was informed by his legal team that this specific set of...
Is there a question on the floor? Why are you commenting?
I'm seeing if I've laid the foundation enough to ask the question. My question was objected to for foundation.
Okay, well, you can go back to the question.
Okay.
You don't have to give the commentary, so if there's a question, then there'll be an
Sure.
objection. Okay, all right, thank you.
So with that, Dr.
Okay.
Baumgartner, in your understanding of categories 1 and 2, all disenfranchised felons, the ones you refer to as permanently disenfranchised, a statute that re-enfranchises those, as a matter of math, would it not affect black Tennesseans positively at a higher rate as compared to white Tennesseans?
Objection, Your Honor. Vague and calls for legal conclusion.
Counsel?
I'm not sure what part was vague.
All right, would you explain that, please?
Dr. Baumgartner is not a lawyer. He would not know how any hypothetical reenfranchisement scheme would affect any felons in Tennessee.
Your Honor, what we've heard today is that Dr. Baumgartner is completely unaware independently of what Tennessee's
Okay, look,
reenfranchisement scheme.
we're not, that's not responsive to the objection.
No,
No, counsel, respectfully, what you are doing is you are giving commentary and your opinion and your conclusion about what the witness has or has not said. That is for us to decide. We're simply taking up an objection, so if you could limit your objection in response to what counsel is saying, and please stop commenting on your opinion of what the witness is saying or has not said. I just don't want us to go through the entire cross-examination in this way. So that may be your style, and that's okay if that's your style, but I'm asking you to please limit your comments not as an opinion of the witness, because you would agree that that's not appropriate, correct? Your opinion about what he says or doesn't say?
Oh, gosh, no.
Okay. What we want you to do is respond to what counsel said, and her objection was that it was vague
Yes.
and vague
Calls for legal conclusion.
and calls for legal conclusion. So tell us why the question is not a vague question.
I guess I'm not understanding what word I used that was vague. That I don't understand the
Okay, I'm
objection.
going to ask counsel to explain again what you contend to be vague.
Opposing counsel asked Dr. Baumgartner about a reenfranchisement scheme, but did not identify what type of reenfranchisement scheme that would be, whether it was hypothetical or real. And again, we know nothing about what this scheme is.
Okay, so did you,
I certainly did not intend to ask about any reenfranchisement scheme. I didn't use those words in the sentence. I don't intend to ask about that.
well, I thought that's what I heard, but let's have you restate the question again.
Okay.
Okay, yes, sir. Thank you.
We have determined, Dr. Baumgartner, according to your numbers, that as a percentage of population, that blacks are disenfranchised by virtue of being convicted of a felony at a higher rate than whites, correct?
Yes.
Okay. And so, if any law, not a specific one, not anything, just any law that allowed for the reenfranchisement of all of those felons, let's start with all of those felons, would it not have a correspondingly greater opportunity, positive effect on the black population than on the white population?
Objection, Your Honor. Vague and calls for legal conclusion.
Overruled. You may answer the question, doctor.
I already answered that question in the positive. If it were all, it would have the exact opposite implication with regards to race as the disenfranchisement, if it were all, and that is what I understood in this question.
Okay. In this case, how many felons are in Category 1 that are not also in Category 2?
I believe that number is 323,000 roughly, minus roughly 13,000. So that would be about 310,000.
Okay. And your understanding is those 310,000 are not, quote, permanently disenfranchised. I think you used the word temporarily disenfranchised, correct?
The first category is all those disenfranchised.
That's not what I
The
asked.
second category is those, my understanding, permanently disenfranchised. I really don't know if the other 310,000 people might or might not regain the franchise. I wasn't asked to analyze that.
Well, Dr. Baumgartner, you used the words temporary and permanent disenfranchisement.
I think I did, yes.
Okay. And so now all I'm asking you to do is define how many temporarily disenfranchised Tennesseans there are.
I'm not entirely sure of what happens to all the people in Category 1. I wasn't asked to analyze that question. I know some of them may regain their right to vote. Those in Category 2, my understanding was they would not. I don't know the answer to your question.
So you're unsure if some of Category 1 is unable to regain their right to vote? The ones minus the permanently disenfranchised?
I know that they lost the right to vote. I am not aware, and I wasn't asked to analyze whether they might regain it. I only was asked to analyze the Category 2 as compared to the overall Category 1.
And so was temporarily disenfranchised a slip of the tongue?
It might be an imprecision.
Could permanently disenfranchised also be an imprecision?
Well, that phrase was given to me by the legal team, and that's what I understood Category 2 to be.
And they didn't give you the phrase temporarily disenfranchised?
No, I had the phrase, all right, my understanding is Category 1 is the overall category of everyone who, by virtue of having been convicted of a felony, is disenfranchised. And then a subset of that group is Category 2, the permanently disenfranchised.
Let me ask this. Had you used as the total population just the disenfranchised, Category 1, had that been your population, not the entire state of Tennessee, just the disenfranchised, and you had rerun the racial effects of what you ran, would that have shown a net positive for black people, more so than white people?
Objection, Your Honor, vague.
Okay, could you please restate the question, counsel?
You used a total population of around 6 million, representing the entire state of Tennessee, is that right?
6.9.
Okay. And if instead of using 6.9 million, you had used 323,000, the number of convicted felons in Tennessee, and then you had rerun your analysis to see who was affected most by re-enfranchisement laws, like the one at issue in this lawsuit, would your analysis be flipped? Would it not be more positive for black people than white people?
Objection, Your Honor, vague.
I'm at a loss for what was vague about that.
Could you explain your objection, counsel?
I just don't understand what the question is asking, Your Honor, to just eliminate the Tennessee population.
I'm sorry?
I just don't understand what Dr. Haley was getting at by asking Dr. Baumgartner to omit the population of Tennessee.
Okay, the question had to do with the 322,000 that were disenfranchised. And the question was, if an analysis had been rerun, would the result have been that blacks were re-enfranchised
At a much higher rate than whites.
at a much higher rate?
It's vague to the re-enfranchisement question. I just don't understand what the,
Okay, I'll overrule the objection.
On the contrary, it would show a disparity that works to the disadvantage of blacks.
Tell me why.
If you look at Table 2 in my report, and I would urge the judges to look at Table 2, in Category 1, whites are 60%, 60.6%. In Category 2, they're 55%. So they reduced by a certain percentage, 5%. Blacks are 36% of those in Category 1, but they're 40% of those in Category 2. So the black share increases in the example that you chose, which of course ignores the entire population. But in the example that you chose, it would work to the detriment of blacks, not to the betterment or to ameliorate the statistics.
I'd like to be very clear. I didn't mention categories 1 or 2 in my question. I'm talking about the total felon population in Tennessee.
322,000.
Yes. And if you were to rerun your analysis with all of the rates you used, and instead of using the 6.9 million Tennesseans, you only used convicted felons, would that not flip your analysis? In other words, would that not mean the opposite, that blacks were affected positively at a higher rate than whites by any re-enfranchisement scheme?
Yes, it would mean exactly the opposite of what you're suggesting. If I were to limit myself to the 322,000 individuals who've been disenfranchised, which is Category 1 in Table 2. To be very clear for the court, Category 1 is 322,000 people who have been disenfranchised.
Okay.
In Category 2, we see the 13,000 and some people who've been permanently disenfranchised, as we've discussed. The white share in that second category is lower than the white share in the first category. The black share in the second category is 40%, whereas it's 36% in the first category. So the racial disparity is sharper in Category 2 as compared to Category 1. So the premise of your question, I think, is then turned on its head.
We seem to be missing each other. I'm making no reference to Category 2. This question has nothing to do with Category 2. This question is, Category 1's population is 323,000. You say of that population, blacks outnumber white as a percentage of about 2.6%. 2.6, it's a rate, not a percentage. A prevalence rate of 2.6, is that right?
No, that's not right.
Okay, tell me what's not right about it.
There are 322,984 individuals who are disenfranchised. In that group, 60% are white,
Okay,
36% are black.
okay. And so if you were to establish a reenfranchisement scheme, what percentages are being affected, black and white?
It depends on the scheme.
If you were to present reenfranchisement for all of those felons, what would the percentages of affected felons be, black and white?
That's a question that I've previously answered.
I don't think you've given us the percentages. How many black Tennesseans would be affected by the ability to be reenfranchised?
If all disenfranchised individuals were reenfranchised, it would affect 36% blacks, 61% whites.
And as a rate of their population of Tennessee, the prevalence ratio would now favor the black Tennesseans, would it not?
If there was no such thing as disenfranchisement, then that would have the opposite effect as the effect of disenfranchisement. Since the policy of disenfranchisement for felony convictions is adverse to blacks, eliminating it would be would have the opposite impact. I think that's obvious.
So reenfranchisement schemes, to the extent they apply to all felons, are favorable to black Tennesseans. Is that not correct?
To the extent that they apply to all felons.
Okay. And in this case, if we were to presume, because I know you didn't dig deeper, as you've testified, behind the permanency, if in fact, in Tennessee, all members of Category 1, except for the ones that are part of Category 2, are able to be reenfranchised, would the rate not favor black Tennesseans compared to white?
There, I think you're asking me to compare Category 2 with the remainder, the residual of Category 1. And like I've said, the racial difference, there's a racial difference between Category 2 and the residual of Category 1. And that works to the detriment of African Americans.
Let's see if we can make it numbers instead of conceptual. 323,000 about in Category 1, right?
Correct.
About 13,000 in Category 2, is that right?
Correct.
All right, so the difference is 310,000, is that right?
Correct.
Can you ballpark the racial makeup of the 310,000?
It's most likely very close to the racial makeup of Category 1, approximately 60% white, approximately 36% black.
Okay, that's what I keep, and this is what I'm getting at. I'm making no reference to Category 2. For that group of people, that 310,000, would a reenfranchisement scheme that allowed all 310,000 to seek reenfranchisement affect Tennessee's black population at a more positive rate than its white population?
What I see is that the actual Category 2 enhances the racial difference. But in the hypothetical that you described, yes, it would benefit the black population.
At a rate higher than the white population?
Well, you've asked me not to talk about the population. So we have 60% white and 36% black. So of those that would be reenfranchised, it would be 60% white people and 36% black people. So I think that's to the advantage of the white people.
Okay, and while it advantages 60% versus 36%, we know for a fact, you've testified, that Tennessee's population as a whole is not near 36% black, is it?
Now we're back to the census figures.
Is the answer to my question yes?
Well, you asked me not to talk about the population.
I've now asked you a different question. Is the answer?
Now that you asked me to refer back to the population, then yes.
Okay. Let me ask you another question, because I think you corrected yourself enough times, but I want to be sure it's clear. Is it your testimony that for every black person disenfranchised, that 2.6 white people are disenfranchised?
No.
Okay. In fact, for every white person disenfranchised, less than one black person is disenfranchised. Is that right?
Well, I'm not sure how you're, what do you mean by your I'm not sure how you're calculating these rates and how they refer or correspond to the rates that I referred to in my report.
I'm not talking about rates, I'm talking about actual people, right? So your report went to great lengths to use rates instead of raw numbers of people. Am I right about that?
Well, I wouldn't call it great length.
Did
But-
you ever once use raw number of people in any of your comparisons?
In all of my analysis, I laid out the raw numbers because they form the basis of all the calculations. So I laid out in Appendix Table B, one, the population by county. All those are raw numbers that are available to the court.
Let's focus then, I'm sorry about, I did ask an open-ended question. When you kept saying that blacks are disenfranchised at a greater rate, you did not intend the court to think that more blacks are disenfranchised than whites in Tennessee, did you?
No, it's a rate per population.
Okay, and so in fact, as a ratio, for every white person that loses their right to vote by virtue of being convicted of a felony, less than one black person loses their right to vote by virtue of conviction of a felony. Is that right?
More whites are numerically disenfranchised than blacks, yes.
And do you know about what that ratio actually is, the raw number, not the rate? The raw number, white to black.
195,813 whites, 117,000 and some blacks.
Close to 2 to 1?
Almost.
Okay.
What was the number for the whites? You said 195,000 something?
Yes, I'm reading from Table 2, Your Honor, in Category 1.
Just give me the number.
195,000 whites, 117,000 blacks.
Okay, thank you.
Okay. And let me ask, you talk about effects on elections. Given that the raw numbers, we agree that election results are not calculated in rates, they're calculated in raw votes, right?
Yes.
And if I were a legislator that thought the black population was not going to vote for me, would felon disenfranchisement be a smart way to get reelected?
Could you, I feel like the question is asking me to evaluate the intelligence of people running for office and trying to be reelected and trying to manipulate the electorate in a way that's smart or not smart. And I hesitate to suggest a smart way to manipulate the electorate.
Let me ask it more clearly. If I'm trying to win an election, and I think black people by and large do not vote for me, would felon disenfranchisement cause me to lose more white votes or more black votes?
I really don't know. Depends on the candidate, the platform of the candidate, kinds of people that might vote for that candidate.
I've just given you those inputs. Black people don't vote for me, white people do. Would felon disenfranchisement lead to me getting more total votes? Or would I in fact lose more white votes than black votes?
Sir, if you want to be an elected official in the state of Tennessee and no black person will vote for you, and you know that, and you still want to be elected to office, I guess you would have to manipulate the electorate, wouldn't you?
I'm going to need you I understand that you don't like the question, but I'm going to need you to answer it.
Could you restate the question?
Sure. If I am a legislator who is interested in getting reelected, and I know that the black population doesn't vote for me, but the white population does, would I be best served if my goal were to get the most votes to enact felon disenfranchisement in Tennessee?
The winner of an election is the one that gets the most votes compared to the second place. It depends how people might vote for the second place person.
Would felon disenfranchisement in the circumstance I just gave you cause more white people to lose their votes than black people?
Yes.
And so if I was counting on the white vote and I knew the black vote wasn't going to vote for me, I would have a net loss of votes via felon disenfranchisement.
But so would the other candidate, and we don't know how that would work.
Okay, so if you're trying to manipulate the electorate, felon disenfranchisement is not a very good way if you're trying to disadvantage black
Well, history proves that it's been a very widely used form of electorate, manipulating the electorate, as you say.
I didn't ask you if it was widely used. I asked you if it was a good way. Because you're losing more white votes than black votes, aren't you?
It depends on how the vote is going to split. It's certainly, I don't think that it would be so widely used if people didn't think it was effective.
I just gave you a concrete example, and you can't give me a concrete answer. We have the numbers in Tennessee. I've told you to assume that no black person is going to vote for me, and white people do.
But who's going to vote for your rival? You can't have an election with just one candidate, although maybe that's your preference.
Okay.
And if you can manipulate the electorate in that way, then maybe the next step would be that there can't be a rival candidate to the incumbent, because you mentioned that you were already a legislator.
And
So
so-
perhaps that's the plan. But in my understanding of elections and in our country, there's at least two candidates, although sometimes there's unopposed incumbents. And in that case, it really doesn't matter. But in a case where there's at least two candidates, it depends on what the other candidate does.
We're going to switch gears. On your table A2, it's what you refer to as permanently disenfranchising.
In my table, which?
A2.
A2. I'm sorry, did you refer to table A2 and refer to that as the permanently disenfranchised?
I think you have a table called crime codes.
Is it A2 or A1?
A1, I'm sorry, it's A1.
Table
You're right.
A1, okay.
Are you with me?
I'm at table A1 on page 25 of my report.
Tell me what that table refers to generally.
Table A1 lays out the offense codes and dates that constitute category 2.
Okay.
Table A2 provides the same information for category 3.
Perfect. Did you ever do an analysis that isolated tampering with evidence?
No,
Why not?
I wasn't asked to.
Are you aware of what the plaintiff was convicted of that disqualifies her from seeking reenfranchisement?
No.
It was, in fact, what you list as crime code. It's tampering with evidence. I think it's 6520, is that right?
Objection, Your Honor, testifying on the record.
I'm sorry, what was it?
Testifying on the record.
Testifying on the record, you mean counsel?
Counsel.
Counsel, state your question again, please.
Sure.
Okay.
In this case, there's a plaintiff with a disqualifying felony of tampering with evidence. Is that on your category 2 list?
Tampering with evidence is included in the offense 2 categories listed, yes.
And it is, in fact, category 6520. Is that right?
Yes, on page 27, 6520 is the offense code listed for tampering with evidence.
Any idea of the total population of people that committed code 6520 in your data set?
Is your question, do I have an idea of that number? No.
Okay. And you were never asked to run that number, were you?
No, I was not.
Let me ask, and this is going to be from a little bit of my own history of doing these things. When you created all of these charts and graphs, was it just an Excel spreadsheet and you manually counted, or did you write some code or some script?
I ran some code.
Okay. And so, in other words, for you to manipulate the data, you would just have to input whatever variables you were looking to manipulate into that code, right?
Well, I wouldn't describe it that way, but I'm not sure exactly what you mean.
Let me ask it this way. How long would it take you to figure out how many people fit category 6520.
It wouldn't take very long.
Minutes, right?
Yes?
Okay. And how long would it take you to produce the corresponding charts that you have throughout your report, isolated to category 6520?
I'm not sure, but it's definitely feasible.
Less than an hour will work.
Well, it's a long report and it's got a lot of tables and a lot of figures, so it might be more than an hour.
Okay. But definitely feasible.
Definitely, any of the, if I had been asked to identify any particular combination or individual code, that would have been feasible given the data that were given to me.
And again, no one asked you to produce any chart, any table that isolated tampering with evidence. Is that right?
That's right, again, yes.
Okay. Let me ask you, and I'm sorry to skip around, but that's kind of how cross-examination works sometimes. You testified as to possible effects on elections, is that right?
Yes,
Okay, and I think your testimony was that the number of disenfranchised felons in some counties exceeds the vote margin in some of those county elections, is that right?
yes, and more generally, the closer the election margin, the more likely that these exclusions from the franchise would affect any election.
And let me ask you, you used the word likely, and that was going to be my follow-up question. How likely do you think it is that elections were affected by felon disenfranchisement?
Highly likely,
Tell me why you say highly likely.
because there's lots of elections.
And that's the only variable you need to say highly likely.
The United States has hundreds of elections in every election cycle. There's elections for county clerks, there's elections for so many things, dog catchers, all kinds of things are subject to election in our country, and some of them in relatively small jurisdictions with relatively few voters. So there's so many elections that some of them come down to very close outcomes.
Right? And let's isolate now to Tennessee, not the United States. Do you have any clue how many felons have sought re-enfranchisement in Tennessee over any period of time?
Well, I have some clue because there's 323,000, so I know that it's not a higher number than that, but I don't have a precise estimate.
Do you have an imprecise estimate? Do you have any idea at all?
Fewer than 323,000.
Okay, that's as good as you can do. If you were to learn that of that 320-something thousand, that less than 10,000 had ever sought re-enfranchisement, would that change your highly likely opinion?
No,
Tell me why.
because as I mentioned, we have so many elections, and many of them come down to ties or small margins. So mathematically, excluding people from the vote may affect some elections.
I'd like to make sure you've now gone from highly likely to may. Those are two very different terms.
Any particular election has a low probability of being decided by 5 or 10 or 15 or 20 or 150 votes, but some will.
So it's not highly likely.
It's very highly likely that some election will be affected.
Okay.
It's not highly likely that any particular election will be affected, but we have so many elections that it's highly likely that some of them will be affected.
And you were confident in saying that without having any clue other than its number is less than the total number of felons, without having any clue how many of those people have ever applied for re-enfranchisement.
The issue isn't really, in my mind, whether they apply for re-enfranchisement. The issue is whether the state excludes them from the voting rolls. That is the decision made by the state. If they choose to get their franchise back, that's up to the individual. But the policy of the state is to disenfranchise them. That policy could affect many, many elections.
And so it's your opinion that the policy of initial disenfranchisement leads to these racial disparities, but you have no opinion about the policy related to re-enfranchisement.
The disenfranchisement has the effects by race that I laid out. It's highly disparate, 3.2 times different. It depends on what the reenfranchisement policy might be to know what its effect would be.
And you, as you sit here today, you have zero opinion on Tennessee's reenfranchisement policy and any racial disparity it may cause.
Well, I've been asked to analyze the disenfranchisement policy, and I've been offered as an expert on disenfranchisement. And so I don't know really what the reenfranchisement policies are. To the extent that they're broad, as you discussed in your hypothetical question about if they were total reenfranchisement, then it would have the opposite effect of the disenfranchisement in the first place.
Okay, so as you sit here today, though, and I want to be clear about this, because there's going to be this testimony, and they'll rely on it, and there'll be an appellate record. You have no opinion on any resulting racial disparity that stems from Tennessee's reenfranchisement statutes.
I haven't been asked to opine on that.
So you have no opinion?
No.
Okay. Sadly, it's going to get even more switching now, because I'm now going to address some specific questions you were asked on direct. You interestingly said at the beginning of your testimony that you had several opinions, and the very first one was in relation to juries versus pleas. Is that right?
Yes.
Okay. I found that strange, because if we go to the page of your report, page 23, titled Conclusion, I fail to see the word jury anywhere. Oh, wait, I do in the second one, I'm sorry. And the numbers didn't match up with what you said on direct. Can you explain the difference?
I said most likely 98%. The number in my report was that 1.01% of Tennesseans were convicted of a felony through a jury trial. So I was being generous that it was over 98%. It's actually 98.99%, but
I mean,
I use the number 98%, not to overstate the matter because it's not quite 99%, so I didn't want to overstate the matter for the court.
well, now you weren't afraid to use decimal places in other parts of your conclusion. Why were you afraid to use one there?
I'm quite a courageous person, and I wasn't afraid not to use the decimal place. I simply chose not to. 98% or 99%, I think, would reach the same conclusion. Very few people are convicted of a felony through a jury trial, whether it's 98%, 2%, or 1%. The actual number is in between. It's 1.01% in Tennessee, according to the data that I had. So I'm sorry if you don't like the use of 98 rather than 98.9, but 98.99 would work as well. If
Yeah, I guess I'm just trying
amend
to-
my report.
I'm just trying to understand the imprecision, because if you look at the bottom of that page, you use 16.5% of the population for blacks. Is that right?
I do.
And then on the next page, under conclusions, you use a black-white disenfranchisement rate ratio of 2.6%. Is that right?
Yes, and I say 10% and under 4%.
So should we assume the whole numbers are a little less precise?
I think that's a mathematical fact that whole numbers are a little bit less precise than numbers with decimal places.
Okay. And I'd like to look behind the numbers for the jury opinion, the jury versus plea opinion. You say it's 1.01%. Did you do any independent analysis to come to that number?
I cite the National Council of State Courts, I think it is, that provides that information, and so that's the number that I used.
Any other sources? Did you go to the courthouses and pull files?
I did not go to courthouses and pull files.
Did you look behind the organization that came up with the 1.01%, what their methodology was?
I read what was available on their website,
And
but when you say look behind, there's no supporting documents made available, so I used the number as laid out in Table 1, and I didn't try to change the number or get behind it, whatever that means.
So you have no opinion on the reliability of that number? You don't know how it was arrived at? You just know that someone said that's the number?
The National Center for State Courts said that, and that's a reputable source.
And you didn't,
Furthermore, it's consistent with other sources that I had in my own experience in North Carolina and looking at the percent of jury trials for felonies. And I cite some other sources on page 4 of my report that come up with other numbers that are less than 5% or they're relatively low numbers. So whether the number is 1% or 2% or whether it was 15%, which it wasn't, it was 1.01%, but the point is it's a low share.
and do you know which courts in Tennessee reported their numbers to this organization?
I don't know that.
And you never looked to ask?
It's not available on the website.
Did you call them up?
I did not call them up.
Did you send them an email?
I did not send them an email.
So you made no independent judgment on the reliability of that number?
It came from a reliable source, and I took it because it's come from a reliable source, and it's consistent with what other literature says about felony trial rates.
Did you apply any analysis to that number?
I used the number in my report, so I'm not sure what you mean by apply any analysis to that number. It's a number.
Sure. And so you didn't do anything to the number. You didn't say, well, I know anecdotally, or I know from my own research that, you know, I should apply this multiplier, or I should subtract this many things because they're counting it wrong. None of that sort of thing. You just repeated their number.
I used my knowledge of the literature and my own experience to recognize that that number seemed definitely to be in the ballpark of what I would expect it to be.
Okay.
And it was from a reliable source and it's consistent with other literature, so I used the number without changing it.
When you were discussing the differences between the effects on the populations, again, as a rate, not as an actual raw number of people, you used the word substantial difference. The 2.6 prevalence ratio, the 3, I think, for the category 2. Can you define substantial for the court?
Are you referring now to table 3 and the 2.6 black-white rate ratio?
Yes, sir.
The word substantial means having a substantive importance. Typically, a difference of more than 20% or a ratio of 1.2 has been considered to be substantial. A difference of 1/100% or 1% could become statistically significant, but it wouldn't be substantively important. So if the ratio were 1.1 or 0.99, I wouldn't be here today saying that there was a substantial racial disparity. If the difference were 1.3, if the ratio were 1.3 and therefore the difference was a 30% greater likelihood for one group compared to another, then I would be here with the same type of analysis because a 30% difference is substantively important. So the idea of whether something is substantively important or substantial is a matter of judgment and understanding whether that's a difference that would matter in somebody's lives. And the court is able to make their own judgment about that. The issue is often confused with statistical significance, which is a different matter. In employment law, sometimes 20% is used as the threshold for substantial. So if it were 50%, 1.5, I would say, yes, that's quite substantial. If it were 2.0, I'd say, yes, quite substantial. It's higher than that in my report. So that's what I mean by substantial.
And what is
Perfect.
I'm sorry, what is the equivalent of 2.0?
Double.
100, double, 100? If
The
1.5
equivalent.
is 50, 1.3 is 30.
Oh, yeah, then if it's a 30% difference, that means 1.3. If it's a double, that means the ratio would be 2.0, that the black rate would be twice the white rate. So if the white rate were 3 and the black rate were 6, the ratio would be 2.0. Which, you know, obviously 6 is twice 3.
Double,
So
okay.
it's double.
I see, thank you.
So that's very simple. That's why these ratios in my table 2.6 and the 3.2 number in my table 3, I think are intuitively revealing to the court. It means it's double or it's triple. the rate. So it's a very simple number.
Okay. And what I wanted to be sure of, and I'll just ask, when you say substantial, you don't mean it in a legal sense. This is purely a mathematical statistician standard. Is that right?
Well, it's not a legal
Okay.
definition.
Perfect. That's all I needed. You made the statement that blacks in Tennessee are 222% more likely to be disenfranchised than whites. Do you think that's true?
Sure do.
Tell me why.
The ratio in Table 3 is 3.2. A ratio of 3.2 means that one group is 220% more likely than the other group to have that outcome. That's what it means mathematically.
Let me ask you this. What is the likelihood of a black Tennessean who's never been convicted of a felony of being disenfranchised?
I'm not sure.
What is the likelihood of a black person in Tennessee who's never been convicted of a felony being disenfranchised by virtue of felon disenfranchisement?
If I understand your question correctly, it's 0.
Okay. And so is the driving factor here a disenfranchisement statute or a criminal justice system issue?
I guess it would be the intersection of the two.
Okay. You also made the statement on direct that every county disenfranchises more blacks than whites. That's not true, is it?
Did I make that statement?
You did.
Could you refer to when I made that statement?
I don't have a transcript in front of me. I think you cleaned it up, and I just want to make sure we're on the same page.
Objection mischaracterizes testimony.
Sustained, that was not the testimony.
I think your second statement, when you cleaned it up, if I can ask a different question, withdraw that one, was that, in fact, very few counties of the 95 disenfranchise more black people than white people. It's that when you reduce, instead of people, you use rates, that in fact more counties disenfranchise blacks than whites. Is that right?
Are you asking me, is that my previous testimony today?
Is that your current testimony as you and I talk?
Oh. I would have to look at the numbers in the appendices to my report, but you recall that white people are 72% of the population and black people are 16% of the population of Tennessee, so it could very well happen as you described. So it's appropriate to use rates rather than raw numbers.
All right, Dr. Baumgartner, I'm going to go to a place that pains me to try and go, but I got the math guy, so let's try and do some math. I want to talk about the regression analysis that was the topic of some amount of conversation. What's the purpose, generally, of a regression analysis?
Could you point out what regression analysis you're referring to?
I think it's the red line on 2 charts in your report. I can give you the page numbers if you'd like. I think the first one appears on page 13.
Yes, I see. Figure 4.
In fact, that is a regression analysis, is it not?
The red line is the regression line. Yes, it is.
Yes. And you call it the best fit regression line, is that right?
Yes, in the note to the figure,
All right.
it says red line indicates the best fit regression line, and then it gives the equation.
And back to my initial question. Generally speaking, as a statistician, what is the purpose of a regression analysis?
Of any regression analysis is to understand the relationship between 2 or more variables.
Okay. And do people often use them for forecasting what a change in a variable may lead to?
What a change in a variable may lead to?
Yes.
Could you
Sure.
be more clear in your question?
In any regression analysis, there's at least one dependent variable. Is that right?
Yes, there's always one dependent variable,
And
and
there-
only one dependent variable.
Only one, correct?
In any particular analysis, any particular equation, there's one dependent variable.
Okay. And there can be one or more independent variables. Is that right?
Yes.
All right, and so in a regression analysis, can you use that analysis to determine what'll happen to a dependent variable when an independent variable is changed?
No.
Tell me why.
Well, I think your question implies a misunderstanding of what is a regression. A regression is an
Good
effort.
chance it does.
A regression is an effort to model or to understand the relationship statistically between two or more variables. It doesn't tell you what happens to variable B when you change variable A.
Well, okay. Your regression analysis only had two variables, is that right?
In figure 4, the analysis there is simply comparing the black rate to the white rate.
Okay, and this is what I keep trying to understand. Which of those two is the dependent variable?
The black rate is on the y-axis, it's the dependent variable.
Why would the black rate be dependent upon the white rate?
The regression here is not a prediction. It's not suggesting that one depends on the other. It's showing the statistical relationship between the two variables.
No.
And the red line shows the best fit line, the regression line that goes through the center of the data points, and it shows that the slope of that line is greater than 1.
Now, I want to,
If the regression line were at the black line, there would be racial equity. The regression line has a slope of 2.88. And that's simply a line that goes through the middle of the dots. This is not a prediction or a theoretical model. It's simply a summary of the statistical correlation between the two variables. There's no effort on my part here to present a causal model or statistical prediction of what will be the black rate. It's just showing what the relationship actually is across the 95 counties. So the red line is merely a summary of what that relationship is.
all right, now, I want to focus back, like we just did this a couple of minutes ago. You said every regression analysis will have a dependent variable and an independent variable, right?
By definition, yes.
Okay, and here you said the dependent variable was the black vote, is that right?
The black rate of disenfranchisement.
Yes. And so all that leaves the independent variable to be, you said it was a two-variable analysis, is the white.
Correct.
Okay, and so what I'm asking you is, why? Why is the white vote the independent variable and the black vote the dependent variable? How are those two things at all determining each other?
Each county of the state may have a population of black and white people who are disenfranchised.
Mhm.
And so the effort here is simply to see for a county that disenfranchises, say, 1/2 of, or 1% of its white population, and what's the most likely percent of the black population that's disenfranchised in that same county? The answer is 2.88. That's the red line. So it simply shows the degree of correlation between these two variables. It's not a model. Sometimes we have a model where we're trying to predict, is a person going to have a heart attack? And we have all the risk factors. Are they overweight? Do they have high cholesterol? That's a predictive model. This is simply a statistical correlation. There's no prediction here. I'm not trying to suggest that the black rate is determined by the white rate, although I am able to show in this model that the judges can see that there is a clustering around that red line, and there's no clustering around the black line. The black line would be racial equity. So the clustering doesn't go there. The clustering goes along the red line by definition. So the red line is simply a mathematical formula, regression, to draw the line that best describes the fit of the points. That's all it is. It's not a theoretical prediction.
So let me ask it this way. The red line, if I took the white rate, the x-axis, and multiplied it by 2.8, will the red line not be at that exact number at every point on the red line?
If you took the white rate and multiplied it by 2.88,
Yep.
you would get the red line.
So I don't get it. Why are we doing a regression analysis? That's just simple multiplication.
To determine, is it 2.88? Is it 0.7? Is it 1.05? What is the red line? That's why we do it.
And how does error rate relate to this regression line?
That's a question I find it hard to even understand. If you could restate it, perhaps.
Did you assume an error rate in your analysis?
Did I assume an error rate?
Yes.
Could you ask a different question that I could better understand?
If you didn't, you can say no.
I've estimated an error rate.
So you did assume one. You estimated one.
I didn't assume one.
What's your estimation of the error rate here?
I don't recall, and I didn't report it here, but if there were no error, all the lines would be directly exactly on the red line. All the dots would be directly on the red line. There would be no wiggle room, no
Yes.
error.
Agreed. And so you say you estimated one. How'd you estimate it? Because I didn't see that anywhere in your report.
I didn't report it because it wasn't of interest. But it's obvious from the scatter plot that's presented in figure 4 of my report that there's a scatter. It's not a perfect prediction. When we know the white rate, we don't know exactly what the black rate will be. On average, it will be 2.88 times the white rate. That's what the regression allows us to know.
So you're telling me that there's math in your report that you don't remember the underlying estimations that informed it, and you don't know them as you sit here today?
That's not true. I know exactly the underlying estimation is 2.88. You asked me about the error. That's not the estimate.
You said you estimated an error rate, did you not?
I estimated the OLS regression. When you do that, you also are given, you find out what is the goodness of fit of that model. If the goodness of fit were 100% or 1.0, all the dots would be exactly precisely on the red line. You can see for yourself, and the court can see, that all the dots are not on the line. There's some difference, some random fluctuation, some stochastic element to the analysis. That's how it works.
Let me ask you, and this will relate. You were asked by counsel for Ms. Moses whether you had reviewed the report of Mr. Gary Smith. Is that right?
I did review that report, yes.
And do you remember his analysis of gender's effect on disenfranchisement?
I remember that he did an analysis of gender.
And do you remember what about his findings were, maybe generally?
Generally, a large percent of the felons, the people disenfranchised because of a felony conviction, are men rather than women.
And in fact, the ratio by which men were affected as a rate of the population was much, much higher for men than women as compared to black versus white. Is that not right?
It might be. I don't recall exactly, but it might very well be.
That makes sense to you?
Yes, it would.
And so in fact, if you had plotted as part of your regression analysis, if you'd used multi-factors, race and gender would have actually tracked much closer than race. Is that not right?
Well, here I have to ask you, what regression are you referring to?
I said, had you done a regression analysis with multiple variables instead of just two, we add gender.
What would be the dependent variable in this analysis?
I mean, you used black votes. Let's go with that.
I didn't use black votes. Could you
used-
be specific? I mean, there's all kinds of regressions, and every regression has to be particularly
Okay.
specified. The regression in figure 4 is simply for descriptive purposes to calculate what is that red line. Is it 2.8? Is it 4.5? Is it 0.9? That's the only purpose of that regression. I'm not proposing a model of who's disenfranchised.
Let me ask more simply. The prevalence ratio for men as a percentage of their part of the population in Tennessee would be much higher than 2.6 as it relates to felon disenfranchisement compared to women. Is that right? Is that not what Dr. Smith has in his report?
Well, you've used a bunch of words, prevalence ratio, and what, okay, so are we looking at the 2.6? When you mentioned the number 2.6, it makes me think you're referring to the ratio in table 3.
I am. I think you used 3 different words in your testimony. I think at one point you said prevalence ratio was one
That's
of
the
the
word
terms.
that he uses in his, yeah.
Okay.
So what would you, what
So
was the
if
question?
it's 2.6 for black as compared to white, You agree that it's much, much higher for men as compared to women?
You mean the ratio of disenfranchising men compared to disenfranchising women, or the ratio of disenfranchising black men compared to white men?
No race involved. The ratio of disenfranchised men versus disenfranchised
Oh,
women.
I don't know.
You don't remember from his report?
No.
Okay. This is the part where if you can just give me 2 minutes to maybe consult with counsel, I think I'm about done. I just want to make sure I didn't miss anything because
Okay,
there was a lot of skipping around.
All right.
To avoid the sort of repetition that Judge Cook referred to. I think I'm done. The only question I have of the court is we're going to have a motion.
I'm sorry?
We're going to have a motion related to his testimony in light of what his testimony just was. Would you
You're
like
gonna
that
have
at
a
the end?
motion?
Yeah.
Okay.
Would you like that at the end of her redirect, or would you like it now?
I have no idea. Counsel,
Sure.
what type of motion are you referring to?
Your Honor, this witness just testified unequivocally. He has zero opinion on any racial disparities caused by Tennessee's reenfranchisement
Okay,
scheme.
hang on a second.
This-
Is this, what type of motion
A
is
motion to strike all of his testimony and exclude him.
Okay, let's hold off on that.
Oh, okay.
We're gonna take our redirect. I'm sorry.
My fault.
Okay, that's okay. We'll give you a chance to, make your motion though. Okay.
Thank you, Anna.
Okay.
Dr. Baumgartner, I have 3 questions for you. You were asked some questions about why you focused on rates of disenfranchisement rather than raw numbers of people who were disenfranchised. Do you recall that question?
Yes?
If we want to understand the existence and extent of racial disparities, is it more informative to focus on rates or raw numbers?
Rates.
Why is that?
Well, as I mentioned, and it's clear in Table 2, the state has roughly 70% white and 16% black population. So naturally, in almost anything, there'll be more white people than black people because whites outnumber blacks by large numbers. So it's better to say, well, let's take 100 blacks, 100 whites, and look at the rates. That's what the rates show. And then we see whether something is more prevalent in the black community or in the white community. So we look at rates, which is simply percents. How many people per 100? So it's a percent, I call it a rate. And then we compare those rates. That's the ratio, 2.6, 3.2, that's laid out in Table 3.
Thank you, Dr. Baumgartner.
Okay, that concludes the redirect?
Yes.
Okay, thank you. Okay, counsel, you have a motion?
We do.
Okay.
Your Honors, in my opening, I was clear that there are 2 injuries complained of here. The first is the inability to be reenfranchised.
Okay, well, let me just say this, because normally we don't take motions during witnesses' testimony, so this is a little unorthodox. So it's not a motion that would be made after the close of plaintiff's proof. There was no pre-trial motion to exclude the witness. The witness has been admitted. So I'm just, why would a motion at this stage be a proper motion if it has anything to do with the testimony of Dr. Baumgartner?
Your Honor, you've been doing this, you've been a judge much like I've never been a judge, so you certainly have more experience. I don't think it hadn't been that uncommon in my practice for motions to strike the testimony of witnesses to be made.
After they've testified?
They are generally made at the conclusion. You can't strike something that doesn't exist yet. It's impossible to file, it's impossible to make the motion to strike until there's something to be stricken.
Okay.
And I don't think it's, I mean, I've successfully and unsuccessfully made them before. If Your Honor doesn't want to entertain one, I totally understand it. I just won't make it. But I do think the appropriate time to move to strike something is after it's been into the record.
Okay, well, go ahead and make your motion then.
Okay.
Okay.
And again, it's informed by relevance. This lawsuit,
Now, you know, we have to be careful because we don't want you opining upon the merits of the testimony.
no ma'am.
Okay, and then, so are we dealing with because I'm just trying to keep the record clean. And normally, motions to exclude are they're pre-trial. So there's a deposition, the witness testifies, direct, cross, and then you have the deposition, and then you say, you're asked the court to exclude because the witness is not qualified, or the opinions, but there's a basis, and then we do that pre-trial. But the witness has already been tendered as a expert. And the rules say, and I was gonna pull up my TPI, but the court is free to accept or reject the opinion of any expert. The court is not bound to consider the opinion of any expert. And we have certain factors that the Tennessee pattern instructions, and it doesn't really matter whether it's a jury or non-jury, we still apply the same instructions, but there are certain guidelines that it gives us in terms of how we consider and evaluate a witness's testimony, an expert witness. So the witness has already been tendered as an expert. So I'm just trying to understand, what are you seeking to exclude without a big overview? Are you seeking to
Yeah.
exclude
You're
Dr. Baumgartner as a witness, or certain parts of his testimony, or what exactly?
We are seeking to exclude the entirety of his testimony.
Okay.
Now,
Well, we're gonna
here's-
ask you to put that motion in writing and to brief it, give notice to opposing counsel, let them review it, and then we'll take it up at the proper time. But he's already concluded his testimony, so there's no prejudice to doing it that way.
So the only possible prejudice, and I'm not disagreeing, and Your Honor,
Well, the
I'll
witness is
defer to Your
already, I
Honor.
mean, the redirect is already concluded. So the witness is, for all intents and purposes, concluded. So we are not going to stop the trial at this point to take an oral motion, which I'm not quite sure is procedurally proper. And it just seems to me, so that we can keep the trial moving, please do a written motion and a factual and a legal basis, and then allow the plaintiff an opportunity to respond to it. And then we can evaluate that. We'll be in a much better position to evaluate it on its merits. There are certain motions that are made during the trial, but I've never, ever had a motion to exclude the entire testimony of a witness, expert, who has already been tendered. So if this goes to the weight of his testimony, then that would not be a basis to exclude him, right? Under the guidelines that we have. It may go to how much weight we give his opinions and his testimony, but it would not be a basis to exclude the testimony once the witness has been tendered. So we will confer, but again, Judge, any comments in terms of the motion or how we handle that?
Maybe we should take 5 minutes.
Okay, let's take a recess.
Thank you, Your Honor.
All rise.
Right. George, you want deferred, and we are going to ask you to file that written motion, and then we'll give the plaintiff a chance to respond, and then we'll either take it up on brief. If we feel that we need an oral argument on it, then we'll request that. Okay.
Thank you so
Any more? You're welcome. Any more questions for Dr. Baumgartner? No.
No, Your Honor.
Okay. You're excused, sir. Thank you.
Thank you all.
Thank you. Okay. Want to call your next witness?
Plaintiff calls Dr. Tracy Birch.
Dr. Tracy Birch, officer. She may be in the hallway.
I'm sorry, Your Honor, she's in the
Oh,
courtroom.
she's in the courtroom? Okay. Dr. Birch, please come forward. How are you this afternoon?
I'm doing well, Your Honor, thank you.
Wonderful. Raise your right hand for me, please, and let's go ahead and, were those, yeah, let's go ahead. Officer, could you please remove those documents and give those back to the plaintiff, I believe? Officer, plaintiff's counsel.
I'm sorry.
All right, thank you. Dr. Birch, yes, please raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may be seated.
Good afternoon, Your Honors. Mike Mazzullo from Arnold and Porter on behalf of plaintiff.
All right, good afternoon, Counsel Mazzullo.
Please state your name for the record.
Yes, I am Tracy, T-R-A-C-I, Birch, B-U-R-C-H.
Where are you currently employed?
Currently, I am employed both as a professor of political science at Northwestern University, as well as a research professor at the American Bar Foundation.
How long have you been a professor at Northwestern?
Since I received my PhD in 2007.
I'm sorry, did you say the American Bar
Foundation.
Foundation? Okay.
What is your educational background?
I did my undergraduate work at Princeton, where I majored in political science with a minor in African American studies, and my PhD at Harvard, where I was a joint degree in government, which is what they call political science, and social policy, which is a separate field.
And since completing your PhD, what is your professional background?
So since my PhD, as I said, I've been at both Northwestern and the American Bar Foundation. I've published several articles in peer-reviewed journals, as well as award-winning books. I have I've done a number of service obligations for the discipline, for the profession of political science. For instance, I'm currently editor-in-chief of a Law and Society journal, Law and Social Inquiry. I've also been associate editor of Political Behavior, which is our subfield journal in political behavior, which is elections, public opinion, and voting behavior. I've been on the executive committee of the Elections, Public Opinion, and Voting Behavior section of the American Political Science Association. I've also served as reviewer for a number of institutions and prominent journals such as National Science Foundation, Science, the American Politics, American Political Science Review, Journal of Politics, that sort of thing.
Have you previously testified as an expert witness?
Yes, at trial more than a dozen times, as well as in some depositions as well.
In what jurisdictions have you previously testified as an expert witness?
All over the South, including Georgia, Alabama, Mississippi, Texas, North Carolina. I also worked on a case in Tennessee as well.
Dr. Birch, based on your education, training, and experience, do you consider yourself an expert in political science as it relates to political participation and the effects of criminal convictions on voting and democratic engagement?
Yes.
Have your opinions in this case been formed using methods that are commonly accepted in the field of political science?
Yes.
Can you identify which of your publications that you have authored that are relevant to your opinions in this case?
I don't have a copy of my CV in front of me, if you don't mind It'd be easier if I had the,
Sure. Your Honor, plaintiff moves to admit Dr. Birch's report.
Okay?
Your Honor, we do have an objection to hearsay, which we understand Your Honor has overruled for the other experts in this case. However, we do want to note that objection on the record.
Okay, all right, thank you. The report, does it include the CV?
Yes, I believe the
It's all
CV
one-
is at the back.
Oh, all one document?
I believe
Okay.
so, Your Honor.
All right, the court will overrule the objection. We'll mark this the next,
I believe, Your Honor, that's Exhibit 57, is that right?
okay, all right, thank you.
Yeah. Your Honor, may I approach the witness?
Yeah. The officer will take care of it. Thank you.
Dr. Birch, I'll go back to my question. Is the CV in the back? Do you see your CV there?
yes, it starts on, well, it's renumbered, so it starts on page 1, which is after page 17 of the report.
Okay. And my question was, can you please identify which of your publications that you have authored are relevant to your opinions in this case?
Yes, certainly. So if we just go, starting on page 2, my work, my article published in the Annals of the American Academy of Political and Social Science titled The Effects of Imprisonment and Community Supervision on Political Participation. My 2013 book with the University of Chicago Press, Trading Democracy for Justice, Criminal Convictions and the Decline of Neighborhood Political Participation. Skipping down a little bit, my work, 2012, Did Disfranchisement Laws Help Elect President Bush? New Evidence on the Turnout and Party Registration of Florida's Ex-Felons and Political Behavior. 2011, on page 3, Turnout and Party Registration Among Criminal Offenders in the 2008 general election. My 2011 piece is about legal financial obligations. And, also then, I guess, I don't have it here, but my dissertation as well was about measuring and estimating disfranchisement rates in several states.
Your Honors, plaintiff tenders Dr. Tracy Birch as an expert in political science and the effects of criminal convictions on voting and democratic engagement.
Okay, that was a mouthful, so let me write that down.
Sure.
Political,
science and the effects of criminal convictions on voting and democratic engagement.
yes, Counsel.
Your Honor, we would object to the admission of Dr. Birch's testimony
Okay.
for the reasons that we stated in our motion in limine, which my understanding is hasn't been ruled on one way or the other at this point.
Okay,
Our position is that her 3 conclusions that she makes are about general disenfranchisement. In a nutshell, this case is about permanent disenfranchisement. Therefore, under Tennessee law, under Rule 702 of the Rules of Evidence, not only must Dr. Birch be qualified, and we're not disputing her qualifications, her CV is very lengthy and she's qualified. However, her expert opinions must also substantially assist the trier of fact in reaching a determination in this case. The determination to be made in this case is whether the permanent disenfranchisement is unconstitutional in this case. And Dr. Birch's opinions about general disenfranchisement and everyone, which this court has already held that this case is not about general disenfranchisement, will not substantially assist this court in making that determination.
all right, thank you, Counsel. Response?
Ms. Moses brings facial equal protection and substantive due process claims, and those claims recognize that facial challenges necessarily involve broader systemic evidence. Permanent disenfranchisement is part of this general disenfranchisement scheme, and the harms that she discusses in the report are consistent both with permanent and general disenfranchisement.
Your Honor, with all due respect to opposing counsel, they're not consistent with permanent disenfranchisement. Because, if I may proffer, Dr. Birch speaks extensively about how difficult it is to be re-enfranchised and go through the process of perhaps applying or having to pay off legal financial obligations. But a person that's permanently disenfranchised does not have to do any of those things. And if they did, it would be fruitless because a court cannot re-enfranchise them. So permanent disenfranchisement is different than general disenfranchisement. And most of the things found in Dr. Birch's report, most of the harms that she discusses are just simply not applicable to permanent disenfranchisement.
Okay, are they relevant to the equal protection claim or the due process claim?
No, Your Honor, because both of those claims are rooted in the permanent disenfranchisement, not general disenfranchisement. So even if it is an equal protection claim about permanent disenfranchisement or substantive due process claim about the same, we're talking about permanent disenfranchisement here, not general disenfranchisement.
Okay, Mr. Basula?
I would say any concern raised goes to scope or weight, but not admissibility in the first instance.
I'm sorry, say that again?
I'm sorry. Any concern would go to scope or weight, but not to admissibility in the first instance. And again, Dr. Birch's testimony will talk about how permanent disenfranchisement operates in practice and what effect it produces at scale. And the harms that Dr. Birch talks about in the report and we'll talk about today are consistent with permanent disenfranchisement as well as general felon disenfranchisement. And again, Tennessee courts have recognized, as we laid out in our papers, that facial challenges necessarily involve broader systemic evidence of the statutory scheme.
Okay. Sir?
Yes, Your Honor. Our position is just this broader systemic evidence that they're talking about is much broader than the inability to be re-enfranchised here. They're talking about all sorts of things that will not help this court make the determination that it needs to make, and may honestly be confusing to sort out on the back end after we have all this testimony. This is something that should be taken up on the front end before we get through all the testimony, and she said all these things that may be completely inapplicable to the statutes that are at issue.
Okay, well, if it's relevant in part to the, if there are going to be opinions with regard to permanent disenfranchisement, would it be possible just to make objections if the testimony or the questioning is not relevant to the issues as opposed to excluding all of the testimony?
Your Honor, while certainly we will object if this testimony is allowed in, our point here is that the entire thing can be excluded as a whole because it will not substantially assist this court under Rule 702.
Okay, answer that question.
It will definitely assist this court, substantially assist this court.
In what way?
In the court's evaluation of plaintiffs' equal protection and substantive due process claims, which again are facial claims not limited just to Ms. Moses. Ms. Moses has an as-applied challenge under the Equal Protection Clause, under the Substantive Due Process Clause, and we also bring a broader facial challenge under those constitutional provisions. And as the nature of the nature of those challenges is that we're not talking about just Ms. Moses as applied, but how this statutory scheme works more broadly in the state of Tennessee and applies to folks other than just Ms. Moses. And Dr. Birch's opinions will talk about the impact of these laws more broadly beyond Ms. Moses.
Your Honor, if I may be heard on that point.
Yes.
Opposing counsel has said substantive due process and equal protection, and you keep saying those words, but he hasn't boiled this down to the specific things that this court will have to find in order to conduct the analysis for substantive due process and equal protection. What we have from Dr. Birch here in her expert report doesn't go to those specific things. In order for substantive due process to apply, you're looking at two factors. One factor is whether she even has a right to which substantive due process applies. And then two, the test is whether it shocks the conscience. Here, this witness doesn't provide any evidence of those two things whatsoever. Two, for equal protection, you're looking at there whether different groups are being discriminated against one way or the other. Dr. Birch does not offer any testimony about that in general and as applied to the facial equal protection claim in this case. And then secondly, Your Honor, another thing to talk about here is we're talking about the inability for Ms. Moses to be re-enfranchised. That inability comes from one specific statute, Tennessee Code Annotated 40-29-102B. That is a list of crimes for which no one can be restored. That's the only thing this case is about. This court has already held that it's not about 40-21-12, and it's also not about the process with which Ms. Moses cannot even engage, which is applying to the court and doing the whole process of petitioning for the right to vote, or the burdens that may come with that, such as paying off legal financial obligations like court costs, or being consistent with child support obligations. None of those things come into effect here, because we are only talking about a list of crimes for which she cannot be restored, and whether that is constitutional.
Okay.
So the entirety of Dr. Birch's expert report and in her testimony should be excluded because it will not substantially assist this court in making the relevant determinations.
Okay, Mr. Mazzullo, we've not read the report, but do you contend that Dr. Birch's testimony is going to focus mainly on the issues that individuals have when they're disenfranchised, not necessarily permanently, but under the felony disenfranchisement statute, the challenges that they have in terms of reinstatement?
No, Your Honor.
Okay, because that's what I thought I understood counsel to say, that the bulk of her opinions and testimony is going to relate to that issue.
It will not, Your Honor.
Okay.
Given that the statute has changed as of late last year.
Okay, so what is the substance, again, try to explain to us again, what
Sure.
is the substance of her opinions going to be, and how are they relevant?
So our claims include a balancing of benefits and harms. In other words, government interests, right?
As
And-
it relates to the permanent disenfranchisement statute?
Correct.
Okay,
And the impact on affected persons and communities. And what Dr. Birch will testify to, as in the report, is what those harms are, right, which is on one side of the balancing test,
okay.
and also what the government interests are, which are on the other side of the balancing test.
As it relates to permanent disenfranchisement?
Yes, yes.
Okay.
Now, I will say, part of her research and scholarship, right, is beyond just permanent disenfranchisement, but there's an overlap there, and they're generally I'll let Dr. Birch talk about that, but yes.
Any questions? Questions? No questions? Okay. All right, the court will overrule the objection to exclude Dr. Birch, but at the same time, if there are areas of the testimony that defendants contend are not relevant, please make those objections.
Yes, Your Honor.
But in terms of excluding her as a witness or her entire testimony, the court will overrule that.
Yes, Your Honor.
Okay, because the defendants have already said that she's qualified, it's just that it's a 702 objection, and then relevance.
Yes, Your Honor, that is correct.
Okay, all right, very good. Okay, now, in terms of the tender, I just want to make sure that we're on the same page. So is there opposition? I know that you've already raised your objection, but in terms of the area of the expertise, it was political participation and, can't read my own writing.
Your Honor, if I may,
Okay.
it was political science
I'm sorry, political science, okay.
and the effects of criminal convictions on voting and democratic engagement.
And Your Honor, we have no objection to those specific categories and her being an expert in those categories.
All right, thank you. So Dr. Birch is tendered as an expert in political science and the effects of criminal convictions on voting and
Democratic
Thank you.
engagement.
democratic engagement. Okay.
Dr. Birch, I'd like to now turn to what you were asked to do in this case and how you approached that work. What were you asked to do in connection with this case?
Yes, so I was asked by counsel for the plaintiff to review the literature on felony disfranchisement with respect to the harms of these kinds of policies for individuals and communities, as well as to evaluate some stated goals of legislatures in passing these laws.
I'm sorry, could you repeat the scope of that, please?
The stated goals of legislatures in passing the laws, as well as the harms of felony disfranchisement policies for individuals and communities.
What methods did you use to form your opinions?
I used sources and methods that are commonly used in political science, and especially the analysis of peer-reviewed publications in political science and other disciplines. I also discussed my own work in this report as well.
And is your analysis limited to the state of Tennessee?
Some aspects are specific to the state of Tennessee, and others are more general findings that may include national data, including Tennessee.
At a high level, which of your opinions will you be discussing today?
So today I'm going to focus on my opinions relating to my findings. That numerous studies support the conclusion that felony disfranchisement policies detrimentally affect individuals as well as communities. Communities I define both as geographic space, but also maybe referring to racial and ethnic communities. I also will be discussing my findings relating to the stated goals of the legislature as well. And or of defendants, the defendants in general.
And how does felony disenfranchisement affect individuals who are subject to it?
Certainly. So for individuals who are subject to disenfranchisement, in general, we tend to think about I'll back up and do a little bit of theoretical work here, but we think about these kinds of policies as a class as separate from prison, probation, parole, fines, those kinds of punishments, and we instead call them collateral consequences. And they're sort of like a class of additional penalties that might range from being denied the opportunity to apply for welfare benefits, or not being able to live in a certain place if you're a sex offender, or even certain kinds of penalties that we've been discussing here, like serving on, not being able to serve on juries or run for office. So they're a part of a larger class of these collateral consequences that have been studied quite a bit in sociology and political science and the like. And generally, the research shows that these kinds of additional penalties have been shown to detrimentally affect people's individuals' ability to reintegrate in the community. So once you're released from supervision, once you're released from prison, your ability to stay out and thrive is oftentimes affected by these kinds of collateral consequences. Another one might be certain kinds of legal financial obligations, for instance, that might make it much harder for people to succeed afterwards. So part of the reason, aside from just the financial penalties, or like if you think about, if it's hard to stay out, if you're having a hard time getting a job because, say, you were a barber and you can no longer practice that profession. There's also these attitudinal effects to the extent that collateral consequences can be very stigmatizing, and so the deprivation of rights, the deprivation of social and political rights, especially, can send messages to people that they're not part of the political and social community, and the political and social community has no concern with them. And so those kinds of messages send shame, humiliation, and the like, and it makes it so that people can't form those attachments to employment, to partners, to the state that they would need to survive.
I'm sorry, I forgot what the question was. What was the question?
How does felony disenfranchisement affect individuals who are subject to it?
Okay, all right, thank you. Okay, I'm sorry, Dr. Birch, you may continue.
Oh, thank you. So basically, there's attitudinal effects like stigma that come from this exclusion from the political and social community. And felony disenfranchisement has also been shown to affect reentry and reintegration, often through stigma. And so there's empirical research that I cite in my report on pages 5 and 6 that support this claim. So interviews.
Okay, are we gonna have, and I'm trying to just give you the time, but do you have another question, or did you want her to continue with her empirical?
My next question was gonna be,
Okay.
what sources do you rely on for that
Okay,
analysis?
He's gonna ask the question and, okay.
Dr. Birch, what sources do you rely on to reach that analysis?
Sure. So on pages 5 and 6, I discuss at the bottom Miller and Spillane, who did some interviews of returning citizens, people with felony convictions who were coming back off of supervision, who talked about how they thought that their inability to vote, lack of an ability to vote, affected their reintegration into society. Other interview work from Uga and Manza also show this stigmatizing effect. Other work that I cite here by Scheinman. Scheinman actually did an experiment where she surveyed a group of people who were returning citizens in a couple of states and showed them asked some people questions about, say you got the right to vote back, or did you know you had the right to vote, compared to other people that she didn't tell them that. And she found in a couple of studies that those groups of people who were told that they were able to come back and vote were much more likely to express trust in government and other pro-social attitudes, as well as political efficacy, which is shorthand is the belief that
Objection,
people.
Your Honor. To narrative and cumulative at this point.
Narrative and cumulative, okay. Want to address the first narrative?
I can ask the next question, Your Honor. I asked Dr. Birch just to give a sampling of the sources she relied on for that analysis. That's in her
Okay.
report.
Okay, sustained.
And Your Honor, on the cumulative part as well, Dr. Burgess is reading her report on the stand here. It's already been admitted to evidence. To the extent that we're just gonna have her read that, I don't really see a point in the witness just reading that out, Your Honor.
The court would agree. Dr. Birch, you can use your report to refresh, or if you're cited to the report, but we would prefer that you testify directly to the questions. Okay.
Okay.
All right.
Sorry, Your Honor.
No, it's okay.
Dr. Birch,
Is that okay, Counsel?
Yes, Your Honor.
Okay, thank you.
Dr. Birch, what does the literature show on whether felony disenfranchisement affects recidivism?
So the literature does not support the claim that policies such as felony disenfranchisement have a deterrent effect, that is, keep people from going back to prison. In fact, the literature that I reviewed finds the opposite effect. It either has no effect, it doesn't help with recidivism, or it actually makes people more likely to recidivate.
And do the effects of disenfranchisement stop with the individual?
No. As I show in my work and the work that I cite here in my report, communities are affected as well.
Does your book, Democracy for Justice, look at this question?
Yes. So in my book, Trading Democracy for Justice, what I do is examine at a very granular level, which is block groups, which are about 1,000 people, give or take. It's a census category, roughly corresponding to neighborhoods. What does incarceration and community supervision, and thus the number of people who are disenfranchised, look like? And I completed that work for North Carolina and Georgia, as well as I have a few footnotes in there about Florida as well. And basically what I find is that people with felony convictions who are disfranchised tend to come from a very small number of communities across the state. They're not evenly distributed. And what that means is that some communities have very high proportions of disfranchised people. And then those numbers are high enough that they can then lead to spillover effects with respect to political power and also just voter turnout as well.
And What mechanisms are driving these community level effects?
So I explore several of these mechanisms in my book. So the first one is the idea of role models. So if you think about how you first learned to vote or got interested in politics, it was probably from your parents or some of your friends who invited you, or watching other people in your community who were close to you doing that. And people in communities where, say, I think some of my data in my book showed that there are some communities where 20% of people aged 18 to 35 couldn't vote. And so being in those kinds of places means that even the people who can vote are less exposed to other voters who can serve as role models. There's also issues with respect to political parties. So if we think about how political parties mobilize voters, what they do is they get lists of people who voted before, and then they go and target those communities with door-to-door walking and stuff. So if you have the kind of community where there's large numbers of people who can't vote, then of course that means that you're less likely to get mobilized by parties and other groups who are trying to get out the vote. So that's just a couple of mechanisms.
And what sources do you rely on to reach that analysis?
My own book, as well as I cite here several studies on voter turnout and voter mobilization in political science.
Changing topics now, what does the research show about racial patterns in disenfranchisement?
So generally speaking, I do find in my work that racial patterns, African Americans are much more likely to be disenfranchised, but also to suffer from these community level effects and live in high disenfranchisement communities. And as I cite here in my report, in Tennessee, African Americans are, we see evidence of that racial concentration of disenfranchisement as well as the sub-state level. And because there's a number of these that I'm going to cite, I'm going to refer to my report here, but on page 8, I talk about how in Tennessee, there's research by Cottrell et al. That shows that in Tennessee, congressional districts 8, 9, and 5, more than a quarter of African Americans were what they call missing from the electorate. That is disproportionately where you would expect if black and white people had the same level of mortality and disenfranchisement. This is what the African American population should be. And they find that about 25%, more than a quarter of African Americans were missing from the electorate in those congressional districts. About half of the missingness is due to felony disenfranchisement, according to the authors. In the state legislature, it's even worse. So there are some, more than 30% of African American voters were, quote, missing from Senate districts 28, 10, 31, and 30, and House districts 83, 50, 28, 93, 84, 97, and 54. And those were, that article was written in 2019, so those numbers may be slightly different now because of redistricting. But that was the estimates then, where they had high rates of concentration of disenfranchisement.
Dr. Birch, since you issued your report, the Tennessee legislature has amended the statutes governing voting rights and restoration. Are you familiar with those changes?
Yes.
Does the passage of the amended law change your opinions?
As expressed in my report, not substantially.
And why not?
Because the issues that I discussed in my report with respect to information costs, that is confusion about what your status is, as well as psychological costs, which compliance costs, which is about like the time and money that it might take to get reenfranchised, and the psychological costs, which is fear of prosecution or other kinds of negative repercussions are still applicable.
At the time you wrote your report, what was your understanding of the government interest being asserted by the defense in this case?
So yes, so as I...
Hold on, I missed. What was that question?
Sure. At the time you wrote your expert report, what was your understanding of the government interests being asserted by the defense in this case?
So I was not provided a list of specific state interests that were served by disfranchisement that were articulated by the defendants at the time of my report.
Sitting here today, what is your understanding of what the defense is attempting to put forward as a government interest?
So my understanding is that they are saying that their interest is in preventing people who are unfit to vote, as well as language about election integrity.
In your research and work, is that language about being, quote, unfit something you have heard before in defense of disenfranchisement?
Objection, Your Honor. This is calling for a opinion that was not disclosed in her expert report. As she just admitted, her expert report was written without any knowledge of what the government interests are, and now opposing counsel is asking her specific questions and to analyze the specific government interests that are applicable in this case. That was simply not disclosed to us. It was not something that was subject to her deposition or that we had the opportunity to depose her on, and it is improper expert testimony at this point.
Okay.
So, Your Honor, at the time of Dr. Birch's report, we repeatedly asked defendants whether they had a government interest. We talked about this at the final pretrial conference, and our principal position, we moved in limine on this, you may remember, is that the government interest should not come in at all because they did not disclose it in discovery. Again, we raised this in a motion in limine, the panel heard argument at the final pretrial conference. But at a minimum, our expert needs to be able to address the government interest that they're now asserting. It can't be a one-way street. In their ROG response, they said they have, in their interrogatory response, they said they have no knowledge. We asked the depositions, the same thing. Coordinator Goins and Ms. Henry Robertson, they said they have no knowledge. So we've asked this time and again in discovery, and this purported government interest was never disclosed, which is why Dr. Birch was not asked to opine on it in her report. Although I will finally note that my next question is there anything in the report responsive to this purported government interest?
Okay, counsel. So if I understand, this kind of, this issue applies to one of the issues that came up in the motions in limine with regard to the state allegedly not disclosing any governmental interest. So I guess the first question is there going to be any proof from the state, the defendants, that there is a governmental interest, whether it's rational basis or compelling governmental interest under the strict scrutiny standard?
First, Your Honor, this court's already found that there are two government interests. It's law of the case at this point, and it comes directly from this court's order on the motion to dismiss by defendants.
Well, that's assuming that we apply a rational basis test. And I know that the state's argument has been that once one has been disenfranchised and they've lost their right to vote, then it's rational basis. But assuming that the court were to find that it was a strict scrutiny analysis.
Your Honor, the interest remains the same. Whether we apply, whether it must be compelling or legitimate, or whether it must be rationally related, the interest remains the same. The question just is, does it reach that level of scrutiny? Here, the court's already identified the two interests. It's identified it as a matter of law. And the Tennessee Supreme Court has held in City of Memphis versus Hargett that courts can't identify a government interest as a matter of law, and there need be no specific proof of what the government interest is. If I may refer, Your Honor, I brought copies of it if Your Honors would like a copy. And you can take judicial notice of the court's order. And the date of this order is also very relevant. The court's order came out July 19th, 2023. Dr. Birch didn't write her report until 2025. And she says that they had no knowledge, opposing counsel says they have no knowledge of the government interest. And I'll just read it into the record, Your Honor.
Well, you don't have to do that. So my question is, during the trial, does the government intend to put on any witnesses that are going to testify to a governmental interest? Not what the court has already said in its order, but is there going to be any proof at trial?
Well, Your Honor, that depends on two things. One of the things, it depends on if we're not required to put on any proof because we
Well,
don't have the
that's not
burden
what
of
I'm
proof.
asking you, counsel.
So, well,
Okay, I'm not asking you
yes, Your Honor, but
that.
that's a
Okay.
determination to be made by the group. May I consult with my co-counsel
Well,
for
it's
this moment?
relevant, because if the state is going to, and like I said, the motions kind of interplay, because if the state is going to put on proof, and that proof was not disclosed, and the court is inclined to let the state put on that proof, then the court would be more inclined to allow Dr. Birch to testify about these compelling interests that the state is going to allege. Now, if the state is not going to put on any proof of any compelling governmental interest or rational interest or whatever, any interest, then the court would be more inclined to not allow Dr. Birch to testify if she did not give that opinion. So the two are somewhat connected. Does that
Yes,
make
Your
sense?
Honor. One brief point on that.
Okay.
Just as you can see, we have a team of lawyers here, Your Honor.
You need to
I'm not
consult with them?
responsible for every witness
Okay,
in this case.
I
It might be
understand
helpful
that.
if I could talk to them just a little bit.
Absolutely.
And see what they plan on bringing out.
Do you want to
their
step out in the
examination.
hallway so we don't have to take a
We
recess?
can probably just huddle over here briefly,
okay.
and we'll get right back with you.
Okay, that's fine.
Okay, Your Honor, I can respond now.
Okay.
I've been informed by my co-counsel. So, there's a two-part answer to that question.
Okay.
First, we've got to look back at what the interrogatory request was. The interrogatory request was for what is the specific government interest that was supporting these laws. And we don't have an answer to that because we're not the legislature, Your Honor. This is Coordinator Goins, this is the defendant in this case. That was a interrogatory posed to Coordinator Goins, and he does not know the exact things and the reasoning behind the legislature because there's legislative privilege and he's not afforded that information. The second part to your question, Your Honor, is Defendant Goins going to present possible government interests that support these laws? And the answer is yes, we do plan on putting proof on that. Third part of that answer is, do we have to? And the answer to that is no, this court can find government interests as a matter of law.
All right, counsel, Mr. Missoula.
Yeah,
So it sounds like the state may put on some proof with regard to governmental interest.
right.
So what would be your position about Dr. Birch testifying to any issues related to governmental interests that were not disclosed but now may be coming forward?
Right, that was gonna be my line of questioning, was to ask her exactly about what we consider to be undisclosed purported government interests, and give our witness an opportunity to address them because they were not previously disclosed. And if I may briefly address the point about the court's order from 2023, that court's order was at the pleading stage on a motion to dismiss, in which the court was assessing the plausibility of claims and considered what the defense was asserting as a plausible government interest. At the pleading stage, the court did not make an acceptance of proof, it did not, weigh evidence, right? That was at the pleading stage. After the pleading stage, in discovery, we asked Coordinator Goins about this exact question. And we asked it in interrogatory. Discovery is the phase of the case in which defendants should disclose what, if any, government interests are at play, so that we could address them in this trial.
Okay, so then would it be fair on both sides if the court is gonna allow Mr. Goins to testify to alleged governmental interest, then to allow Dr. Birch, or should the court exclude both? Should the court exclude Dr. Birch from testifying? And if the defendants did not disclose any answers to those questions, and I'll give you a chance to go back and look at your interrogatories, but assuming that question was asked, and because this came up in the motion in limine, and there were several witnesses that said that they did not know of it, had no knowledge. Now, I don't remember any discussion about what Mr. Goins, in terms of his knowledge, but assuming that that was not answered, should the court exclude both Mr. Goins from testifying and Dr. Birch, or should the court allow both? I'm going to start with Mr. Missoula.
So our principal position is that there was no government interest asserted and disclosed in discovery. And
Okay.
therefore, it's not in the case, and that's our position in the motion to eliminate. If there's no purported government interest at play, then I don't see a reason why Dr. Birch would have to opine on it if it's not in play. But we're saying if it's in play, it can't be a one-way street where Dr. Birch doesn't have an opportunity to address it.
Makes total sense. So what do you think, counsel? Should it be allow both or exclude both? Because it can't be a one-way street.
Your Honor, we're fine at this point if they want to ask Dr. Birch these questions, and we'll have Coordinator Goins speak to the same government interests at that point. So to the extent that my objection is the operative thing here, I can withdraw that objection.
Counsel?
Yes, of course, we preserve our overall motion to eliminate, right, seeking to exclude the government interest, but understanding that the court is not ruling on that in this moment, then I'll proceed with Dr. Birch.
Well, I mean, we can't have it both ways, so I know, when you say you reserve it, I think that this comes down to what's fair. So if the plaintiffs did not disclose Dr. Birch's opinion with regard to governmental interests, correct? There was no disclosure.
Not with these specific ones that he just asked
Right.
about. Yes, Your Honor.
And the state did not disclose any answers or governmental interests in response to interrogatories. Either they come in or they don't. So if you want to, at the proper time, object to Mr. Goins testifying, then the court is not going to allow Ms. Birch to testify at this point. Now, if you want to have her stay and call her as a rebuttal witness, if that comes in, because we don't know what we're going to do with regard to Mr. Goins. So if there's not an agreement on the front end that it's all going to come in or it's not going to come in, and you want to reserve your objection, that's fine. But at this time, I would sustain the objection and not allow Dr. Birch to testify to a governmental interest, with the understanding that if there is testimony that comes in, if we do allow it, and we're not going to prejudge, but if we do allow it, then if you want to call her back as a rebuttal witness, it's only fair that she be able to testify.
Yeah.
So either Mr. Goins disclosed that, or he didn't. If he didn't, we still may let him testify to that. But then in fairness, it would only be fair to the plaintiff to allow a response to that testimony. Does that make sense?
Yes, Your Honor. If out of maybe perhaps practicality and given Dr. Birch's residence elsewhere, perhaps it makes sense to do a proffer of Dr. Birch's testimony such that she wouldn't have to return after Coordinator Goins is on the stand and this issue is resolved, whenever that may be, sometime tomorrow.
Well, we may be able to allow that. What time does Dr. Birch have to leave? Because we're going to work late this evening, so.
Yes, she was scheduled to go out this evening.
Okay, well,
I think
Counsel, do you have any objection to that? Once the testimony is completed for Dr. Birch, we step off the bench.
Yeah.
You make an offer of proof, we don't see it. We finish the case. Court makes a decision with regard to Mr. Goins' testimony. And then depending on what that may be, we can go back and revisit whether or not Dr. Birch will be allowed to testify.
Your Honor, that seems like an appropriate way to handle this scenario is with an offer of proof. I will note just for the record here, because we have discussed briefly what the interrogatory was and what specifically was asked.
Okay.
It's been brought to my attention. I have a copy of the interrogatory now. Unfortunately, not one to share with everyone, but just one for me.
That's
and
okay.
Defendant Goins objected to that response and had a procedural objection to that interrogatory that was made. So one of the reasons why that interrogatory was not answered is not simply just because we refused to state what a government interest is, but because there was a procedural reason why the the defendant in this case, defendant Goins, could not answer that question. And because of the procedural problem with that interrogatory, it was not answered.
What was the procedural problem?
Yes, Your Honor, I can read it here.
Okay.
I'll just read you our objection because I don't have time to paraphrase it in my head as we're going along here.
Okay.
So, the interrogatory seeks information beyond the scope of the court's October 11th, 2023 order, limiting discovery requests to the following topics: race, ethnicity, and conviction data, voting pattern data, or legislative history of the 1986 and 2006 versions of the challenged felon disenfranchisement statutes. That was our first objection, is that the interrogatory for just what is the government interest was beyond the scope of the court's order authorizing the discovery.
Okay.
And then we had a second objection as well. The interrogatory also impermissibly requests defendants to provide a legal conclusion. The General Assembly's government interest in enacting what was at the time 4029-204 is a legislative choice and is not subject to courtroom fact-finding and may be based on rational speculation, unsupported by evidence or empirical data. Since courts never require a legislature to articulate its reasons for enacting a statute, it is entirely irrelevant for constitutional purposes whether the conceived reason for the challenged distinction actually motivated the legislature. Additionally, we objected that the interrogatory request that the defendant Goins speculate beyond his personal knowledge as to the decisions of the General Assembly. And we finally objected, there was like 5 objections to this interrogatory, Your Honor, that plaintiff's characterizations of 4029-204 denies Tennesseans the right to vote. By its terms, 4029-204 does not deny the right to vote to any person who is qualified to vote in Tennessee. So there were 5 objections, and that's the reason the interrogatory was not answered. And there was never a hearing on a motion to compel on these where a interrogatory response was compelled from the defendants. We didn't violate any motion to order to compel by the court. So to say that we should be prejudiced because we didn't answer this interrogatory that we validly objected to would be fundamentally unfair.
If I may, Your Honor, just quickly on just the interrogatory point.
I'm sorry.
If I may, quickly on the interrogatory point.
Okay.
I don't have it in front of me, but I've looked at it in preparation for this. There is not an objection on the personal knowledge. There's a paragraph on personal knowledge where the response is, there's a litany of objections, which is common for ROG responses. And then it says, additionally, this interrogatory, I'm quoting, this interrogatory requests defendants to speculate beyond their personal knowledge.
Yeah.
So the response, the response was that it does not have personal knowledge. And then we asked Coordinator Goins and the 3002 witness, Ms. Henry Robinson, in their deposition, what are the government interests? And I can pull the cites from the deposition transcripts if you'd like to pull those up. And they said, we're not aware of any. We have no knowledge of any.
All right, so you said Miss Robinson?
Yeah.
And who?
Henry Robinson and Coordinator Goins.
Okay.
I may be mispronouncing the names.
So, counsel, let me just ask a question. We can drill this down. If they alleged that it was speculative, he didn't know, and then in his deposition he says he has no knowledge, does he have knowledge today?
Yeah, that's my question.
Your Honor, there's a fundamental difference between, is there a government interest out there that supports these laws, and whether there is a specific government interest that the legislature had in mind when they passed these laws.
But how are you gonna get that into proof? If Mr. Goins and, is it Ms. Robinson?
Henry
Yeah, I
Robinson.
just wanna make sure I had the name right. If y'all lodged all those objections that those two as witnesses is beyond their personal knowledge, is speculative, et cetera, how do you propose you're gonna get any government interest in the evidence? Because you're not gonna have them take the stand today and start testifying about government interest that they couldn't answer before, are you?
Well, Your Honor, we
yes
have
or
2
no?
different things here, and that's as I was just explaining.
So let's go to my question.
Yes, and
How do you intend to put on proof of government interest when the 2 witnesses, your representatives of your client, say they don't know?
I think it all depends on, Your Honor, the question that was asked of them, both in the interrogatory and the deposition.
So we're gonna parse out the wording of an interrogatory?
Yes, Your Honor, because interrogatories have to be specific. So if the question is, did the legislature have a government interest in mind at the time it was passing these laws?
Well, they don't know. They said they don't.
My clients don't know that. Okay. If the question is in the interrogatory or at the deposition, is there a government interest out there that does support these things? There are answers that can be had to that question.
How
and those
can
answers
they
that this
answer
court
if they don't
defines
have
them.
personal
Yes.
knowledge?
Excuse me, Your Honor. I'm
How are
sorry.
you gonna establish that they have a basis to answer that question?
Your Honor, I'm not the attorney.
Yeah,
that
you are
would be
the attorney.
Directing those witnesses, so may I confer with my co-counsel on how they plan on establishing that?
Well-
I mean, we've got a little bit of disconnect here between.
Yeah, okay, so, I feel like we're getting derailed here, but number one, they objected, okay, so there was a scope, a limitation of scope of answering, because we allowed additional limited discovery, right? There's a lot of water under the bridge here. It was limited. Apparently, y'all asked stuff that they said wasn't limited. Y'all never sought any motion to compel on that topic either, that I recall, any hearings on that, right? You just accepted that answer, that objection, and moved on, right?
So, to be clear, Your Honor, they have that objection, but then there's a substantive response that says additionally, Coordinator Goins does not have any knowledge of this.
Okay, yeah, but that's true, but did you seek any motions or clarification of what the missing gap here is in their answer that they're gonna try and bring up at trial?
We did not move, Your Honor, on that specific interrogatory. We followed
Okay.
up on it at the deposition. We did not move on that, and the reason I just stated is because there is still a substantive response following the objections. If they had said we refuse to answer on the basis of these objections, we would have moved to compel.
So what we have here is the defense is gonna pop up and try to introduce, I'm deducing here, proof of a government interest through people that said in their interrogatories they didn't have any knowledge of it. Am I forecasting that pretty well?
Your Honor, we first of all, we objected to speculation. I don't think that it's a substantive answer to say that something calls for speculation beyond someone's personal knowledge. But secondly, while to the extent that is a representation of the content of their personal knowledge, Your Honor, that we interpret this interrogatory as asking for the exact government interest articulated in supporting the legislature's passage of these laws, and not whether one does exist that supports these laws. And that is two different questions, Your Honor.
Well, then they would just be speculating if they don't have any personal knowledge, right? They would just be, we could all kind of come up with something.
Well, Your Honor,
But-
it all goes back to the case law and how these constitutional challenges are handled.
Okay.
The
Why didn't they just answer the question?
Because
in
we
terms
had
of-
a laundry list of objections to the questions, Your Honor. That's why the question was not answered.
But they answered the question, but they said they didn't know what the governmental interest is. So now they're saying, well, we don't know what the government, they are the government. So we have the legislature, then we have the executive and judicial. There's a governmental interest. So maybe not knowing necessarily what the General Assembly intended, but in terms of the governmental interest.
Your Honor, I think this fundamentally goes back to the way that constitutional challenges in these cases are handled. The question is not what is the legislature's specific interest that they had in mind at the time that they were passing this law. A law can be justified by governmental interests that are outside of anything contemplated by the legislature in the legislative history or in the legislative record. I point Your Honors to the City of Memphis versus Hargett case, where a very similar issue came up, and the plaintiffs in that case argued that the defendants did not put forth specific proof of an exact governmental interest that supported that exact bill that was passed in the legislature. And the court said that the state doesn't have to do that, that it can be determined as a matter of law. The state, Tennessee Supreme Court cites a laundry list of cases there that all found as a matter of law that the government has an interest in maintaining election integrity, as this court has already found in its law of the case.
And was that under a rational basis or strict scrutiny analysis?
Your Honor,
Because
the City of Memphis versus Hargett was a strict scrutiny analysis.
Okay. All right, so then why is there a need to call Mr. Goins then to testify if the state's position is you don't have to put on any evidence of that?
Your Honor, Defendant Goins has more knowledge about many more things than
Yeah.
just this one
Well,
piece of
this comes down to
governmental
whether or
interest.
not we should allow the testimony of Dr. Burge based
Yes,
on
Your
what,
Honor.
right, so, again, either the state's gonna put on that evidence or they're not. If you're telling the court that they're not gonna put on that evidence, that they don't have to, that Mr. Goins is not gonna testify, then we're gonna exclude the testimony of Dr. Burge.
Your Honor,
But we can't have it both ways.
I understand that we
Okay.
can't have it both ways, and so our position is that we will call Dr. Goins, and we will have that testimony, and that's why We're fine with Dr. Birch going
All
ahead
right,
and testifying.
and you know that there's gonna be an objection, so we're not saying at this point that it's gonna come in, we're saying that they're gonna raise the objection.
Yes, I understand.
But
that.
in the interest of Dr. Birch, how do you suggest that we handle Dr. Birch's testimony with regard to governmental interest?
Your Honor, your suggested method earlier of the offer of proof is, I think, a good procedure.
Offer proof? Okay, we'll take an offer of proof at the end.
Yes, Your Honor.
Okay, thank you so much.
No more questions besides your offer of proof later, Your Honor, Your Honors.
Okay, so that concludes your testimony, your questions for the witness?
Correct. We'll do that offer of proof, I presume, later, after the cross, is that correct?
Yes.
Yes, so
That
that-
concludes your direct?
Yes.
Okay. All right, cross-examination.
Yes, Your Honor.
Okay.
One brief moment for me to get a sip of water.
Okay. I think we're all gonna get some water, huh?
We just did a lot of talking there, didn't we?
And tell me your name, counsel. I keep saying counsel. Repeat your name again for me.
Yes, Your Honor. Zachary Barker from the Office
Mr.
of the
Barker,
Tennessee Attorney
okay.
General.
All right, very good. Okay,
Yes.
Mr. Barker.
Good afternoon, Dr. Birch. My name is Zachary Barker. As I just said, I've got a few questions for you now. I want to make sure that we're talking about the same things while we're going through this. So let's begin with talking about some of the terms that you used in your expert report. The franchise is the ability to vote, right?
I think that, since you asked it that way about being precise, I think I use it to talk more about, I may use it interchangeably with the ability and the right.
Okay. So a person who can vote is a member of the franchise.
I think I would say is enfranchised.
Okay. A person who can vote is enfranchised. Am I saying that correct? I want to make sure that we're on the same page.
Yes.
Okay. Disenfranchisement means taking away a person's right to vote, right?
Yes, generally.
And some people say that disfranchisement, some people say that disenfranchisement and add two more letters, but that's the same thing, right?
Yes.
Okay. So, in other words, when you're disenfranchising someone, you're taking away their right to vote.
They can no longer vote, that's right.
Then there's the term re-enfranchisement, right?
Yes.
And re-enfranchisement is adding someone back to the franchise, correct?
I'm just gonna check my report
Sure.
to see how I use it here. Is there a specific place in my report that, you wanna ask me about?
No, I'm
where
just
I use
talking kind of
re-enfranchisement?
generally here. I know you use that term in your report, but
Okay.
re-enfranchisement is the concept of adding someone back to the franchise, right?
So the reason I ask that is that I think it's not just that. So, I have a phrase here in my report called rights restoration, which, can either be, automatic or you have to go through a process. So I don't want it to just be, so I'm not sure if you're asking about that or something specific in my report.
I'm not getting that specific yet.
Okay.
I'm not getting that specific yet. So let's just talk about re-enfranchisement just kind of generally is the idea of adding someone back to the franchise, right?
So I think about that as giving someone back the right to vote.
So you might call that voting rights restoration then.
Under some circumstances.
Okay. Then now let's take these terms that we've talked about and let's put them in the context of Tennessee then.
Okay.
Felony disfranchisement is the taking away of the right to vote due to a felony conviction, right?
Yes.
And Tennessee has felony disfranchisement.
Yes.
Every person convicted of any felony in Tennessee since 1981 loses the right to vote.
Objection. Calls for a legal conclusion.
Counsel, does it call for a legal conclusion?
No, Your Honor, it doesn't call for a legal conclusion. Dr. Birch just testified on direct examination about disenfranchisement, reenfranchisement, the effects thereof. We're just asking her understanding of who's disenfranchised and how.
Okay, well, the question included 1981, and it's somewhat specific. So she's not qualified as a legal scholar or a lawyer, political science. So would a political scientist know what the law was in 1981 with regard to disenfranchisement?
Your Honor, I can rephrase the question, I
Okay,
think,
and it
too.
was just the 1981.
Yes, I can
Okay.
I can rephrase that. Dr. Birch, at the time you were writing your report, every person who committed a felony, any felony in Tennessee, lost the right to vote, right?
So what I have here specifically in my report is, according to the Secretary of State, and I cite the website, in Tennessee, all people convicted on or after May 18th, 1981 lose the right to vote upon conviction of a felony by any authority, including those outside of Tennessee. So I'm not making an independent determination there, I'm just citing.
You cite to the Secretary of State's website,
Yes,
and that source that you used says that anyone in Tennessee convicted of a felony loses the right to vote.
yes.
And Tennessee is not the only state with felon disenfranchisement, are they?
No.
48 states have felony disenfranchisement?
Specifically in my report, I do talk about, yes, so, 48 states do ban voting because of felony convictions. And then I go on to talk about, 23 states, people lose their right only while they're in prison. 15, voting is restricted for anyone who's in prison or on probation or parole. And then they get automatic restoration. And then actually Tennessee is one of 10 states as an outlier that prevents voting among people even after they finish serving.
Thank you for that extra information, Dr. Birch, but let's go back to my question, really straightforward here. 48 states have felony disfranchisement, right?
Yes, they do have some form of it.
And Tennessee also has reenfranchisement or restoration process.
So Tennessee, because they don't have automatic restoration, has to have a so Tennessee, because they don't have automatic restoration, has to have an application, a further process afterward. So almost all states have a restoration process, but Tennessee is the one that requires additional steps.
That's a yes to my question.
So I'm saying like yes, and but it's still an outlier.
That's a yes, they have a restoration process.
Yes.
And you referred just now to that restoration process as additional steps for getting the right to vote back, right?
Yes.
And 10 states, including Tennessee, have a process requiring additional steps, don't they?
Yes.
And in Tennessee, some felons can be reenfranchised, right?
Yes.
And some felons cannot be reenfranchised, correct?
That's my understanding.
Let's talk a little bit about your personal opinion here. You don't know if felon disenfranchisement is right or wrong, do you?
No, I don't make that determination.
But you think at some point people should be able to participate in elections and regain their voting rights, right?
I do.
Even murderers?
Again, it depends on the circumstances. I don't really have any differentiation by crimes or anything of that nature.
Even murderers who are still in jail, they should get to vote.
Again, that's the determination of the legislature. I don't know.
I'm asking you, your personal opinion. Should they be allowed to vote?
I don't know.
Rapists?
I don't know.
People that deceive the government by tampering with evidence?
Again, I don't know.
What about people that committed voter fraud and cheated in elections?
I don't know.
So you just don't have an opinion on whether people should be allowed to vote or not?
Again.
Okay, I'm just, hang on a second. Is this a personal opinion or a professional opinion?
Your Honor,
Because
it goes to her.
Hang on, just
Yes.
a second, hang on. Your question was her personal opinion. Her personal opinion is not helpful to us. So did you mean her professional opinion within the context of her expertise, or are you just simply asking for her personal opinion?
Your Honor, I'm exploring this witness's bias, which is allowed under the rules of Tennessee evidence. She has been, for her entire career, writing reports and documents on felon disenfranchisement, and I'm simply probing to see.
Okay, so you're asking about her personal opinion.
Yes,
I just
Your
wanted
Honor.
to make sure, okay.
Yes, Your Honor.
All right, very good, go ahead.
So, in your personal opinion, you just don't have an opinion on whether these people should vote or not?
No, as far as like the kinds of things you would think about if you were thinking about it personally as far as professionally, no. I actually go back and forth on it, so I don't really know.
All right, I want to go over your methodology a little bit for how you arrive at your professional opinions in this case. We're moving on from the personal ones. You did a literature review, right?
Yes.
And you picked pieces of work to review.
Yes.
No one gave you articles or documents to review?
I don't think so.
So you got to pick pieces of work on the harm of disenfranchisement, right?
Yes.
And you specifically characterized them as articles on the harm of disenfranchisement, didn't you?
Can you show me exactly what you mean?
Yes, I can. In your report on page 3,
Mm-hmm.
in the first paragraph there, scope of the report, you said, I was asked by counsel for the plaintiff to review the literature on felony disenfranchisement with respect to the harm of felony disenfranchisement.
Yes, that's what they asked me to do.
All right. You reviewed pieces of work of other folks, right?
Yes.
You reviewed your own work because you have so much.
Yes.
You even cited some of your past work in your expert report.
Yes.
And you reached conclusions based on those pieces of work.
Yes.
You put those conclusions in your report, right?
Yes.
But you did not survey Tennesseans independently, did you?
No.
You did not survey Tennesseans with felonies?
No.
You didn't survey Tennesseans with felonies asking if they had ever sought restoration of the right to vote?
No.
You didn't survey Tennesseans with felonies even asking them if they wanted to vote?
No.
You didn't interview any individual Tennessean with a felony, did you?
No.
You didn't speak to a Tennessee felon who had sought restoration of voting rights?
No.
You did no statistical analysis on disenfranchised Tennesseans?
Not for this case, no.
You didn't even interview Ms. Moses, did you?
No.
You don't know if Ms. Moses can or cannot be re-enfranchised?
No.
You're not offering any conclusions about Ms. Moses?
No. I think I only mentioned her once or twice in the report.
And you weren't asked to address anything specific to Ms. Moses, were you?
No. Again, I think I only address her specifically with respect to the psychological effect.
Well, let's turn to your opinions. You reached 3 opinions in this case, right?
Yes.
First, you opine numerous studies support the conclusion that felony disfranchisement policies detrimentally affect individuals and communities, correct?
Yes.
And let's break that down. You specifically use the term felony disfranchisement, right?
Yes.
And that is the removal of the right to vote, right?
Yes.
You did not use the term re-enfranchisement.
No.
You did not use the phrase voting rights restoration.
Not in that line, no.
You use the term, and you conclude that the policy of taking away the right to vote detrimentally affects individuals
That's right.
and communities.
Yes.
48 states take away the right to vote when a person is convicted of a felony, right?
Yes, they do.
And you think that those 48 states have chosen a policy that you say is detrimental?
Yes, to individuals and their communities.
Well, let's talk about those individuals then. You reached an opinion on the effect of disenfranchisement on individual people, didn't you?
Yes.
And your opinion is all about disfranchised people, right?
Yes.
And all disfranchised people,
Yes.
not Tennesseans.
I think my arguments are applicable to Tennesseans, yes.
But you're not making a Tennessee-specific opinion here, are you?
No, I think that this is the statements I'm making about stigma and the like are broadly applicable.
And you're not limiting your opinion to only people of upper socioeconomic status, are you?
Hang on a second. Just a minute. So there is a point here, for instance, that I do talk about at the very beginning on page 4. I think I do talk about some financial burdens, such as legal financial obligations and the like, that are related to socioeconomic status.
But your opinion is not specific to one socioeconomic class, is it?
It is with respect to, it's more applicable for people who have certain financial constraints, yes.
Let's back up.
Okay.
Your broader opinion, that it has you have an opinion that it has a detrimental effect, right?
Yes.
And you would say it has a detrimental effect on people of a higher social class?
Yes, but in some instances, especially the part about legal financial obligations, to the extent that that matters for reenfranchisement, yes, that's going to be a differential effect.
Sure, but there would also be a detrimental effect on people of a lower economic class too, right?
Yes, but it would be worse.
Sure, but there's a detrimental effect on both, is what you're saying.
Yes, but you asked me if I had any distinctions by socioeconomic status. I'm telling you yes.
Let's talk about other distinctions. You don't make a distinction specific about the detrimental effects to one race or the other being worse, do you?
So, just a second. So yes, on page 8 in my report, I do talk about African Americans in Tennessee having worse effects.
I understand, I think you were talking about the communities there, right, for African Americans in that section?
So this is individuals as well. So African Americans as a group tend to have disproportionately high disfranchisement rates. And then I'm also in that same paragraph talking about the community concentration. So it's both the first part here is about Tennessee and the high rates of missingness, which I would say is like the individuals, and then it goes on to talk about communities in that paragraph too.
Let me phrase that a little bit differently.
Okay.
You're not saying that felony disfranchisement only detrimentally affects one race, right?
No. I'm saying
It detrimentally affects, sorry, I didn't mean to cut you off, go ahead.
Okay. No, but I am pointing out that, again, because these are negative effects overall, and then that there is a racial gap, that it's worse for one racial group.
And you're not saying that it affects one gender detrimentally, but not the other, are you?
No, I'm not saying that.
And you did not divide disenfranchised felons into those who can or those who cannot get their right to vote restored, do you?
No, I think the statements I make here are pretty clear, but actually, for instance, the statement I make on page 5, the denial of civil rights such as voting, quote, deprives a person of his civic personality and social dignity and demonstrates society's indifference to his interests. And so, again, that factor is of that stigma does affect people differently, depending on whether they can come back, whether they can be successfully reintegrated. That message about whether they can be successfully reintegrated.
You also talk about effects on communities, right?
Yes.
And that's what your own study's about, isn't it? Trading Democracy for Justice?
Yes.
And you cite your own study.
Well, yes.
And that study looks at North Carolina.
Yes.
It looks at Georgia.
Yes,
It looks at Florida,
yes.
not Tennessee.
No, I cite other research for the community supervision on Tennessee, and it's consistent with what I find in my work for those states.
And when you're talking about the effects on communities, you mentioned this idea of prison-based gerrymandering.
Yes.
You did not analyze Tennessee's elective districts to see if prison-based gerrymandering was occurring, did you?
I'm sorry, I missed the last part of
Sure.
wording your question.
You did not analyze any Tennessee elective districts to see if prison-based gerrymandering had an effect in Tennessee, did you?
No.
In your report, you don't cite any studies of Tennessee data to support the idea of prison-based gerrymandering, do you?
Just checking really quickly. No.
And you did not independently audit the data of any of the studies that you cite, did you?
No, I didn't go back and reanalyze any of them.
Now, you mentioned on direct examination that there are communities with high numbers of disenfranchised people in them, right?
Can you be more specific?
Just, you mentioned on direct examination
Okay.
that communities exist with high numbers of disenfranchised people, right?
Yes.
Those same communities have a high number of felons, don't they?
That depends on what you mean by felons. So, in some places, such as Tennessee, there's going to be people who aren't currently serving a sentence. So, people who've been formally incarcerated or formally convicted.
Let me be more specific.
Okay.
Those specific communities will have high numbers of people convicted of a felony in Tennessee.
Yes.
Let's talk about your second opinion here. You say that political science literature supports the conclusion that requiring individuals to apply to have their voting rights restored after a felony reduces voting participation post-discharge, right?
Yes.
But you didn't talk about that on your direct examination, did you?
No, I mentioned it though.
You mentioned it. Okay, well then let's talk about it a little bit here. Having to apply is the additional steps that you talked about.
Here in particular, I was discussing the process. Sorry, I'm going back really quickly. So I was discussing, I think, the process that was in place when I was writing that included submitting, I think, a certificate of restoration as well as going to court for rights restoration, to file for rights restoration, I think.
And you admitted on direct examination you've taken a look at that new process that came after your report was filed, right?
Yes, I haven't studied it in depth, but I am familiar.
And are you familiar with it enough to know that a felon has to petition a circuit court to get their rights restored now?
I don't know the exact court, but yes, that they do have to go to court.
And the coordinator of elections, excuse me, that was word salad there. And the coordinator of elections no longer has a role in that process, does it?
Objection, calls for legal conclusion.
Mr. Parker?
Your Honor, she's talking about all the steps of the process and what people have to do to get their rights restored. She analyzes it in her report, and we're just simply asking her if the coordinator of elections has a role in that process. We're not asking for a legal conclusion here about what the law requires, but just whether she knows if he has a role or not.
I believe counsel asked whether Coordinator Goins has any role in the process. Dr. Birch has already testified that she's not offering an opinion on the amended law that was passed late last year and did not provide an analysis on that. So it's outside the scope and is asking for legal conclusion.
Mr. Parker?
Your Honor, we're just simply asking if she's familiar with this. It's not
I know.
outside the scope. They asked about the 2025 laws on their direct examination.
Not outside the scope? Is it not outside the scope?
I only mentioned about the 2025 laws to say that whether it changed her other opinions, but not on the new restorations statute and system. So she provided no testimony on the post-amended law as it currently stands and the mechanics of how that law works.
Is there an opinion provided in her report?
Not on the post-2025 amended law.
Okay,
This
so,
report was prior to that.
So what would be the relevance if it's not in her report, if she didn't testify? How is
No,
that not out,
We'll withdraw the question.
not outside the scope? Okay,
We'll just strike the question from the record.
okay.
You also reference a study from Meredith and Morse from 2017 on page 17 of your report, don't you?
I do.
And that study found that only 3.4% of a random sample of Tennessee felons have ever applied for voting rights restoration, right?
Yes, but I should say what their population is the full, group of people. I don't think they were able to account for, what's the word I'm looking for? The satisfaction of the requirements.
And under that old process, you say that, because this was in, let me strike that, or get this straight. That report was from 2017, right?
Yes.
And that was 9 years ago.
Yes.
Different process than what happens today, right?
Yes.
Okay. But even under that old process, application rates varied by race and gender, didn't they?
I believe so.
But they were relatively low for all groups.
Yes, because again, they are not looking at the eligible population, they're looking at the entire disenfranchised population. They couldn't calculate the eligible population. So, just to explain further what the distinction I'm making there is, I don't think they can fully calculate things like who had paid all their legal financial obligations, like satisfied all the requirements for reenfranchisement. So that's the overall number, not the estimate of the number of eligible people who had applied.
And you look at voting participation pre and post discharge, right, in the report?
Can you point me to what you're talking about?
I think it's right after that reference to Meredith and Morris in 2017, I think on page 7.
7?
17.
Oh, there's nothing, that last line is, that's like the last line of the report.
Sorry, it's not there. Let me just ask generally about this. If a person can't get their rights restored, their voting participation is going to be 0, isn't it?
Yes.
Okay. Let's move on to your third opinion here. Your third opinion is that the findings of research and political science and other disciplines do not support the claims that felony disenfranchisement incentivizes individuals to complete all terms of their sentence, nor does the research support the claim that such laws eliminate arbitrariness in the franchise. That's what your report says, right?
Yes.
But you didn't talk about that specific on direct examination, did you?
No, I did not.
Okay. I want to talk about an instance from Tennessee that you note in your report. You mentioned that there were 11 people that were convicted of voter fraud in Sumner County, Tennessee. Do you have knowledge of that?
Can you point me to the, yes, I see it. It's on page 15.
On page 15, yes, we're on the same page there. They were ineligible to vote because of a felony conviction, right?
That is, yes, that's what they were accused of.
All 11 pled guilty,
Yes,
and all 11 admitted that they voted illegally then, right?
yes.
I'm sorry, what was that last question?
All 11 admitted that they voted illegally, right?
Can I back up on that answer? I don't actually write here what they said. I have here all 11 pled guilty to related charges, so I don't know exactly what they pled guilty to.
Thank you, Dr. Burge. So we just talked about people pleading guilty to voting illegally. So let's talk then about what you call verification extremism in your report. You define verification extremism as requiring applicants to meet large numbers of requirements to prove their eligibility for a program, right? That's on page 11 if you're looking.
Yes, I see that.
And for voting, that would be proving their eligibility to vote. Right?
Proving their eligibility for,
Voting.
yes. In this case, though, I think, or for the reenfranchisement policy as well.
So this idea of verification extremism is that some states try too hard to make sure that felons are eligible to vote.
So what I have here is the exact definition of verification extremism is it involves compliance costs that require applicants to meet large numbers of requirements to prove their eligibility for a program that in ways that can lead to the erroneous denial of benefits, lengthy delays, and even invasion of privacy. And then I go on to talk about how some administrative requirements may be expensive, difficult, or impossible to meet. So that's the definition of verification extremism.
So you think that some states ask for too much documentation to verify whether someone's eligible to register to vote?
I'm talking, yes.
But surely you're not saying that states just have to take felons for their word that they're eligible to vote and sign them up, right?
No, what I'm saying exactly is, so say for instance, you have a requirement that someone has to pay all their legal financial obligations. And then they have to provide documentary proof. There may not actually be documentary proof that someone paid a legal financial obligation in 1984. I don't have, well, I was only 4, but I don't have canceled checks from, 1990 and things like that. And so even though requirements may seem, reasonable on their face, the actual work of trying to go about fulfilling them is difficult or even expensive for people to be able to meet. It may require flying to a county where you were convicted and on the hopes that they actually have the records from 20 or 25 years ago to be able to provide you with that documentary proof. So that's the kind of thing I'm talking about in that section.
And that's a yes to my question.
I think you asked me what verification extremism was, and I was telling you that actually, no, that's not what I...
No, Dr. Burks, that's not what I asked.
Okay.
I asked you.
Mm-hmm.
You are not saying that election officials just have to take the word of a felon that they are eligible to vote, are you?
Oh, and then I said no. Instead, I'm saying something else.
Thank you. You disclosed no specific examples of what you call verification extremism in Tennessee in your report, do you?
So hang on for a second. Other than the discussion of just giving the list of administrative requirements such as birth certificates or payment receipts. So I do mention the payment receipts there.
You disclose no specific examples of what you call verification extremism in Tennessee in your report, did you?
No, I'm just speaking here generally about payment receipts.
And you didn't analyze whether Ms. Moses is struggling with verification extremism, did you?
No.
Your Honor, 1 moment to confer with co-counsel. Your Honor, there's no further questions at this time.
All right, thank you, Mr. Barker. Redirect, Mr. Mazzella?
Nothing
Mr.
further,
Mazzullo?
Your Honor.
No redirect.
Correct.
Okay, all right, well then I guess this is a good time to make the offer of proof. It's 4:26. So let's go ahead and make that, and then we will probably recess for dinner. Now, have you spoke to all the attorneys and everyone understands what we're doing in terms of the scheduling?
Yes.
Okay, in preparation for our inclement weather. Is there anyone in the courtroom that's not aware of what we're doing in terms of scheduling?
Your Honor, I'm aware of what we're doing, but I
Okay.
do want to note to the panel that I have another obligation in Shelby County to meet with another client of mine at 6:30, so
Okay.
I may be absent, but the rest of the team's
Okay.
here to handle it.
Well, we will be happy to excuse you.
Yes, sir.
And
Okay.
There was a hand from.
Court report?
I'm just not aware, Your Honor. if it was-
Oh, I'm sorry, okay, and you're one of the most important people.
I can stay, it's no problem, I just don't know.
Okay, okay. Well, we're expecting inclement weather on Friday, so we're gonna try to work late this evening and then late tomorrow in an effort to finish, hopefully. So the idea was that we would take an hour, well, about an hour and a half for dinner, and then come back and work a couple hours, however long, and we'll stop at a good stopping place, and we'll try to do the same tomorrow. Hopefully, we can finish tomorrow. Now, if not, we may have to come back just briefly Friday. We're hoping that we can get through all the proof and closing statements tomorrow. If not, we were thinking maybe come back for an hour on Friday morning. Not opening statements, closing statements. Be done by 9 or 9:30 so that everyone who has to travel can beat the weather, hopefully. So, yes.
To avoid surprise,
Yes.
I promise to keep it short, it's almost an appeal issue. There's gonna be a Rule 42.02 motion. I don't plan on spending 3 hours arguing the case, I just need to make sure the grounds are out there to preserve them.
Okay, when you say it's gonna be an appeal issue, what do you mean?
I think there are some cases that say if the 42.02 motion isn't made, that you waive some of those.
Oh, okay, no, oh, yeah,
I just
okay.
wanna make sure that-
Oh, no, we'll
I
allow.
don't plan on doing the whole 3 hours,
Yes.
I expect it to be a minute and go home.
Okay.
But I'd like to get the things out.
Well, listen, we said in chambers that even though we are hoping on this schedule, we want all the attorneys to fully put on your cases, so there's to be no misunderstanding. So, we're not asking you to abbreviate your proof, to limit any proof. No, please, you all have worked very, very hard. So, we're gonna do our best that we can, right, Judge?
Absolutely.
We're gonna do the best, but if we don't finish and the storm comes in, then we will deal with it, okay?
Last thing.
Yes.
Coordinator Goins has been dealing with a medical issue for the last week and a half or so.
I'm sorry to hear that.
He has put off a surgery to be available here. That may yield two things.
Okay.
One, during his testimony, he may just need to get up and walk around every so often.
That's fine, absolutely.
And two, he doesn't want the court to think it's disrespectful, but when his testimony is over, he may not be here much longer.
Okay. All right, well, we'll be happy to excuse Mr. Goins, and we appreciate him coming in and making himself available. So whatever we can do, sir, to accommodate you, we will definitely do that, so,
It's a kidney stone,
okay.
and so
Yeah.
if it hits, I'm just gonna have to take a break.
Okay, well, if it hits, you do what you...
News to tell.
Well, I've never had them, but I hear they're very painful, so, okay.
Yeah, I may look miserable, it's not miserable to you all.
Okay, all right, very good.
Oh, you say that to all the judges.
Did you hear Judge Cook?
I did not.
I
Okay.
was just joking.
Okay, well, we're gonna step off. Please
put forward as a government interest?
They have some language about that people who've been determined to be permanently disqualified or unfit for the franchise, and some language about preserving the integrity of elections.
In your research and work, is that language about being, quote, unfit, something you have heard before in defense of disenfranchisement?
Yes.
Is there anything in your report responsive to this purported government interest?
Yes. So, for instance, I do talk on page 5 about stigma and the importance of excluding people from the franchise, and the denial. And specifically, I cite Judith Sklar, who was a famous political theorist, who talks about how the denial of suffrage is an important marker of social standing, and that to not have it is basically the kind of thing that acts to exclude people from the polity. And so in this paragraph, I talk about how the deprivation of voting rights sends messages of political and social exclusion. And those messages, here I specifically talk about it with respect to efforts to reintegrate in society, but it's also the kind of giving the message that you can never reintegrate. It's a permanent marker of distancing the citizen from here Sklar refers to as the inferior status.
Were you surprised that this was raised as a government interest when you heard it?
Yes.
Why?
Because when
Objection, for the record, objection to speculation and improper opinion, surprise.
Why?
I was surprised because typically when I've come across terms like unfitness, specifically unfitness for self-government, in my work, it's usually being used in a context that relates to marking certain kinds of groups as being unable to have the franchise because of their personal characteristics. And that could be related to certain racial groups. For instance, this language was used in reports to basically talk about the fitness for self-government for certain racial groups, not just including black people and Asian people and people you consider non-white minorities, but also certain classes of immigrants like Southern Europeans and the like, Italians, Sicilians, and the like.
Are you able to give any specific examples?
Sure. So the one example is from the Dillingham Commission report of 1911, in which it's a report commissioned to the U.S. Congress that talks about the specific fitness of self-government for different kinds of groups, and again, different kinds of racial groups, and whether or not they can be admitted as immigrants or should be admitted as immigrants because of this idea of fitness for self-government. There's also some pretty famous books that have won the National Book Award and other kinds of national prizes that talk about this issue, like Alex Kasar's The Right to Vote, as well as Matthew Fry Jacobson's Whiteness of a Different Color.
What about the language about maintaining the, quote, integrity of elections? Is that something you have heard before in defense of disenfranchisement?
Yes.
And is there any empirical literature that is relevant to whether disenfranchisement laws promoted interest in the, quote, integrity of elections?
Yes, there's some empirical literature. Generally speaking, there are, I put this kind of in the class of books and articles that look at the relationship between the restrictiveness of voting laws and how people think about elections in a particular place. And typically, the actual election laws in a place aren't related to whether people think elections are fair or have integrity or whether there's voter fraud or not. The literature shows that's more driven by elite messages than it is about actual voter laws in the place where the person lives on the ground.
Are you aware of any empirical literature that supports alleged, quote, unfitness or, quote, integrity as legitimate government interests?
Empirical literature, I can't, none comes to mind.
Nothing further.
Judge Birch, opposing counsel just asked you if you were aware of any literature finding that integrity of elections is a legitimate government interest, right?
Objection. This characterizes the question.
Let's have the court reporter roll it back then. Court reporter, read the last question that opposing counsel asked, please.
Yeah, I believe it was empirical literature.
Did you hear that question, Judge Birch?
I did?
Is that the question that he just asked you?
Yes.
Are you aware of any court opinions that have stated that maintaining integrity of elections is a compelling government interest?
Yes, one comes to mind. It's from, I think it's either from the 1870s or 1880s, which I think was maybe would have been the first one, in Alabama that talks about that as a government interest. And I believe it was justifying disenfranchisement laws in the it was Alabama's 1875 Constitution. It was something like that. And then
Would it surprise you if the Tennessee Supreme Court had held that in 2012?
Again, it may have.
Objection. Call for a legal conclusion.
You can answer. Go ahead.
Again, it may be, but I was asked about empirical literature.
Okay. Let's talk a little bit then about the idea, opposing counsel talked to you about unfitness for voting. Sorry, excuse me, I have to flip through my notes here. Tennessee has felon disenfranchisement, right?
Yes.
And so the disenfranchisement part is based on committing a felony, right?
Not exactly.
Well, the conviction of a felony, let me put it that way.
Well, so obviously, there are some people in Tennessee who've committed felonies who have the right to vote because you have like a grace period and some other stuff, so I think, right?
But currently in Tennessee, a felony is what causes losing the right to vote.
If you get convicted today.
Yes, I said currently.
Yes.
So it's the conviction of the felony that's the operative thing that causes the disenfranchisement, right?
If you get convicted today, but not for the whole pool of people who've committed felonies.
It's not any specific characteristic of a person.
Just when they committed the felony.
Right, but for instance, it's the commission of a felony that causes someone to lose the right to vote, not the fact that they're bald, is it? So if a bald man gets convicted of a felony, is it because he was bald and loses the right to vote? Is it because he was bald, or is it because he committed a felony?
So the reason I'm hesitating, actually, is I have a real reason for hesitating. And the reason I'm hesitating is because it actually does relate to age, but not baldness in particular. So older people, because of the timing of the way the statutes are written, if you're old enough to have committed a felony in a certain date, you're less likely to be disenfranchised than a more recent person. So there are some personal characteristics that are more correlated because of the personal characteristics like age. So that's one that I want to.
Let's do a hypothetical, Dr. Birch.
Okay.
I'm bald, right? You can see me?
Yes.
I'm bald.
You have some hair.
Well, there's not much. Well, I consider myself bald, right?
All right.
If I commit murder and am convicted of murder, right, I would lose the right to vote in Tennessee.
Yes, if you committed that murder today.
And I wouldn't be able to get that right back, would I?
No, not if you committed that murder today.
And I wouldn't lose my right to vote because I was bald, right?
I'm saying that is true for baldness.
I would have lost the right to vote because I was convicted of murder, right?
Okay, so this is great. So the distinction I'm making for your hypothetical is,
Let's answer my question, Dr. Birch. I would lose the right to vote because I was convicted of murder, not because I was bald, right?
not because you were bald, because you were convicted of murder. But that's true for that particular instance of the hypothetical.
And you think that it's not appropriate for the legislature to say that someone who committed murder should not be voting?
So I'm not opining about whether it's appropriate or not. But again, I don't think that's the opinion I'm offering.
Okay. One moment. That's all that I've got.
Nothing further.
All rise. back in session, maybe see you.
Okay. Okay, we ready to get started?
Yes, Your Honor. One or two preliminary things before we call our next witness. The counsel for the parties spoke over the break. We had suggested, came to a suggested agreement, pull that down. Came to a suggested agreement around both ending the case. We had talked about closing arguments, and I know this came up at the pretrial conference. Both parties have agreed, depending on the preference of the court, given that we're going to be doing post-trial briefing, we would be happy to waive closing arguments given the time constraints we're under and given the post-trial briefing. So wanted to tell that to the court. We're in agreement that if the court is okay with that, we're happy to waive those. In connection with that, thinking about the schedule for post-trial briefing, what we've decided or would suggest to the court would be set a deadline for post-trial briefing of findings of fact and conclusions of law 45 days after receipt of the trial transcript. The idea would be when we get the trial transcript, one of the parties will file a notice with the court to say trial transcript has been received, and then that will start the 45-day clock. And we wanted to just put that in front of your honors to consider, given that we just talked about it.
Okay.
And with that, plaintiff calls its next witness, coordinator and defendant Mark Goins.
Okay, good evening, Mr. Goins. Yes, good evening, sir. Okay, please, you have your right hand raised. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? Thank you. Please, come have a seat. Make yourself comfortable.
Or stand up if you need to.
Yes. Whatever your preference.
Thank you.
Okay.
And your honors, before I start my questioning, I'd like to ask permission under Rule of Evidence 611, since Mr. Goins is an adverse party. Rule 611 allows me to cross-examine, even though I'm calling him.
Okay.
Thank you, Your Honor. Could you please state your name and spell it for the record?
Yeah, Mark, M-A-R-K, last name Goins, G-O-I-N-S.
And what is your position in the Department of State?
I'm the coordinator of elections for the state of Tennessee.
And is that, do you oversee a department called the Division of Elections, is that right?
So the Secretary of State has different divisions, and we are the Division of Elections, correct?
Okay, and do you mind during my questions today if I refer to the Division of Elections as the division? Is that okay?
Yeah, yes, I mean, so, yes.
I'm happy not to if it'll be confusing.
That's fine.
Okay.
I just want to separate, so there's a state election commission as well, and they're separate. They're an independent entity, and if you were to ask a state election commissioner, they might also say we're part of the Division of Elections, but they're not. I'm not trying to be tricky. I'm just, some of the state election commissioners, they're independent. They like to be independent.
Understood.
And they should be.
Well, then let's focus a little bit on the job of the coordinator of elections. We're going to take a look at what was previously admitted into evidence as Exhibit 47. And we'll get that up on the screen, and then I need Exhibit 47 so that the witness can take a look at it. I'm sorry, Trial Exhibit 47. So it is, sorry, I believe it's Plaintiff's Exhibit 65.
Oh, no.
There you go.
Which one?
It's Trial Exhibit 47, I believe, but it was
Okay.
pre-marked as Plaintiff's Exhibit 65. And just for the record, this is the third supplemental declaration of Mr. Goins.
47. Well, that's my copy. Yeah, do you have, okay, that'll be better. Thank you.
And Mr. Goins, you have a copy of Trial Exhibit 47 in front of you?
Yes.
Take a quick look at that, and if you will just confirm for me that this was a third supplemental declaration that you submitted and signed in the federal felony disenfranchisement case in Nashville.
It is.
Okay. I want to take a look at a few paragraphs just to help us understand the role of coordinator of elections. If you'll take a look at paragraph 3, and you see there, you note that you serve as the chief administrative election officer of the state, and your statutory duties are set forth in Tennessee Code annotated 211202. Did I read that right?
Yes.
And in this declaration, you also say, among other things, you are statutorily charged with the following duties. And in the
Your Honor, we're gonna object, and it's just to get a read on how this objection is gonna go, because it's gonna come up a lot. Well, Mr. Goins is an attorney. The one-word objection calls for a legal conclusion. He's
Okay.
discussing very specifically what a statute requires.
Calls for a legal conclusion. Okay, well, these are his statutory duties, though. These are his statutory duties.
Understood.
Overruled.
So you list 3 here in paragraph 3. Prepare instructions for the conduct of registration, advise election commissions, primary boards, and administrators of elections as to the proper methods of performing their duties, and authoritatively interpret the election laws for all persons administrating them. Is that right?
That is correct.
And those are from that statute as far as you recall? We're happy to look at it if
They are from that statute.
Paragraph 4, you note that as coordinator of elections, you are also statutorily empowered under a different statute, Tennessee Code annotated 22139C, to formulate a uniform procedure for verifying the registration eligibility of any person convicted of an infamous crime. Is that right?
Objection calls for a legal conclusion again.
Overruled on the same basis. It says that, and this is his affidavit, that he signed allegedly on June 7th, 2024, Mark Goins, and it says, as the coordinator of elections, I am statutorily empowered under Tennessee Code annotated 22139C. So the court would overrule it for the same basis.
Understood, Your Honor.
All right, thank you.
Yes, with one caveat. That statute has changed a little with the new law, the overall statute.
We will get to that in just a moment. So, looking at this declaration and the statutory duties you talk about therein, part of what you are doing as coordinator of elections is authoritatively interpreting the election laws for the people who are administrating them. Is that right?
Election officials, correct.
And that would include county election officials and other people involved in the election process?
Election officials, yes, and that's county election commissioners and administrators.
And administrators of elections, do you often abbreviate that as AOE?
Yes.
Okay.
I'm sorry, what's the AOE?
Administrator of elections.
Thank you.
Part of also, you listed in the second bullet point, is advising election commissioners, primary boards, and administrators of elections as to the proper methods of performing their duties. Do I understand that correctly, that you're also giving them advice on how to conduct elections, how to tabulate votes, how to maintain voter registrations, those kinds of things?
We do mainly, so there's somewhat of a joint responsibility with the State Election Commission. It's kind of independent, but we typically do this through training, and also we have a certification process that the State Election Commission plays a part in as well. And then independently, there's statutory authority for us to do that, yes.
Okay. And I want to differentiate between two things. So there's also in your declaration here, excuse me.
Well, I'm sorry, I did mischaracterize. I think I said affidavit, but I meant to say declaration, so let's just correct that. Okay.
Absolutely, Your Honor.
Okay, thank you.
Let me lay a little foundation for my next question here. If you go to paragraph 5, you see where it says, on July 21st, 2023, I issued 2 memoranda to county election officials. Do you see that?
Yes.
You say here, these memoranda establish new policies and procedures for these officials with respect to the registration of individuals with felony convictions. Did I read that correctly?
Yes.
Okay, and so, and I believe we talked about this during your deposition, part of the way that you establish policies and procedures for local election commissions and administrators of elections is you send these memoranda instructing them how to, on certain topics, is that right?
Yes, but the statute also says concurrence of the Secretary of State, so the Secretary of State is aware that we're sending the memos.
Got it. And we'll look at several of those in just a moment. So communicating with local boards of elections, administrators of elections via memorandum is one thing that you do. I believe also sometimes you and members of your staff will get questions from local election commissions and administrators. Is that right?
Yeah, we get a lot of phone calls, and actually the phone calls typically are how we give a lot of advice.
Okay, great. Let's then look at, we're going to look at a statute, and Your Honor, consistent with what we've done so far in this case, I'm going to have a number of statutes that I want to look at with the witness. We're not going to enter them into evidence because they're statutes, but I'll have a copy for you to look at, and we'll have copies for the court as well. So let's pull 211-201. Copies for the court and one for the witness. No, these are.
Did you get to eat? He did. Okay. You got to eat. You got a little break. Did you get to eat? Yes. Okay.
Troy, can you put 211-201 up there? Oh, did you not get a copy, Mr. Goins?
I did not.
It's not going to evidence. Thank you. And Mr. Goins, this is a copy of Tennessee Code Annotated 2-11-201, which is one of the statutes you mentioned in your declaration. Do you see that?
Yes, sir.
I want to look at subsection B. Subsection B says, the coordinator of elections is the chief administrative election officer of the state and shall obtain and maintain uniformity in the application, operation, and interpretation of the election code. Did I read that right?
Yes.
So it's part of your job to make sure that the election code is uniformly interpreted across the state.
Action calls for a legal conclusion.
Counsel, does it call for a legal conclusion?
That is directly out of the statute. This is a statutory duty, and as I'll get to in a second, he has already testified that part of his statutory duty is to authoritatively interpret the election code for all election officials. I don't think this calls for legal conclusions. It's just a discussion of what his duties are.
Yes, sir.
So quickly in response, what wouldn't call for legal conclusion is his understanding of his duty and how he carries out his duty. To ask him what the law requires him to do, in case it's not actually what he's been doing, that sort of thing calls for a legal conclusion.
To be clear, Your Honor, my question was, it's part of your job to make sure that the election code is uniformly interpreted across the state.
And that's exactly asking what the statute requires him to do or not do.
Okay, the court will overrule the objection.
Thank you.
All right, thank you.
So the question, I'll say it one more time. It's part of your job to make sure that the election code is uniformly interpreted across the state. Is that right?
It's a diverse state, small counties, big counties, mid-sized counties. That is one of the toughest parts of this job. Rutherford County and Unicoi County and Shelby County are kind of different. So, but yes, that is something that the legislature has said you need to try to do.
I'm sorry,
I
did not mean to interrupt you. I just said, is it random that you picked that you picked one of my tiniest counties.
Well, Washington County is very similar to Rutherford County, but anyway.
I was about to say, I suspect the witness has studied up just a little bit.
Yes.
Okay, and the reason for that, I take it, is that you want to make sure that what's happening in one county with respect to the elections, as best you can,
Yes.
is also happening the same way in the other counties.
Yeah, as best I can. I mean, sometimes you have like a flood in like Upper East Tennessee had that can throw a little wrinkle into the best laid plans uniformly. You want to take care of those voters, but yes, when it comes to photo ID, you try to make sure that all counties are enforcing the photo ID requirement when someone votes those things.
And the same thing would go for registering to vote people who were previously convicted of a felony. You want to make sure that that's done as best you can uniformly across the state.
Yes.
And if there's any question as to how a particular local jurisdiction should handle that, they can come to you, and that's...
Well, this gets into the diverse state. It's a little different. So Shelby County has their own attorneys as well. Some of the larger counties, not Rutherford, but Shelby and Davidson, sometimes we're conferring with attorneys going back and forth that actually represent the Shelby County Election Commission. So, for example, Linda Phillips is the administrator here. She will get advice from us, and she'll also get advice from local counsel. That's different than in Washington County or Upper East Tennessee, where they're not normally doing that. So Davidson and Shelby are unique in that aspect, where both of them, like Davidson uses Metro and sometimes hires their independent counsel. And so a lot of times we're communicating with those attorneys. That is the exception and not the rule.
Sure. And I think the only point here is that they may have outside counsel, they may get other advice, but ultimately you are the chief election officer. You authoritatively interpret the election laws, correct?
I quote that statute, yes.
Okay. So let's look at subsection C of this same statute. And this is what I think you brought up earlier. Subject to the concurrence of the Secretary of State, the coordinator of elections may make rules and regulations as necessary to carry out the election code. Did I read that correctly?
Yes.
And when we were talking about sending out memoranda earlier, is this what you're referring to? Those fall within the rules and regulations that you're making?
Yes. And I've had the position for 17 years, so he places a lot of trust in me. So a lot of times I'll just say, hey, this memorandum's going out. This is what it says. It's a lot different than when I first started.
It's good to have a boss that trusts you.
Yes.
Okay. We're going to take a look at one or two of those memoranda here in just a second, but I want to ask you a little bit of foundation. I want to talk briefly about the Falls case. Do you recall that case?
Yes.
You were a defendant in that case that went up to the Tennessee Supreme Court, correct?
Yes.
And at a high level, that case was about Mr. Falls attempting to register to vote after he was pardoned by the Virginia governor. Is that right?
I think it's clemency, but it may be one and the same. But yes, he was given a certificate of clemency, I think.
I think you're right.
From Virginia.
Okay. And as a result of that ruling from the Tennessee Supreme Court, the division at your direction actually changed the voting rights restoration process to become a two-step process. Is that right?
Well, I would argue that Falls v. Goins and Justice Bivens writing for the majority changed the process, and we just followed the court case, because ultimately the courts are the true interpreters of the law. I just have the authority for those at the election officials.
Understood. I guess the reason I was phrasing it that way was after the court case came down, there were substantial changes to the actual forms and how the process itself went. Is that right?
Yes.
And those came via memoranda from you. Is that right?
That and training. We held training sessions.
Let's take a look at one of those two memoranda that you sent out. Let's take a look first at what was pre-marked as Plaintiff's Exhibit 111. this one, yeah, this one. Okay. Did you? Okay. Oh, I'm sorry. Yeah, after you, judges. Things easier.
Okay, are you, marking this?
Yes, as I understand it, defense counsel have no objections.
No objection,
I'd like to
okay.
make this to the next numbered trial exhibit.
What number is this?
Exhibit 58, Your Honor.
Thank you.
Mr. Goins, if you'll take a look at this, is this one of the two memoranda that was sent out after the Falls decision came down?
Yes.
And as I understand it, and take a second to look at it if you need to, this deals with older felony convictions, particularly those falling within the so-called grace period. Is that right?
Yes.
And this is, as we talked about before, how you communicated the process changes down to the local election commissions.
Yes.
Let's look at the next memo. It has been pre-marked as Plaintiff's Exhibit 112.
Any objection?
Haven't seen it yet, Your Honor.
Okay,
Not at all. It's-
all right. Exhibit 59?
And I'm sorry, I should have stood up.
Oh, you're fine. At this point.
No, I'm still gonna do my best.
We can relax the rules a little bit, so, okay.
Okay, Mr. Goins, take a quick look at this memo. Is this the other memo that you sent out after the decision came down in the Falls versus Goins case?
Yes, I need to clarify the first memo, actually, that was something, that was not in the court order. It was something that dealt with Falls v. Goins. Just want to be clear. I'd forgotten about that memo, but that was something we wanted to clarify. We had some questions about the grace period and those things.
That's right.
So-
And I'm sorry.
But this second memo is the one that was Falls v. Goins
And
in
just
relation to it.
Sorry. And since you sort of clarify there, I think that was a good clarification. The prior memo about the grace period, the prior exhibit we looked at, I think you just said you got some questions from local election commissions, I assume, about how to deal with the different time periods under Tennessee law about rights restoration. Is that right?
Yeah, and there were some internal discussions on how best to communicate that. And so since we were going to do the training, and we made it all around the same time.
Okay. All right. So back to, apologize, what was this marked? 59. So back to Exhibit 59 here. I think really my only question is, it appears from the face of this memo that the case came down. As coordinator, you did an analysis of the case, which is, there's some of that analysis in this first paragraph. And then as a result of that analysis, you are instructing local election commissions about the new procedures for restoration of voting rights. Is that all right?
Yeah, we were instructing them about the court case and how to follow the court case. Yes.
Great. So then my question, we'll look at a few other memos, but my question is, ultimately, if Ms. Moses is successful in her claims in this case, whether the trial court or maybe on appeal, it is possible or maybe even likely that you'll have to do a similar instruction if she's successful, if something changes about felony disenfranchisement process. Is that right?
It would not.
Your Honors, I assure you, this is a topic that would be discussed among attorneys, his included, and a plan of action would be formulated, and anything he says right now would be part of that privileged conversation. I mean, this is something I can't blow privilege on it, but this is not a question he can answer.
Well, if he's had conversations, that would be privileged, but conversations not already had are not privileged, so, is there another objection?
Conversations have been had.
I'm sorry?
Conversations have been had.
I'm not asking about the conversations, to be clear, I'm asking
Okay.
about the process. And that was why I laid the foundation with these other memos, court case, new process, and I'm asking if it would be similar here.
Okay, well, any attorney-client privilege would be protected, so Mr. Goins would not have to testify to conversations that he's had with his counsel, but to the extent that he may be able to answer that without disclosing attorney-client conversations or advice that he's been given, if he can answer that question, we'll allow it.
So, Mr. Goins, I'll go back to my question, I'll break it up a little bit. If Ms. Moses is successful in her claims in this case, that some or all of the felony disenfranchisement system is unconstitutional, one outcome would likely be that, just like you did with Falls, you would have to think about how it affects the procedure, analyze it, and in your words, I believe, apply the decision of the court and inform the local election commissions about that.
Calls for speculation.
There's a call for speculation?
I think that's why I laid the foundation. I think it is reasonable to assume that that is what would happen in this case, because it's exactly what happened in the Falls case.
I think the very words reasonable to assume means he's speculating. If it's a fact he knows, he can testify to it. If you were asking him to guess what might happen in the future, that's speculating whether it's reasonable or not.
Speculation, Your Honor, is
We won't know if he's speculating until he answers the question. How would we know if he's speculating? And remember, when we're using hypothetical, we're looking at the underlying facts that have been laid. And that's how we determine what weight, if any, to give a hypothetical. So if you give a hypothetical and the underlying facts are not introduced during the trial, then the hypothetical has no bearing. But the hypothetical given in this situation, which hypotheticals are allowed during a trial, is if Ms. Moses was to prevail, whether it be at the trial court level or at the appellate level, how, if any, would the procedure change for the Commissioner of Elections? Is that the question?
I haven't even gotten to how would it change. It would just be, would you need to instruct folks if
Okay,
it was
so
changed?
that's even a more narrow question. So I'll overrule the objection as to that question. I'm sorry, did you understand it, Mr. Goins, or does he need to repeat it?
Yeah, and if I start getting into attorney-client, then maybe counsel might want to. I have asked this question to counsel.
We've had the discussion as privileged. I mean, his answer starts with, I've had this discussion with my attorney. Anything that comes after that is going to be what was discussed.
With all due respect, Your Honor, I'm a little worried that the witness is being guided here in his response to assert privilege. We are asking questions about his statutory roles based on things that he has done in the past with other cases that found certain elements of the election code constitutional or unconstitutional. I'm asking the next follow-up question, which is, assume that this case goes a similar way than Falls, what would be your next step? Understand that he may consult attorneys, but he has an independent obligation under his statutory obligations to instruct local election commissions on what to do. I'm trying to get that out, that that's what he would do. He would need to instruct local election commissions as to how to handle the
Mr.
case.
Goins, are you able to answer the question without disclosing what advice has been given to you? Because I'm a little bit concerned that just speaking with counsel about issues in this litigation and how that might affect your statutory duty, I don't know that you can use the privilege to shield that. But at the same time, you know, we want to be respectful of the client-attorney privilege, and we would not want you to disclose anything that was attorney-client protected. Now, we could certainly take that up in a camera and determine whether there is a privilege, but assuming that there is a privilege, is there a way for you to answer that question without discussing specific legal advice?
So where this is different, and one of the reasons I asked counsel is my understanding this is very limited to only Ms. Moses. So this isn't So what I can't figure out necessarily is if there were to be an order, does this impact everyone broadly, which after consulting counsel would go a memo route? Or if it only truly impacts Ms. Moses, then that's more of a communication to Shelby County Council. It's going to maybe be a letter, maybe advice. I mean, that's the, it's more of, there's some legal issues here that, in all honesty, I don't necessarily understand. I can't figure out how far this goes. Because to me, in one sense, if it's unconstitutional, Ms. Moses, the court order may say that, but it probably means it's unconstitutional to everyone. But I guess we'd have to look at the court order, certainly have to talk to the Attorney General's office.
Sure.
So, I mean, there's this internal struggle here, but part of it is just because it's kind of a different type case.
So, and thank you for that. I appreciate the division between those two things. We will get to in a moment if there's an order as to Ms. Moses specifically. So let me go back and ask a slightly different version of that question. If there was ultimately an order like in Falls, that there was a broad holding that affected the rights of hundreds or thousands of people rather than just Ms. Moses, your practice pursuant to your statutory duties and your prior practice would be you would need to instruct county election commissions about how to handle that.
My prior practices would be I would consult with internal staff, attorneys, the Attorney General's office, and if that is the natural flowing thing, yes, we would instruct through a memo if it's more global. If it's isolated to one, then that's different.
And we will get to that in a moment. Let me do this. We have a number of other memoranda that I want to show you.
Counsel, are you okay? Because he didn't disclose any attorney-client
in
privilege.
fact, I don't know if you saw me whisper to
Okay.
John, but that's what I whispered to him. So if you want to ask that, I'm not going to object. So,
Okay.
so that's
Okay,
fine.
very good, okay.
We have a couple of additional memoranda that we want to move into evidence, sort of demonstrates this point. So these have been pre-marked as plaintiff's exhibits 132 through 144, so it's a packet of them. Happy to show them to defense counsel. They are just like these others in that they are memoranda from Coordinator Goins.
Okay, Mr. Hillo, any objections to any of these, or do you need to look through them?
Real quick to flip through.
Okay.
It looks like his signature's on all but one of them. No objection to
Oh, did I
these.
miss one?
Okay.
Thank you. No, I've got that. Yeah, I've got that.
Are they separate or collective? Collective or separate? Sorry.
I'm sorry?
Collective or separate?
I'm happy to just make this a collective exhibit.
Collective? Okay,
yeah.
that would be easier. Okay.
Absolutely.
Okay.
That's fine.
Collective 60?
Thank you, Your Honor.
Okay.
So, Mr. Goins, do you have what's been admitted as Exhibit 60 in front of you, the collective exhibit?
Yes. Yes.
And I just want to have you look through those quickly. They're on a variety of topics having to do with voter registration and list maintenance and felony disenfranchisement and other topics. Is that right?
Yes.
And I believe these are all memoranda that you signed.
One is unsigned, but it may be a draft.
Okay.
The March 9th, 2018, but other than that,
I see that. And for that March 9th, 2018 memoranda, that's something that it's on your letterhead and shows that it is from you. Is that right?
let me go back and look. That may be a draft. I mean, there was a lot of discovery, well, as you know, there's a lot of discovery in this case. I lost it. I don't think we, honestly, I don't know if we issued this one.
The March 9th, 2018?
Yeah, I don't know if we issued this one, judicial diversions. I don't know if we issued it.
Okay. You don't remember either way if it went out officially or not?
I don't.
Okay. I want you to look briefly at, there's a memo dated June 22nd, 2021. It's about, I'd say, halfway through the stack. It's been pre-marked Plaintiff's Exhibit 139.
June 2021.
22nd.
Oh, yeah, June 22nd, 139, yeah.
Yes, sir.
I'm there.
And do I have it correct that this has to do with informing the county election commissioners about a federal court case having to do with absentee voting related to COVID? Is that right? Yes, yes.
Yeah, that was the, so that was actually the law before. Seems to me, I think there was a court in between that time said they didn't have to vote in person, and then the court came, and then the Court of Appeals said, no, state law says that they do. And so that was just restating what the law was prior to the court's ruling.
Okay. And then if you'll flip to the second to last page in this exhibit, it's a memo pre-marked Plaintiff's Exhibit 143.
I'm sorry, what'd you say?
Second to last page.
Second to last, well, I got them out of order. Is that Plaintiff's Exhibit 143?
Yes,
before
sir.
it was collectively one? Okay.
And both this, so this is dated June 5th, 2024, is that right?
Yes.
And then the next page, pre-marked Plaintiff's Exhibit 144, is June 14th, 2024. You see that? The next one?
June 14th, yes.
And my understanding of these two orders is these were both having to do with the felony disenfranchisement case that was pending in federal court.
Well, I don't know if it's disenfranchisement or reenfranchisement. Most of the issues there were about reenfranchisement, which is a different statute.
Correct. And so that was that case brought by the Tennessee NAACP that was pending in federal court, is that right?
Yes.
And then, so you were updating on June 5th, county election commissions about Judge Campbell's order in litigation, is that right?
On June 5th was Judge Campbell. June 14th, it was the Court of Appeals.
That's right. And so that was going to be my next question.
Yeah.
And then about 9 days later, you did a follow-up memo to county election commissioners notifying them of the Sixth Circuit's administrative stay of Judge Campbell's order. Is that right?
That's correct.
Okay. So you're in fairly, I guess, rapid communication when you need to with county election commissions about legal developments. Is that right?
Yes.
Okay. Let's turn back to a few more. We're going to look at a couple of statutes and talk about how the Division of Elections maintains voter data. So we're going to look at statutes, Tennessee Code annotated 22301, 302, and 303.
Any objection? Oh, no, it's just a statute.
Just
No, or-
statute,
just-
not moving into evidence, Your
Okay.
Honor. Coordinator Goins, do you have those in front of you?
Yes.
So really all I want to ask about here is these statutes taken together establish the statewide voter registration database maintained by you as coordinator of elections. Is that right?
Your Honor, we. Actually, no, that's wrong, sorry.
Okay.
Yes.
And in section 302, this statewide voter database is referred to as the Automated Electoral System, or AES. Is that right?
So the counties feed up to our system, and they feed in through a system we call Automated Electoral System. It's an in-house system. It's just the internal name that we gave it, and that was, I wasn't the coordinator at the time, but they literally put the name of that in the statute.
Got it. So just to make clear, though, that system, that is the official list of registered voters in the state. That's the statewide database.
Well, it's the same as the county. So anything the county has, we have. We only have data the county sends us. So they are the same. So if you go to your county, then and they have a database, it's the same data. So yes, the county has a system and we have a system, and both would be, for that county, that would be the official list for them, and for the state, we would have the official list, but it all comes from the county.
Understood about the provenance. I'm just saying, I want to understand that via statute, that statewide list is identified as the official list of registered voters for the state.
Yes.
Okay. And then I think what you were talking about is in the next section. Section 303 talks about how data from county election commissions gets transferred up to you, state coordinator of elections, via that system, right?
Yeah, that's why I qualified it, because the next statute, read them together, that's how that works.
Right. And it looks like that's not less than once daily, so that's a daily automated process?
It's like 2, 3 a.m. in the morning.
Great.
It's a system that runs automatic.
Okay. So let's take a look at another statute here. Did we do 211-202? I apologize. Can we look back at 211-202? Apologies, I'm trying to figure out what happened to the copies of the statutes.
I've got the 3 that you just referenced.
Right, and the ones that we did before? Yeah, we can just look at the monitor, that's fine. We'll just take a look at the monitor and let us know if you can't read it. So this is Tennessee Code Annotated 211-202.
Yeah, it's Plaintiff's Exhibit 6.
Do you have it in front of you?
Yeah, I've got 6. Yes,
Great,
6.
thank you. Okay. So we referenced this earlier a little bit, and this is, the subtitle of this section 211-202 is duties, and this is part of Title 2, Chapter 11, Part 2, Coordinator of Elections, is that right?
Yes.
And subsection A starts out with a coordinator of elections shall, and then there's a list of duties, is that right?
Yes.
We've talked a little bit about some of these, but I want to look at 2, subsection A2. Coordinator of elections shall prepare instructions for the conduct of registration. Is that right?
Yes.
And so that's part of your job, is to tell local election commissions this is how you register, and I believe there's another statutory section where you are instructed to provide forms for local election commissions. Is that right?
Yes.
Okay. And then I believe, well, I'll just ask, if local election commissions have questions about whether a certain person should be registered, or if the form is filled out correctly, or any other questions about voter registration, they can call you or your office. Is that right?
They certainly can. That doesn't mean they always will. 'Cause
Sure.
And once again, like I say, Shelby and Davidson are kind of their own animal with their own legal counsel, but the statute gives the authority to the administrator of elections to determine whether someone's eligible to register.
Great.
And that's multiple statutes.
And I will skip, but maybe note for the record, I think you answered yes, that part of your job as coordinator is to provide forms.
Yes.
It's not a memory test, but I have here that's under 22136. Happy to look at it, but
There's multiple forms that we're responsible for. That may be correct, but there's multiple we're responsible for.
Okay.
So there's different sections of the code.
great. So that was voter registration and conduct of elections. I want to talk a little bit about purging voters. That's sort of the flip side of registration. Generally speaking, am I correct that if someone was a registered voter and then they are removed from the database, that is a purge of a voter? Is that right?
Yeah, we call it a purge internally. Some call it cancel that registration. It can be either. But internally and with election officials, we call it purging. The statute mentions purge. It also mentions cancel.
And there are a variety of reasons that someone could be purged from the voter registration database, correct?
Yes.
So death would be one.
Yes.
Conviction of felony would be one.
Yes.
I suppose moving out of state would be one.
Yes.
What am I missing? Are there any others?
Request of the voter.
Request of the voter. Okay, great.
Moving to a different county.
Right. And is that correct that if you move to a different county, you have to re-register to vote?
Yeah, because it's considered, the administrator of elections for that county is authorized to register someone to vote. So the fact someone was registered in Shelby County does not mean that they can be registered in Rutherford, because it's a different administrator and they have to check the eligibility.
And in fact, under 211-202, which we can look at if you'd like, one of your duties is if a county election commission does not properly purge records as required by law, you are instructed to investigate that, and if you really need to, you file a petition in court to accomplish that purge. Is that right?
Yeah, there's two.
I just want to make the objection. I think I know the answer, but that calls for legal conclusion. That's the objection.
It is. I think he was about to say, yes, that's what I do. It's just laid out in the statute that that's one of his duties.
So,
What statute is it laid out in?
it is 211-202.
211-202. That was the one that we marked as Exhibit 6. Was it Exhibit 6?
I believe that's
Yes.
right.
You can put it up on the screen so we can see it. Counsel, is it part of his statutory duty?
Your Honor, I think it fits under many of the overrules you've already said, which is it is one of his jobs that the statute asks him to do.
Okay. Let's take a look at the language and see what it says. the
So it is
statute.
A6, 211-202A6. Second page.
Can you blow it up, please?
There we go.
All right.
So this was, I think you're about to answer, Mr. Goins, but this is the provision within the statutory section 211-202, which is the coordinator of elections duties. This covers if a county election commission does not purge the permanent registration records as required by law, and the coordinator of elections, which is you, shall investigate the registration records of that county and file a petition with circuit or chancery court in the county to purge the permanent registration records. Do you see
You
that?
still have an objection?
Yes, Your Honor.
Same objection? Okay, the court will overrule it
Thank
because
you.
it's a statutory duty. Okay.
So you mentioned both processes. You mentioned investigating that process as well. And I think this highlights the fact I can't hire or fire anyone. So there's different independent bodies that I have to go through. The first statute that you mentioned, where it talks about investigating and reviewing, if it gets to a point that we see some of those things that we have to call witnesses, then that's before the State Election Commission. And so the State Election Commission has the authority to decertify an administrator. I don't. And the Election Commission, or they can remove an election commissioner for cause. So that's the first component. The second component that you read, and that's C, we could also take it to the courts. So if we've got two options when it comes to dealing with those things. One is the State Election Commission, who has authority to decertify or remove commissioners. The other would be to take it to a court and then get the court to order the county election commission or the administrator to do their job.
Right, and I guess the point that I was making here with this statute is those are both responsibilities that as coordinator of elections, you need to make sure that the statewide voter file is appropriately maintained, and if that requires you to either investigate and file a suit or to go to the Board of Elections, that is how you fulfill that duty. Is that right?
Those, well, I mean, yes. I mean, if it gets to the point where we need to do that, that's what we would do. And we have taken some over for the State Election Commission before.
Yeah. And actually, that's a good point. It sounds like you have done that in the past. Hopefully, it doesn't always get to that point. Are there times in which you have had to instruct a local election commission, hey, these folks need to be purged. I see they're still in the database, and they just do that?
Well, we hope that they do it, but we've had a situation where some counties have not done that, and one was fairly extreme, and they weren't removing. They also weren't doing their list maintenance, and so I brought that to the State Election Commission.
Gotcha.
And asked the State Election Commission to decertify those individuals. There's certain counties we have to communicate with multiple times. I mean, the hope is that you don't get to that point.
Right. So I want to get a little more specific, a little more granular here about purging persons convicted of felonies. You mentioned that as one of the categories that folks would need to be purged of. Is that right?
Yes.
Okay. And so under Tennessee statute, if someone is convicted of a felony, they lose their right to vote, correct?
Yes.
Calls for the legal conclusion.
Overruled.
And if the person was
well, if they're not prior to 1981, but yes, if you're being convicted of a felony after 1981, then you lose your right to vote.
That's a good clarification. Thank you. If that person was currently registered to vote when they are convicted of that felony, then they need to be purged from the voter rolls, correct?
Yes, the clerk locally is charged with notifying the administrator, and then we do a comparison as well. So we have a list that we send out if for some reason they didn't get the notice from the clerk.
And is that what you refer to in the division as the felon list?
Yes.
And I was about to look at Tennessee Code annotated 22106. I think this just confirmed what you just testified to. We'll take a look at it very briefly. Can we get 22106 up? So we're looking at 22106A. if you look at 22106A4, there we go, right down at the bottom. So I think this is what you were just referring to, Mr. Goins, that a registration of a person shall be purged, and the fourth circumstance is upon receiving information that a person has been convicted of an infamous crime, as defined by 40-2112, from the state coordinator of elections, the district attorney general, United States attorney, clerk of the court that entered the conviction, or other source upon verification by the clerk of the convicting court. Is that right?
Yeah, and as you know, our list is slightly different in that we have different categories of batches. So we're looking at data, and so sometimes a name may change or something along those lines. So the fact that we send this list to the counties, there's like the secondary category, we're not 100% certain it's that same person. Birthday may be off a little bit. Typically it's a name. And then sometimes you find that folks share the same social security number when they're in prison. And so some of these categories, even though we send them to the county is to look into those specific voters to see if they're actually the correct person.
And so when you send the felon list to the county, that is the coordinator saying, we think these folks ought to be purged, but double check before you purge them. Is that
that's how it's trained? Yeah, that's exactly correct.
Okay.
What statute is this?
I'm sorry, this is 22106, Your Honor.
All right, thank you.
The title is Purging of Registration. I apologize, we're flipping around so much. Let's go back to 211-202. Oh, I'm sorry.
Not that, it may not matter, but there's another statute that talks about this list too, where it says that we're supposed to compare and come up with this list. So
okay.
there's more than just this. But I can't think, I don't know the statute right now.
That's absolutely fine. Okay, let's look back at 211-202. This is the one that was pre-marked Plaintiff's Exhibit 6.
Yes. Yes, sir.
So we are going to look at subsection 16 and 17.
Subsection 16 and 17.
Right. And so just to refresh, this is Tennessee Code Annotated 211-202. This is the duties of the coordinator of elections. And now we're looking at subsection A16 and 17.
Mm-hmm.
So A16 says that the coordinator shall devise and furnish to the clerks of circuit and criminal courts a form to be used for notifying county election commissions of the fact that a registered voter in their county has been convicted of an infamous crime and therefore should be purged from the registration records. Is that right?
Yes.
And so that's the part of the duties of the coordinator is to create the form and distribute it to the criminal court clerks so that then they can notify county election commissions of folks who've been convicted of felonies.
Yes, but that form was created before I got here. I don't think we've changed that form. I think it's been consistent.
And then subsection 17, the coordinator of elections also shall instruct the administrators in each county that they are to purge the registration of any person appearing on the infamous crime list required by subdivision A16. You see that?
Yeah, that's how we train. Correct.
Great. Now, as I understand it, as a result of the 2025 legislation, sounds like there may be a bit of a change on the horizon about how county election commissions are going to determine if they need to purge someone who is convicted of a felony. Let's look at Tennessee Code Annotated 22402.
Is that in this packet?
No, we're
Is
going
this
to
the new law, the portal law?
This is the new law. We'll hand it to you right now.
I'm familiar with it.
So Tennessee Code Annotated 22402 instructs the coordinator of elections in collaboration with the Tennessee Bureau of Investigation prior to January 1st, 2028, to create a secure electronic portal through which each county administrator of elections may access information to verify, prior to processing an applicant's application to register to vote, whether the applicant is ineligible to vote based upon records on file that as the result of a Tennessee felony conviction. Did I read all that right?
Yes.
And my understanding of this section is that this is, will this be a centralized database that local election commissions can query to see if a person has a felony conviction that would prevent them from registering?
Yeah, this law was passed because of what happened in Sumner County where folks were caught after the fact. And there was a legislator, Leader Lamberth, wanted to catch him on the front end. And so he was, I met with TVI and other folks. He literally got us in a room and he said, work this out to catch them on the front end. And so in an effort to catch folks on the front end so they don't get caught after the fact, before someone is registered, this is going to prevent them from being registered. So I'm an administrator of elections. Before I register that individual, if there's a database that says this person has been convicted of an infamous felony or being convicted of a felony, it's going to flag that person. And so then the administrator will look and see if it was before 1981. If it's not before then that individual will not register that person. They'll follow that person up. Follow up with, well, they'll tell that person, by statute they have to tell that person they're not eligible to register to vote, and then if that person believes there's an error, they can appeal it to the county election commission, which is a 5-member board.
And so this would be a separate process. This is for people who are filling out a voter registration form. They don't check the box indicating that they were convicted of a felony previously. It's just a normal registration. And then as a result of this, the intent is that local county election administrators will check this database before they register the person?
No, this is going to apply to everyone. It doesn't matter whether they checked the box or didn't check the box. They said that anyone before they get registered, they're going to go through this database. The statute also said we have to do the same thing for non-citizens. It's a different database they'll compare it to, but both were passed in the same piece of legislation.
And so as I gather, the part of the problem this is meant to solve is that folks were not being purged appropriately. Is that right?
So typically when you have a prosecution, that means someone checked that they checked that they had not committed a felony. And so they're on the voter rolls. And then when we do our comparison and they show up on the comparison, then they've committed a crime. And so what Leader Lamberth is trying to do is prevent that person from committing a crime. You know, essentially if they're being flagged, they're not going to be able to register.
Understood. So this is, when you said catch it on the front end, that's making sure that folks who shouldn't be voting are not voting.
Yeah, and Leader Lambert's from Sumner County, and so that's why it was something that he spearheaded.
And I know we discussed this very briefly at your deposition, but sometimes, hopefully occasionally, it's actually the opposite, that someone is purged incorrectly and they need to be restored to the voter rolls. Is that right?
That happens I don't recall, we discussed this before in our deposition. We see that more with dead people than we do with folks that have felonies. But yes, we do have that happen.
And I believe you told me at the time that the remedy there, if someone is mistakenly purged or shouldn't have been purged, is you put them back on the voter rolls. Is that right?
Yeah, that's normally the case.
Okay. And I think I had asked you, it's not like they have to restore their rights, and you told me that, yes, that's correct. There's nothing to restore.
Well, yeah, I mean, if someone has not committed a felony and then they are removed for that specific reason, then there's nothing to restore because they didn't lose their rights. Correct.
So well, let me ask, I know you have a deadline of 2028. Is this portal up and running, being built? Where are we in the process here?
So we're working on the RFP. We're taking the first stab at it, and then we're going to submit it to, so it's 2 different entities we have to work with. Specific for this one, we'll submit it to the TBI, but it's going to be one RFP that we issue at the same time. So we've had meetings and done some of our technical requirements. RFP is request for proposal.
So assume for a second, and right now, where is the felon report the sort of like centralized repository that the coordinator's office has of folks who have been convicted of felony?
No, I mean, we get TDOC's database is what we normally get there, but Leader Lambert wanted the TBI. I mean, that was his, you know, he just wanted the TBI, and that's how we ended up with the TBI.
Understood. So in that current TDOC database, Ms. Moses would show up as having a disenfranchising felony right now, right?
Your Honors, without him having it in front of him, he can't possibly, on a list of 350,000, know if Ms. Moses is on it or not. He can know if she's supposed to be on it, but he can't say if she is or not. If they want to hand it to him, he can look, but it's 350,000 names.
Well, how do you know that he doesn't know whether how do you know that he didn't look to see if Ms. Moses is on it? How do you know? You just can't stand up and give answers. I mean, you can make an objection, but that's not a proper objection.
I'm sorry, Your Honor.
Okay. So I'm gonna overrule the objection. If the witness doesn't know, then he could say, I don't know.
Yeah, truthfully, I don't know. I have a person in the office. This is what they do. They're specialized in this. They have some other tasks as well, but it's consistently in my 17 years there, I've had what I would call an expert on felon restoration, and that is that they would know. I would not know. I don't know that I've glanced at the database, but I've never queried a person in that database.
If the new the portal, I think it's been referred to, once that's up and running, is the idea that that will have everybody who has a Tennessee felony conviction in it?
Yeah, I mean, we've never, like I say, we've not really dealt with the TBI database. So, but in the discussions in the room, that seems to be the ideal of it. Frankly, as this progresses, we'll probably ask for the TDOC database as well. But that's the ideal, yes.
And so the idea is if you have a Tennessee felony conviction, you will appear in that database, right?
So in the discussions, they may have some out-of-state felonies as well. I think that might be and not to confuse things, the TDOC database can have someone that committed a felony in a different state as well, but that's if they got transferred here. So the TBI may have some information, but my understanding is there's no database out there that will have convictions of all 50 states.
And that's why I was asking. I think the minimum level here, looking at the statute, is the idea is at least to capture folks who have Tennessee convictions, and then if there's some other information, that'll be added in as well, right?
Yeah, that's correct.
And so I think we agree that Ms. Moses has a conviction from 2015 that we're here about, so she would be in that database as well, along with others.
Yeah, but yeah, I mean, I would think she would be. I can't affirmatively say she is. My assumption would be she's there.
Okay. So let's then turn a little more focus on what happens when a person convicted of a felony is registering to vote. So don't want to get too much into detail here, but that process of people registering to vote who had previous felony convictions, that changed as a result of the law last year, right?
Yes.
I want to focus a little bit on the end of the process, so not the rights restoration piece, but the registering to vote piece, okay?
Yes.
So, tell me if this is correct. Once a person who was convicted of a felony has their rights restored, they still need to go register to vote again, is that right?
Yes.
And that's because, as a result of the felony conviction, they would have been purged from the voter rolls.
Well, the statute says that. The statute says that when you get your rights restored, that you also have to file a voter registration form, and that the administrator determines that you're otherwise eligible, then they register you to vote.
And so that person has the court order, and they fill out the voter registration form, and they attach whatever documents they need to in order to try to register to vote after their felony conviction. Is that right?
They turn that into the local county election commission.
Correct. And then we're going to look at 22139, which is another statute.
Is that Exhibit 5?
Not yet. We haven't gotten there. So we'll get copies. Oh, I'm sorry. It is 5.
Oh.
Apologies. You knew better than I did where I was going. Yeah.
And which statute did you ask me to look at?
22139.
22139.
And I want to look specifically at subsection B. You have that in front of you?
Yes, sir, I do.
Okay, great. We'll pull that up. B, yes. So the title of this code section is Convicts, Restoration of Suffrage. And in subsection B, the first part of it, before the semicolon, talks about the person needing a pardon or certified copy of a judgment. And then after the semicolon, this section says, however, before allowing a person convicted of an infamous crime to become a registered voter, it shall be the duty of the administrator in each county to verify with the state coordinator of elections that the person is eligible to register under this section. Is that right?
Yes.
And so, going back to where we were in the process before, person gets the rights restored, fills out the voter registration form, attaches the documents, and then that package gets sent up to the coordinator.
Yes, because if you look at A of that same statute, the person who's seeking to vote, they submit the sufficient proof to the administrator of elections. And so that proof is the court order. There's another statute that came with the new law that says we verify that's a court order. So we get the court order, and the person in my office, Spencer, what he does, he will look at the court order that we have received from the court. He will compare it to the court order that has been given from the person seeking to be registered to vote. We verify it is the court order, and then that person, and we send that back to the county saying, we have verified that this is a court order, and the court order is what restores the rights.
And that letter that you send back to the county, that is authorization for them to go ahead and register that person to vote.
Well, I mean, once again, the authorization comes from the state statute, and the statute, in many times over, it talks about the administrator of elections has the authority to register someone to vote. It doesn't say the coordinator, it says the administrator. And the administrator is able to, so it could be that the person may not be a U.S. citizen or those, we're not verifying. When they ask us to verify it, what we are literally looking at after the new law passed is the court order. So that's what we're looking at. There may be another situation like that person may not be a resident of that county.
Sure.
So the fact that we send them that letter, we are just verifying that there's a court order. And that doesn't mean that they're eligible to register. That's up to the local election administrator.
Sure, and
to determine that.
And I understand you're focusing on the rights restoration, conviction of a felony
That's right.
piece. So by sending this back to the local election commission, you're saying not necessarily that this person meets all of the other US citizen over the age of 18, but you are saying pursuant to statute, we verified this as far as being convicted of a felony and being able to register notwithstanding that conviction. Yes, this is authorization to register that person.
It verifies the right had been restored. That's what we verified.
Understood, but they can't register that person until they send it up to you and you all respond to them and give them the green light, correct?
I would agree with that.
Okay.
Well, legally, they shouldn't register them.
Okay.
They can, but I mean, legally, they shouldn't.
Sure, I think this is assuming they're following the law.
Yes.
We're gonna get to that. Okay, so that's the general process. So that's after the person gets whatever court order they get, right? I want to go a little bit back in time. There's actually also a role that you play in the process of getting that restoration order. And this was an amendment to the law last year as well. Let's look at 4029-203.
Is it okay if I stand? And can I testify and stand?
Yeah, absolutely.
Okay. Are you able to hear me?
Yes.
All right. Progressively, it's getting worse. Okay. I'll keep
If you need to take
my
a break,
stone.
if you need a break, let us know.
Yeah, I'm going to try to get through this.
Okay.
Well, even if you need 5 minutes or something, please.
If that's okay. Can
Yeah,
I?
absolutely.
Yeah, let's take a
It's-
recess.
it's-
Let's take a recess.
All rise. Someone first has a brief
Yes?
We'll do whatever your honors think is best. Mr. Goins has both ibuprofen and prescribed narcotics for pain.
Say that again?
He's got ibuprofen and narcotics for pain. We've instructed him on days he's testifying, he just can't see. And so if he goes another day, then it's a whole nother day of this for him. And so I've offered to cut my costs significantly. If we could stay till 9, we think we could get him completely done and be done. But if we can only go till 8, then we know we're coming back tomorrow anyway, and he's super uncomfortable. And so I kind of, that's where I am. And I'm not trying to force the court into any decision one way or the other. Just wanted to make you aware of what it is.
All right, well, we appreciate that. We have conferred and we have made the decision that we came back about 6:05. We anticipated working a couple hours, so it's what, 7:40-ish, 45-ish?
Roughly.
Yes. And it seems like we're at the beginning of, or early stages of the direct, so we've made the decision that we are gonna go ahead and break for the evening. And we want you all to get have a good evening and get some rest, and we're gonna come back tomorrow at 9:30.
That'll give him time to rest.
To resume the trial. And in terms of the schedule tomorrow, we will work diligently, but if we don't finish tomorrow, we've decided that we will not have court on Friday because the weather is going to be too bad. So if that means that we have to come back and reset a day or two to resume, we think that that would be best. Because we want you all to be able to put on your cases, and we appreciate that concession, but it's been a long day for everyone, so we're just prepared at this point to recess for the evening, if that's okay. So.
Thank you.
All right, thank you so much. We'll see everyone back in the morning at 9:30. And Mr. Goins, please have a good evening, and we'll see you back tomorrow at 9:30.
Yeah,
Okay.
one
All right,
council
thank
comment,
you.
please. Just off the record conversation.